Yes, hello. Can you hear us?
Hello?
Mr. Greer?
Oh, yes, this is me.
Yes, your matter has not begun yet. We are just starting the meeting.
Okay, thank you.
We have recording, Chair Wolf.
Okay, thank you. Okay, let's call this meeting to order, 4:08. Please call the roll.
Second. Chair Wolf.
Present.
Chair Wolf present. Member Forsley? Member Forsley not present. Member Neighbors?
Present.
Member Neighbors present. Member Highland? Member Highland? Member Highland not present. Vice Chair Yankee?
Present.
Vice Chair Yankee present. Member Stein?
Present.
Member Stein present. Member Wong?
She'll be late.
She'll be late, exactly. Member
Not
Padmanabhan? I'm sorry?
Not present.
Yeah. Member Padmanabhan?
Present.
Member Padmanabhan present. Member LaHood?
Present.
Member LaHood present. Member Schmidt?
Present.
Member Schmidt present. 2, 3, 4, 5, 6, 7. We have 7 members. We have a quorum.
Member Highland present.
Oh, Member Highland present. Terrific. Thank you so much.
Okay, great. Let's start with the preamble.
Did you want to introduce the meeting, Chair Wolf, or would you like me to?
I did. Said to call the meeting to order at 4:08 p.m.
Okay. Shall I read public call-in number, remote access?
Please
The public
proceed.
comment call-in phone number is 415-906-4659. Meeting ID is 590-728-229 #. If you wish to make a statement during general public comment, please press *6 and unmute your telephone to speak. Please press *6 to mute your telephone once you are done with your statement. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N-33-20, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. That's CHERYL.LEGER@sfgov.org. All comments received will be made a part of the official record. The Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process.
Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Please call the first item.
Call to order, roll call, and agenda changes. I know of one agenda change, item number 6, file number 20056. The petitioner sent me a letter via facsimile. I received it Friday morning, stating that they had issues beyond their control and had to request, on late notice, request a postponement of their case.
Okay, I also received direct contact from the complainant, and they absolutely had prepared to be here, but it was a situation like our administration said, it was completely out of their control. Let's see. Well, hold off on that for as far as taking action. There's another item, item number 12. There's no attachment, so we have no way of knowing what we're supposed to be taking action on here. So unfortunately, we're not going to be able to hear this item today. We did have communication and notification from the complainant for those items. They're aware of it, and we'll be continuing this item, and most likely call a special meeting just for this item. So item number 12 is pulled from the agenda. Any other changes or adjustments to the agenda? Okay, so before we do that, we have to exercise item 1A. And is there a presentation by somebody? Is legal counsel present? Who's legal counsel today?
Hi, this is Helen Castillo.
Hi, Helen. Are you familiar with 1A, with that Governor Newsom?
Helen Castillo.
I'm sorry?
Can you hear me?
Yes.
Okay.
Are you familiar with it?
With 1A, yes.
Okay. Can you, are you prepared, or can you give a short explanation of what this is all about?
Sure. Basically, Assembly Bill 361 requires that that after September 31st, every 30 days, a body like the Sunshine Ordinance Task Force must make findings to be able to continue meeting remotely by going through, sorry, I'm looking for the documents. By finding that you've considered or reconsidered the circumstances of the state of emergency, and that either you've decided that the state of emergency continues to directly impact the ability of the policy body members to meet safely, and that the state or local officials continue to impose or recommend measures to promote social distancing. So under AB 361, you have to move and decide as a committee whether to adopt the findings that you will be presenting. And I should warn that should you decide as a body that you are not going to, you decline to approve the findings that the chair will present, then the remote meeting can no longer continue, so you have to adjourn. So I just want to say that at the outset so that it's clear that should you decide not to approve, then we have to disband.
Okay, great. So members, as you can see in the attachment, there's a resolution that has 2 pages of whereases explaining what this is about in more detail. I think it'll be a little more expedient if I just read the last whereas and the resolves, and then we can have some discussion, some public comment, and take action. Whereas the Sunshine Task Force has met remotely during the COVID-19 pandemic and can continue to do so in a manner that allows public participation and transparency while minimizing health risks to members, staff, and the public that would be present with in-person meetings while this emergency continues. Now, therefore, be it resolved, the Sunshine Ordinance Task Force finds as follows. As described above, the state of California and the city remain in a state of emergency due to the COVID-19 pandemic. At this meeting, the Sunshine Ordinance Task Force has considered the circumstances of the state of emergency. 2, as described above, state and city officials continue to recommend measures to promote physical distancing and other social distancing measures in some settings. 3, as described above, because of the COVID-19 pandemic, conducting meetings of this body, the Sunshine Ordinance Task Force, and the Education Outreach and Training Committee, Complaint Committee, Compliance and Amendments Committee, Rules Committee, Information Technology Committee, Ad Hoc Committee in person would present imminent risks to safety of attendees, and the state of emergency continues to directly impact the ability of members to meet safely in person, and be it further resolved that for the next 30 days, meetings of the Sunshine Ordinance Task Force and the Education Outreach and Training Committee, Complaint Committee, Compliance and Amendments Committee, Rules Committee, Information Technology Committee, Ad Hoc Committee will continue to occur exclusively by teleconferencing technology and not by any in-person meetings or any other meetings with public access to the places where any policy body member is present for the meeting. Such meetings of the Sunshine Ordinance Task Force and Education Outreach and Training Committee, Complaint Committee, Compliance and Amendments Committee, Rules Committee, Information Technology Committee, Ad Hoc Committee that occur by teleconferencing technology will provide an opportunity for members of the public to address this body and all the committees, and will otherwise occur in a manner that protects the statutory and constitutional rights of parties and the members of the public attending the meeting via teleconferencing, and be it further resolved that, or finally resolved that that Cheryl Leger of the Sunshine Ordinance Task Force is directed to place a resolution substantially similar to this resolution on the agenda of a future meeting of the Sunshine Ordinance Task Force within the next 30 days. Sunshine Ordinance Task Force does not meet within the next 30 days. Cheryl Leger is directed to place such a resolution on the agenda of the next meeting of the Sunshine Ordinance Task Force, and that ends the resolution. So I'll open it up to Sunshine Task Force members for any discussion.
Do we need a discussion, or are you just looking for a motion?
Well, we must always ask for discussion if there's an action item. So if there's no discussion, then I'll open it up to public comment, and then we'll take a vote. Okay, no, I don't see any hands raised or anybody
Do we need a second on that?
flagging me. So let's open it up for public comment, and I'll hand the controls over to
So are you
Mr.
taking what I said is I motion that we approve this resolution?
We have to wait till public comment
Okay.
or you can make a motion, sure, and then we can take public comment. Are you making a motion?
Whichever you prefer in terms of
fine.
efficiency.
Make the motion. That's fine.
I make a motion that we approve this resolution.
Okay, is there a second?
Vice Chair Yankee will second.
And sorry, that was Member LaHood making an original motion.
Right. So motion made by Member LaHood, second by Vice Chair Yankee. Okay, public comment.
Please put David Pilpel in the queue. Thanks.
Do we have other public commenters? Chair Wolf, looks like we only have one public commenter, Mr. Pilpel.
Proceed.
Thank you, David Pilpel. So I've reviewed this issue, commented on it several times in the last couple of days. I would suggest the following edits on the portion that Chair Wolf just read. I would word it as follows: whereas the Sunshine Ordinance Task Force, etc. on that whereas. On the next resolved, one at this meeting, the Sunshine Ordinance Task, yeah, that's fine. On sub 3 on the next page, as described above, because of the COVID-19 pandemic, conducting meetings of this body and its committees in person, blah, blah, blah. And be it further resolved that for at least the next 30 days, meetings of the Sunshine Ordinance Task Force and its committees will continue to explore, next sentence, such meetings of this body or such meetings of the Sunshine Ordinance Task Force and its committees that occur by blah, 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 will provide an opportunity for members of the public to address this body and its committees and will otherwise occur, etc. And be it further resolved that the clerk or administrator of the Sunshine Ordinance Task Force is directed, Last sentence, if the Sunshine Ordinance Task Force does not meet within the next 30 days, comma, the clerk or administrator is directed to place such a resolution. It's been driving me nuts that the template from the city attorney had a typo at the end there. Directed to place such a resolution on the agenda of the next meeting of the Sunshine Ordinance Task Force, period. I don't believe it changes any of the intent, but I think it streamlines the language, and as I suspect you'll be adopting this every 30 days or so for the foreseeable future, I think it would be good to have a simpler and cleaner resolution. Unless there are questions, thanks for listening.
Any other public comment?
You have too much time on your hands.
Last call for public comment. Okay, public comment is closed. Member Highland.
Yeah, I just agree with the last speaker. I think it's important to put in the clerk of the committee rather than Cheryl Legge's name, because she's not there next month and Victor Young does it, then that could be an issue. So I think the clerk would be more encompassing, and I think it's also cleaner to write the Sunshine Task Force and its committees rather than listing them out each time, or list them out the first time but not subsequent times, just to have a cleaner document might be wiser. Thanks.
You're welcome. I think a better term is not clerk but administrator, because that's the official title. But it should be maybe administrator or assistant or I'm not sure, or other agent or other responsible party or something like that. Member LaHood.
I want to agree with Member Highland and with the commenter. In fact, I think all of the edits were very well worded, and if we were to just go back and listen to the audio and follow them in detail, I think that would make it all much simpler.
Hi. Are you waiting for Marie? Is she here?
Are you? Hello? Ma'am, can you please put yourself on mute by pressing *6? Thank you. Okay, so anybody else? Any other comments or adjustments? I agree. I thank the Mr. Pilpel, public commenter, for the good wordsmithing. I think that it doesn't change the intent, but does definitely streamline it. I would, with regards to replacing Mr. Legge's name, try to find it. Just put the word administrator in there. That still depicts that position be there. But if the administrator is not, present, then it's got to be some other responsible party it's filling in.
This is Victor Young. We could just say SOTF staff.
Okay, that's fine. Thank you for that suggestion. So in the last resolve, it'll be that the SOTF staff, or that the staff of the Sunshine Ordinance Task Force is directed. How about that? Okay. And all the other edits seem fine to me. Okay. No other comments? Ready for a vote? Okay. Please call the roll.
Member LaHood?
Aye.
Member LaHood, aye. Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Member Forsley, not present. Member Neighbors?
Aye.
Member Neighbors, aye. Member Highland?
Aye.
Member Highland, aye. Member Stein?
Aye.
Member Stein, aye. Member Wong? Not present. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member LaHood, second by Vice Chair Yankee to approve the resolution.
Okay, thank you. And thank you, DCA Castillo. Appreciate your help and advice on this. Continuing with the approval of the agenda.
I'm sorry, Chair Wolf.
Who's speaking?
It's David Pilpel. I'm happy to provide a marked version of that to Cheryl if that helps you. Thanks.
That's sure. Thank you.
Yes, that would be appreciated, Mr. Pilpel.
Okay. Need to take action on continuing item number 6. There's a lot of background noise. Can everybody please, who's on the phone, please press *6 to mute yourself? I will not continue the meeting until everybody does. It's too much background noise.
This is Victor Young. I'll go ahead and mute all the speakers at this time. And I would also suggest that we continue item number 12 as you referenced.
Yes, for sure. So I will I'll move it. Move to continue item number 6 and number 12 at the call of the chair. Is there a second?
Member Highland here will second.
Okay. Any discussion? Any public comment? If you wish public comment, please press *6 to unmute yourself and let us know. *6. Last call for public comment. Okay, seeing no public comment, are we ready for a vote? Okay, please, no objection, please call the roll.
Chair Wolf?
Aye.
Chair Wolf, aye. Member Highland?
Aye.
Member Highland, aye. Member Forsley, absent. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Wong, not present. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Moved by Chair Wolf, seconded by Member Highland to continue items 6 and 12 to the call of the chair.
Very good. Okay, please call the next item.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force September 1, 2021 meeting. I have a copy of the minutes. If anybody would like to make suggestions.
Members? Any changes or adjustments to the minutes? Okay, is there a motion to approve the minutes? I will call public comment after the motion is made.
This is Member Stein. I'll make a motion to approve the minutes.
Moved by Member Stein. Is there a second?
This is Member Neighbors. I'll second.
Moved by Member Stein, second by Member Neighbors. Is there, let's open up for public comment. Press *6 to unmute yourself and let us know that you wish to speak. *6 will unmute yourself and let us know that you wish to speak. Last call for public comment. Okay, hearing none. Members, any last discussion? Okay, ready for a vote? Hearing no objection, please call roll.
Member Stein?
Aye.
Member Stein, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Forsley, absent. Member Highland?
Aye.
Member Highland, aye. Member Wong? Not present. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member Stein, second by Member Neighbors to approve the minutes of September 1, 2021.
Okay, thank you. The motion is approved. Please call the next item.
Item number 3, Board of Supervisors Ordinance 201132, Campaign and Governmental Conduct Code, Behested Payments. Shall I read the preamble, Chair Wolf?
Go for it. Sure.
Effects on the Sunshine Ordinance Task Force members and possible additional proposed amendments to present to the Board of Supervisors based on discussion of this issue.
Okay, members. Some of you are new to this. Some of you are not. In 2017, there was an ordinance created that created some restrictions on activities by public officials, including appointed officials, with regards to fundraising by nonprofits and other types of entities. In that time, it was unclear as to whether the Sunshine Ordinance Task Force was also included in this because of our quote-unquote status and whether we rose to the litmus of what the original ordinance had placed these restrictions on, the type of body we are. We're kind of an interesting, unique body because we were created by the voters. We weren't created by the mayor or the executive branch. We weren't created by the Board of Supervisors, and we're not part of a charter amendment. And because we don't have specific authority to enact policy or to impose penalties or issue permits or what have you, we had asked the Ethics Commission, well, actually, one of our members at the time, Dave Moss, had asked the Ethics Commission for an official opinion, which summarily included the Sunshine Ordinance Task Force as he was asking the question based upon his position. He worked for a nonprofit, and several of us also did too. And the results of that were that the Sunshine Ordinance Task Force members are exempt from that original behest payment ordinance. These new amendments have come up, and it seems to include all appointive officers or appointive officials, and it's not clear as to whether the Sunshine Ordinance Task Force is still exempt or whether we have now been folded into these amendments. I have asked Supervisor Haney and his office to provide some explanation, considering he is the author. I heard back from his office today. Unfortunately, they have a conflicting meeting happening right now, so no one can be present from his office that is familiar familiar with the amendments to present. I had further requested, if they weren't able to send somebody, to continue the item until after our November 3rd meeting, so that we had an opportunity to be able to review it, provide any suggestions or a response to the committee, and whether whether they would do so, and give us an opportunity to be able to take action on it and some time to review it. In 2017, when this happened, when it first happened, the first round, it got continued by the Board of Supervisors a couple of times, and part of that was because we requested a presentation. At that time, it was through Supervisor Peskin's office, and his staff had come and gave, very ample access for a question and answer period, so we can get clarity on what the intent of the this legislation is. So with that said, I want to ask DCA Castillo if she has any further information to provide for us. I did ask for some legal counsel to review this, and so Ms. Castillo, do you?
I have reviewed it, but given the fact that the amendment is still undergoing revisions, I do not see anything additional to the language than what you've already stated. I think the difference in what you just, the item that you just raised about employees having to file Form 700, that may be the only thing, to the extent that you've stated that the members do file Form 700, that may trigger a requirement. But so far, it's hard to say what the impact will be without having the final resolution. But based on what the Ethics Commission stated in 2017, in their opinion and their finding, they didn't find that the members of the Sunshine Task Force were required to file or prohibited from, included in the ordinance.
Right. The requirements under the charter for the Form 700 and the the inclusion of the Sunshine Task Force, wasn't that part of the original ordinance also?
I didn't. I'm not sure. I didn't think I saw that.
Section 1104, right?
Hold on. I don't see that offhand. I don't have that copyright in front of me. But if it was part of the original ordinance in 2017 and there is no change to that, then we would need to look into it further. But I would say if that was part of the original requirement under the ordinance in 2017, and the Ethics Commission found that the members of the task force did not fall into the categories, then that would be true today. But like I said, I would have to see what the final ordinance states.
Okay, very good. Okay, any questions?
And I don't know, I think you referenced it and sent it to us, but I'm not sure if you circulated the Ethics Commission 2017 opinion. That might be worth reviewing for all the members, because they do lay out in their opinion not just their answer, but they go through an analysis of why they determined that the task force did not fall under the category of a administrative or an enforcement body.
Yeah, it
So that may
didn't make
provide
it in.
some explanation.
I agree. It didn't make it into the agenda as I had hoped.
Okay, that's fine. Yeah,
If
but just for
members,
future discussion.
if members are interested, well, we can send that around, and we can send that around, and also make that available on the website for members of the public to review too. There's no, unless somebody has some action or any prepared suggestions to move forward to the author or the committee, the rules committee. We can take that now. Otherwise, I would suggest just forwarding them to Ms. Leger, and then she can forward them to me, and I'll review it with Vice Chair Yankee, and then see about what the plans are from Supervisor Haney as to the future of the amendments at this point. We're kind of in a purgatory area without having any response from them. Okay, hearing none, let's open it up for public comment. Ms. Leger, I'll hand it to you.
Do we have public commenters?
Please unmute yourself by pressing *6 if you wish to comment.
This is public comment on item number 3.
Any public comment? Please unmute yourself by
David
pressing.
Pilpel.
There you go.
Hi.
Any other public commenters? Let's see if we can get if there's anybody else we can, so we don't have to keep stopping. Any other public comment? Okay, hearing none. Please wait for Ms. Leger.
Mr. Pilpel, are you ready?
Yeah. Are you all set?
Yep. Go ahead, sir.
Okay. Thank you. So this is on item 3, the board legislation on behested payments. The reference that you made to the Ethics Commission memo, I'm interested in that, whether or not you post it, if you could just relate to me the date of that memo, and if it is already on the website in connection with an Ethics Commission meeting, if you've got the URL or the meeting date, then I can find that. That would be very helpful. I recall a number of things. I recall that the task force is considered a policy body. I was advised long ago, far away, that it does exercise some sovereign powers of the city, and on that basis, the task force is subject to the Form 700 requirements, and I'm trying to remember what flowed from that. That although you have limited decision-making powers, that the powers that are spelled out in the ordinance do confer some powers and duties on the task force, and so taken together, I think you are subject to whatever requirements the board imposes on all officers generally, or on all members of boards and commissions. If there are particular issues that one or more members of this body thinks might impact them with this particular legislation about behested payments, then you may want to suggest an amendment that either carves out members of the task force or applies an exemption to some restriction read broadly, if that makes sense, to others similarly situated that serve on nonprofit boards or have other considerations. Anyway, that's just my recollection. Once again, it's been a long day. I hope that helps. And perhaps, again, if you could give me the date or a website for that memo. Thanks.
Any other public comments? Okay, hearing none. For everybody's edification, I have the item, the Ethics Commission's official opinion. It's a formal opinion. Its item number is OP Oscar Paul -17-001, and the date is printed on it is November 27th, 2017. It's titled Before the San Francisco Ethics Commission in the matter of formal opinion requested by Dave Moss, member of the Sunshine Task Force. By the Commission, Dave Moss, member of the Sunshine Task Force, has requested a formal opinion of the San Francisco Ethics Commission here in the Commission. Now, I'm going to fast forward out of the preamble and go down to the analysis and the conclusions. And I think just the very first result, very first one, it will answer many of the questions that member of the public, Mr. Pilpel, had brought forward. And you can get a little better idea, and everybody else can have it. Again, we'll get it posted on the website, but I think reading this into the record for everyone would be helpful. The question before the Ethics Commission is the Sunshine Ordinance Task Force subject to the behested ordinance? Answer, no. Members of the task force are not subject to the reporting requirement established in Ordinance number 001-17, contained in Campaign and Governmental Conduct Code, here in the code, section 3.610, period. Code section 3.610 provides that, quote, if a commissioner directly or indirectly requests or solicits any charitable contributions or series of charitable contributions from any party, participant, or agent of a party, or participant involved in a proceeding regarding administrative enforcement, a license, a permit, or other entitlement for use, and that list is emphasized, before the commissioner's board or commission, the commissioner shall file a behested payment report with the Ethics Commission, unquote. To determine whether the members of the task force will be subject to the reporting requirements in Code Section 3.610, we must determine whether the task force has been endowed with powers to preside over proceedings involving, quote, administrative enforcement, a license, a permit, or other entitlement for use, unquote. Section 67.35 of the Sunshine Ordinance establishes the task force and enumerates the instances under which the Sunshine Ordinance may be enforced. The task force has been empowered via the Sunshine Ordinance with the following authority. And these are in bullets. Quote, develop appropriate goals to ensure practical and timely implementation of this chapter, unquote. Next bullet, quote, propose to the Board of Supervisors amendments to this chapter, unquote. Next point, quote, report to the Board of Supervisors at least once annually on any practical or policy problems encountered in the administration of this chapter, unquote. Next point, quote, make referrals to a municipal office with enforcement power under this ordinance, unquote. And last point, quote, issue public reports evaluating compliance with this ordinance, unquote. If it goes on, the Sunshine Ordinance does not vest the task force with authority over any proceedings regarding a, quote, license, a permit, or other entitlement for use, unquote. While Section 6730 of the Administrative Code empowers the task force to make referrals to a, quote, municipal office with enforcement power under this ordinance, unquote, whenever it concludes that a person has violated any provisions of the Sunshine Ordinance. The Sunshine Ordinance withholds enforcement power from the task force and defers enforcement decisions to other bodies, period. New paragraph. As a general matter, administrative enforcement is limited to those proceedings which, 1, impact the rights and duties of a particular party, 2, are subject to appeal or other judicial review, and 3, result in deterrent or punitive action that carries the force and effect of law. The Sunshine Ordinance gives the task force no authority to conduct such proceedings. The purpose of the task force is to protect the public's interest in open government and open records. The task force's role in pursuing this purpose is advisory. The task force's primary function is to advise the Board of Supervisors and provide information to other city departments on appropriate ways in which to implement the Sunshine Ordinance. Because the task force cannot have before it a proceeding regarding, quote, administrative enforcement, a license, a permit, or other entitlement for use, unquote, Mr. Moss, as a member of the task force, is not subject to the new behested payments reporting provisions of Code Section 3.610. And by virtue of that, and I'm finishing there, and this is my own notation, and by virtue of Mr. Moss as being a member of the task force, extends to all members of the task force. Okay, any further questions, discussion? DCA Castillo, is there anything you wish to add?
Multi-reading.
I'm sorry, I didn't hear you.
Oh, sorry. No, I think you covered it all by
Okay.
reading the portions of the opinion in the Ethics Commission.
Okay, if anybody's of interest, the last two questions were, and they're very short. Does the Sunshine Ordinance Task Force engage in proceedings regarding administrative enforcement, licensing permits, or other entitlement under the Behested Payment Ordinance? The answer is no. See the above question, which I just read. And the last one are parties with complaints and other matters before the Sunshine Ordinance Task Force, quote unquote, quote, participants, unquote, and quote, parties, unquote, as described in the Behested Payment Ordinance. And the response from the Ethics Commission is no. See the same response from the question one. So then their final statement is, as a member of the Sunshine Ordinance Task Force, therefore, Mr. Moss is not subject to the reporting requirements in Campaign and Governmental Code Section 3.610. This response constitutes a formal opinion by the Ethics Commission concerning the application of the Campaign and Government Conduct Code and the Commission regulations to specific transactions or activities set forth. Reliance on this opinion is limited to the facts presented here. Any change in material facts presented may alter the analysis and conclusion of this opinion, and the analysis conclusions reached in this formal opinion may be affected by subsequent developments in the law, including but not limited to statutes, ordinance, regulations, formal opinions, and case law, period. And that ends the document. Okay, if there isn't anything else, we've had public comment, opportunity to discuss. We'll continue this item to the next meeting. And if there could be a motion to that, I would appreciate it. Entertain a motion to continue.
This is Member LaHood. I make a motion to continue this matter to the call of the chair.
They moved by Member LaHood. Is there a second?
This is Member Stein. I will second that.
So moved by Member LaHood, second by Member Stein. Are we ready for a vote? Hearing no objection, please call the roll.
Member LaHood?
Aye.
Member LaHood, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley, absent. Member Neighbors?
Aye.
Member Neighbors, aye. Member Highland?
Aye.
Member Highland, aye. Member Wong? Not present. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member LaHood, second by Member Stein to continue the matter to the call of the chair.
Very good. Please call next item.
Second. Item number 4, file number 21054. Complaint filed by Patrick Monette Shaw against Grant Colfax, Veronica Vian, and the Department of Public Health for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner. On July 20, 2021, the Complaint Committee requested that the respondent provide the requested records within 2 weeks and that the petitioner report back to the committee. As of August 25, 2021, the petitioner had not received their documents.
Okay, Complaint Committee Chair Schmidt, would you like to offer any opening statement or brief report from the committee?
What I will say is that Mr. Monette Shaw apparently was in the past able to get reports of the type of information that he's seeking now. The hospital made a change in its computer systems. He made a request which seemed to be not anything different than what he had done in the past, and was told that he basically wasn't given the kind of records he was used to getting. In pursuing his claim here, he was told that for some reason at this time, there would need to be a manual search in order to fulfill his request, as opposed to keying in search terms as had been done in the past. And he's heard sort of conflicting information. He believes that it doesn't make sense that the current system wouldn't be able to generate what he needs. So there's a factual question, I guess, as to is it true that for some reason when they made their changes, now it's gone back to a manual system? And then there's I believe you could say there's a legal question, which is that if it's true, if that factual question proves to be if the answer to that question is, yeah, they've gone back to some kind of manual system, then would they need to go to the files and compile what he's looking for, or would that be considered to be a requirement that they create a new document? And so that is somewhat their contention, is that they don't need to create a new document. And there is some, at least state law, that says that in certain cases, you don't need to create a new document. So that's my summary of the situation. I know that Member Stein may have made the motion back at the committee, so I should also see if she has anything to add.
Sorry, I don't have anything to add. I think that was the one meeting that I wasn't able to attend originally. I did have a question about whether in that meeting DPH had said whether or not they even still use the SF Get Care database, but I don't think I was at that meeting.
As I recall, the motion was to ask them for a report to give us a little more information. Now I'm recalling it was Member Wolf, maybe who Chair Wolf, who made the motion to ask them to fill us in on what exactly is going on, and that they would need to report back to us. And I believe there's been no response in any way.
Thanks.
Okay, thank you very much. I just for everybody's edification, I know we usually take public comment at 5 o'clock, but the petitioner had requested a reasonable accommodation to be heard before public comment, and considering the two items before took a little bit of extra time, we're going to continue hearing this item, and then we'll have public comment, general public comment thereafter. Okay, so let's begin our process. We're going to hear from the petitioner first, and then we're going to call for any any witnesses. Then we're going to hear from the respondent, ask for any witnesses from them. There'll be a question and answer period for clarification by the task force. Then we'll hear rebuttals, and the task force will there'll be I'll entertain a motion. We'll take some public comment after the motion is made, and we'll take action. Okay, Ms. Leger, are you ready?
I am, Mr. Minich. Are you ready to begin?
Yes, ma'am.
And is the respondent here? Is the respondent? Department of Public Health? Is anyone? Yes. Who's speaking?
Oh, yes. This is Christina Padilla. I'm a public information officer at the San Francisco Department of Public Health.
Familiar with the? Are you familiar with the details of this complaint?
I'm somewhat familiar. I do want to preface this by saying that the previous custodian of records, Veronica Vian, she was managing this request, and she left the organization recently in September. So I'm temporarily covering public records until a new person is hired to take her place. And I'm saying that because the extent of my historical knowledge is limited to what was entered in our next request database, and that 4-page document that Mr. Monette Shaw provided, which I read in detail. So I have some history of it, but not everything.
Okay, great. So members, I'm just going to preface this by saying, if you find that Ms. Badillo does not have enough information to provide enough representation for the respondent in response to the complaint, that you might want to consider continuing the item. So just keep that in mind. Okay, so let's begin. Ms. Leger, I'll hand it over to you, and we'll hear from the petitioner, Mr. Monette Shaw first. Thank you.
Mr. Monette Shaw, you ready to speak?
Yes, ma'am.
Go ahead, sir.
I filed this complaint on May 4th, 2021. Despite the 2 supplemental documents I submitted afterwards on July 15th and September 10th, and the chronology document I submitted to you on October 6th to summarize this complaint and add additional information that later became available, the initial complaint remains essentially unchanged, except for the addition of Eric Raffin, Jeff Scarafia, and Dr. Ratana Wongsa as additional individuals responsible at DPH. DPH has provided in the past similar data for at least 7 years, going back to at least July 2006 by providing retrospective data. My initial complaint noted that DPH provided a partial response about out-of-county discharges from Laguna Honda Hospital. DPH has not provided the out-of-county discharges from SFGH because it claimed, I think wrongly, on September 16th, 2020, that its new electronic healthcare record system named EPIC doesn't track out-of-county discharges. So DPH has still not completed this records request by providing the out-of-county discharge data from SFGH. After submitting this complaint on May 4th, I received additional information on June 16th from EPIC Corporation's Media Relations Department, who informed me that EPIC's database contains a module named Patient Flow that captures each patient's discharge location, including the name and address of the facility, the name of the city the facility is located in, along with the type of facility patient has been discharged to, apparently in structured database fields. So I filed my first supplement on July 15th, prior to the complaint committee's July 20th jurisdictional hearing. The complaint committee found the task force has jurisdiction and directed Ms. Vienne and DPH to submit in writing within 2 weeks from a knowledgeable person whether the requested records exist in DPH databases and whether the data could be extracted to comply with California Code Section 6253.9A. Ms. Leger has confirmed DPH did not respond within the 2-week period the complaint committee had requested. Following the July 20th complaint committee hearing, I received a response to a separate but very related records request on August 2nd, containing a thread of 29 emails exchanged among DPH IT staff members. So I filed my second supplemental document on September. Of note, the 29 emails revealed DPH's staff claimed there were no structured database fields, but EPIC Corporation appears to show that there are structured database fields that I showed you in the graphic on page 65 in the full packet.
Sorry, sir, your time's up.
Okay, I will continue in a rebuttal period.
Okay, thank you. I just put a note for the record that Vice Chair Yankee left the meeting at about 4:02 p.m. I think he'll be returning within the hour. Okay, are there any persons or witnesses to provide any facts or evidence in support of the petitioner? Okay, hearing none. Respondent, Ms. Padillo, you have 5 minutes. Wait for Ms. Leger.
Ms. Padilla, are you ready?
Yes.
You may begin.
Thank you. From the files that I have that the previous custodian of records worked on, I see that her response was that because the Department of Public Health adopted a new electronic record system. We do not currently track the out-of-county discharges, and because it was going to be a manual process through the new system, the city's obligation under the Sunshine Ordinance, like the Public Records Act, is to produce public records in its custody. And so there was no requirement that a department construct the document for the request. And that's really all of the information that I have regarding this request.
Does that complete your testimony?
Yes.
Okay, thank you. Are there any persons or witnesses providing facts or evidence on behalf of the respondent? Okay, hearing none. Members, the matter is now with you for questions and answers, clarification. We'll have debate after rebuttals.
What about a rebuttal period to what DPH just said?
Mr. Minette-Shaw, you're aware of our process that we have a Q&A clarification period now, and then when the task force members are satisfied, then I'll call for rebuttals.
Okay.
Can you acknowledge?
Yes, okay, go ahead.
Thank you. Member LaHood.
Yes, thank you. Ms. Padilla, I have a question. You said that this would require some research and a manual assembling of information. If it's possible to do this research, it strikes me that there are responsive documents. These documents perhaps need to be redacted, but couldn't you redact them to only show the requested information? If the information exists in public documents and you can provide it in that format, I don't think you're required to create a new database. You could just provide those documents redacted in such a way to show just the requested information, to show the requested information and redact any information that should be redacted for in light of privacy concerns. Is that something that you think would be possible?
I would like to speak to some of our DPH subject matter experts on EPIC or some of the leadership to understand what that process is like before I give just to give a more informed answer, just because I know it's a manual process, but I don't know what that looks like.
Okay, thank you. That was my question.
Okay, Member Padmanabhan.
So, Ms. Padilla, I don't know if you, so if you're going to ask, questions about EPIC, then could you add this too, as to whether Mr. Minette-Shaw is right about whether EPIC contains the patient flow data? And if so, does that not mean that out-of-county discharges are data is present, is there in EPIC? And yeah, could you find the answer for us, Ms. Padilla?
Yes, I can.
Okay.
Yeah.
The second question is also for Mr. Minette-Shaw. You had written that that you received an email that was heavily redacted from Ms. Vian. What was in that email?
I don't know, obviously, because I can't see under the redaction, but the timing of it was interesting. I submitted it late in the afternoon or evening on May 4th. And on May 5th, I received a receipt in email that DPH Miss Vian had in fact opened and read my Sunshine complaint that I filed the day before on May 4th. And it was somewhat curious that they chose to redact part of her email to other DPH IT staff. So the coincidence in timing was really strange because I had never, ever received any redacted information in the 7 or more years I've been requesting similar data. And in those 7 years, they never had a need to redact patient information that may have violated HIPAA, patient privacy protections. This is strictly aggregate data. It is not about any individual patient discharge location. And consistently over 7 years or more, DPH has provided the same information without any allegation that it would require redacting patient confidential information. And I might add that the documents I have submitted to you addresses the fact that if a patient at Laguna Honda Hospital or SFGH has been hospitalized with room charges, how does DPH know when to stop the billing for those room charges after the patient has been discharged if their electronic record system doesn't know when the patient is discharged to? They have been barking up the wrong tree, obfuscating the issue by saying that they have difficulty matching up zip codes at the time of discharge, when in fact, Epic Corporation has indicated there are structured database fields that list the name of a city a patient is discharged to. It's in Epic, it's there, but the IT staff 29 email exchanges never addressed why they couldn't look in the patient flow module that contains the discharge disposition data that Epic Corporation claims exists, and they've never tried to address why they are suddenly unable to track this when they've been providing it for over 7 years. I can't believe they've spent $164 million on a replacement electronic healthcare record system that doesn't know where the patient is or where to send the bill to collect any kind of insurance or reimbursement for the hospitalization. This is completely ridiculous.
So this leads me to my last question for Ms. Padilla, which is that do you know of other databases that are in use?
I'm sorry, can you repeat that?
Do you know what other databases are in use other than EHR or Epic?
To
track
I can add that to the questions to ask our subject matter experts for Epic.
Okay.
I'll call upon myself. Ms. Padilla, is it Padilla or Padillo?
Padilla with an A.
Padilla, I'm sorry. Okay, just want to make sure I'm pronouncing it right. So at the time, the complaint committee had made this request that the respondent provide either in person or in writing from a knowledgeable person of this database and of the data when the data to provide when the data was transferred from the old to the new system, and if the information that the requester requested is contained in the new database. That's the first part. Was that satisfied?
No.
I don't believe it was.
Okay. The second part is, and whether the information is extractable from either database for the period of time that the requester made the request, and provide that in writing within 2 weeks. Was that satisfied?
I don't believe it was either.
Okay, thank you. Any other questions, clarifications? Okay, are we ready for rebuttals? Okay, seeing no objection, we'll hear from the respondent first on rebuttal for 3 minutes, and then the petitioner. Ms. Leger, I hand it over to you.
Okay. First the petitioner, you said? I thought.
No, first the respondent, then
Yeah.
the petitioner.
Yeah. Ms. Padilla, are you prepared?
I'm here, yes.
Okay, I'm going to start the timer. Go ahead, ma'am.
It appears to me that we owe the requester, Mr. Monet Shaw, either the responsive records if they're available within EPIC, which I can confirm with our subject matter experts, or the documentation in writing from the subject matter experts, whether the records are contained in EPIC. I know there are some questions we have at hand, and that's something that I can work on. And that's all I have.
Okay, thank you very much.
Thank you.
And now the petitioner. Please wait for Ms. Lee.
Patrick, are you ready?
Yes.
Go ahead, sir.
I have tried my damnedest to inform Chair Wolf and the task force that this does not involve migrating records from old databases to new databases. The time frame that I've been looking for this data should only have been entered into EPIC. And it's disheartening that we now have another public information officer who is not, admittedly, a subject matter expert. She doesn't know what she's talking about. And the data exists in EPIC. They don't need to export it or anything else other than write a query looking for the name of the city of the facility a patient is discharged to. It doesn't violate HIPAA. It is not something protected under patient confidentiality. They've been providing this for over 7 years, and I can't believe they paid $164 million for a database that can't do what the old database did. This is ridiculous.
Okay. Okay, thank you very much. Does that conclude your rebuttal?
Well, there's lots more I'd like to get to, and about the fact that knowledgeable staff have not appeared at all in any of these hearings, and that DPH is simply stonewalling and snowing the task force. The data is there. Epic Corporation admits the data is there. It's just that the IT staff got stuck
30 seconds, sir.
whining about zip codes instead of focusing on the discharge notes.
Maybe not.
Can you please stop the clock? Victor, can you please? We can't do that when we're going to cut the other folks off. Can everybody please, if you're not part of this party to this, please press *6 and mute yourself. Lots of background. Thank you. Okay, please continue with the clock. Thank you. Mr. Manette-Shaw?
What?
You can continue for the rest of your time. I'm sorry.
Okay, I'm not sure what else to say. That the claim that DPH now needs to go back and consult with its subject matter experts is completely ridiculous. The task force should direct DPH to produce the records within the next 5 days, and the task force should order DPH to work with Epic Corporation to figure out how to write a database query to get at the records that have got to be in that database. How do you stop billing? How do you hand a patient discharge notes with their list of medications and do any kind of post-discharge follow-up of patients if you don't know where the fuck that they're at? This is nuts.
Okay, Mr. Manette-Shaw, please watch your language. Thank you.
You need to direct DPH to contact Epic's technical support staff to figure out how to write this query. The data is there. It's in another Epic feature called Care Everywhere. If you go to the hospital, like I did a year ago, you're handed a 13-page or more document when you are discharged. It's all tied into records in a patient's chart, and if they're not putting it in the chart, then they never had the patient. It didn't happen. If they don't know where the patient is discharged to, presumably the patient is still there, and the billing is going to continue until they figure out when and where they discharge the patient to.
Okay.
This is not rocket science.
Okay, I think we're over time. I have not heard Ms. Leger call for the end of the time, but I think we've heard enough. Thank you very much. Members, the item now is with you for deliberation and for action. Member Padmanabhan.
Yeah, I'd like to go ahead and make a motion.
Go ahead.
So I move to find the Department of Public Health violated Administrative Code, Sunshine Ordinance Section 67.21B for incomplete production of records, 67.21C for failing to provide assistance, 67.27 for failing to provide justification for redaction, and maybe 67.22B for not sending knowledgeable staff.
What about willful failure?
No, Mr. Manette Shaw, please do not speak out of turn. Please, your time, we've had your time, we have your records. It is up to the task force now to make their decision. Thank you, Member Padmanabhan. So we have a motion for 6721B, 6727, 6721B and C, 6722B, and 6727, right?
That's right.
Okay, great. Is there a second?
I'll second. Member Schmidt?
Moved by Member Padmanabhan.
Will that include an order that all this be produced? I'm not sure if I heard that.
Member Padmanabhan?
Yes, I'm happy to include that.
Good motion. Second.
Okay. Addition that records be produced, is there a time frame?
5 days.
Please, Mr. Manette Shaw, I'm just going to mute you if you're going to continue to speak out of turn. I'm not going to tolerate it. Members, is there a time frame? So generally, when we issue orders of determination, our complaint procedure requires a response within 5 days. So
then in that case, yeah.
So 5 days?
5 days.
And I will add that this will be monitored by compliance and amendments. Is that okay with you? Okay, great. So I'll repeat the motion. Okay, great. So this was moved by Member Padmanabhan, second by Member Schmidt to find a violation, the Department of Public Health in violation of 6721B, 6721C, 6722B, 6727, with the reasons behind those that can be retrieved later, and that the records be produced within 5 days, and that this be referred to compliance and amendments for monitoring. Okay, members, any further discussion or debate before I open a public comment? Okay, hearing none, we can come back to that. We'll open it for public comments. So public comment for anyone other than the parties.
I would like to make public comment.
Please unmute yourself. We hear you. Please unmute yourself by pressing *6 and wait for Ms. Leger.
I'm waiting to make public comment.
Oh, okay. We will call you speaker number 1.
Okay, can I start?
Just a moment. I want to see if there are other public commenters. Okay, Chair Wolf, I'm not hearing other public commenters. We will begin with speaker number 1. Ma'am, are you ready?
Yes. My name is Dr. Teresa Palmer. I'm an ex-employee of UCSF, and I'm still a referring physician to UCSF. And I wanted to note that there is a pressing public interest in knowing who we are transferring out of county, because it's an important measure of gaps in services in San Francisco. If we have to dump people out of county, it means that we can't take care of them in county, and we need to know that. I am very familiar with Epic. I've used it at Kaiser, at UCSF, and at Sutter, and I remain a referring physician for 2 of these systems. There is clearly a data entry about discharge that could be, and location of discharge that could be found by writing the proper data request. And my feeling is that the folks at the Department of Public Health just don't want to know who's going out of county, and or they're too overwhelmed from COVID to try to find out. But we do need to know who we're dumping out of county. And I think Mr. Manette Shaw is extremely right. He's been working on this information for years. We have multiple supervisors who are interested in writing legislation to have hospitals track who's being discharged out of county. And we need to start with our own house. Thank you.
Any other public comment? Last call for public comment. Okay, public comment is closed. Members, are we ready for a vote? Hearing no objection, please call the roll.
Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Forsley, absent. Member Neighbors?
Aye.
Member Neighbors, aye. Member Highland?
Aye.
Member Highland, aye. Member Stein?
Aye.
Member Stein, aye. Member Wong? Member Wong, absent. Member LaHood?
Aye.
Member LaHood, aye. Vice Chair Yankee?
Absent.
Absent. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member Padmanabhan, seconded by Member Schmidt, to find that the Department of Public Health violated 6721B and C for incomplete production of record, 6722B and 6727 for failing to provide justification for redaction, and that the records be produced within 5 days and to be monitored by the Compliance and Amendments Committee.
Very good. Okay, please call the next item.
Thank you.
Before you move on, I just want to state that 5 days is from the issue of the order of determination and not 5 days from today.
Yes. Thank you.
No.
Yes, that's the way our complaint procedure is written. I'm
That
sorry.
could take months.
No, it won't take months. Please call the next item.
Item number 7, file number 20100, complaint filed by Winship Hillier against the Behavioral Health Commission.
Oh, no, Ms. Leger, you missed public comment, general public comment.
Sorry, I apologize. You're absolutely right, I apologize. Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay, if you wish to speak in general public comment on items not on today's agenda, please unmute yourself by pressing *6, and I'll hand it over to you, Ms. Leger.
Sullivan. Winship Hillier.
Do we have other public commenters?
Winship Hillier?
I got you, Mr. Hillier. I'm just trying to see if there are other public commenters. Okay, we will begin with Mr. Sullivan. Mr. Sullivan, are you ready?
Yes.
Go ahead, sir.
The Sunshine Ordinance requires that public employees give accurate and truthful information. I'm going to work backwards into this reasoning because I think it will be easier to understand. Section 67.22, release of oral information, B. This section shall not be interpreted to curtail existing informal contacts between employees and members of the public when these contacts are occasional, acceptable to the employee and the department, not disruptive of his or her operational duties, and confided to accurate information, not confidential by law. So informal contact, employees must give accurate information. Kind of sounds like the task force should hold informal hearings. A broad and logical interpretation of this is that employees must also provide accurate information in formal situations. It seems the assumption of the ordinance writers. I went looking for some language to back it up. Big things are usually at the top. Section 67(1), finding and purpose. B, election officials, commissions, boards, councils, and other agencies of the city and county exist to conduct the people's business. People do not cede to these entities the right to decide what the people should know about the operation of local governments. Also, no is used in 67(1)D and the Brown Act 54950. Dictionary.com, no, to perceive or understand as fact or truth, to apprehend clearly with certainty. Merriam-Webster, no, to be aware of the truth or factuality of, be convinced or certain of. In my opinion, the Sunshine Ordinance and the Brown Act requires government employees to provide accurate and truthful information at hearings, regardless if they are not under oath. The Sunshine Ordinance goes further in section 6722E in protecting public employees from disciplinary action for being accurate, speaking the truth, and disclosing any public information or a public record. Thank you for your time.
I would like to speak.
Mr. Hillier, are you ready?
I'm ready, Ms. Leger.
Okay. Go ahead, sir.
Thank you, Ms. Leger. I don't need a warning because I'm timing myself. Ladies and gentlemen of the task force, I'm a frequent flyer and hoping to continue to be, well, not really hoping, but I'm anticipating continuing to be. I would like a reference to staff or other resources for factual information regarding the following question. Often I create complaints that have multiple attachments, multiple files, agendas, minutes, and emails, and other documents. They're all combined into one complaint. And usually what I do is I go to FedEx to do this, and while the clock is ticking away at 65 cents a minute, I put these files together into one file, and I put bookmarks on each of the attachments so you can easily navigate to each of them using the bookmark plane. I also sometimes put in highlighting, and that's very, very important sometimes because some of the documents are long. The emails can be long, they can be lengthy. It's very helpful to have highlighting. The minutes can be long, the agendas can be long. However, I noticed that when these complaints are sent around to the task force, and also I think when they're sent out to the respondent, that both of those kinds of information, the highlighting and the bookmarks, are stripped out. And I would like to know whether the task force at least has access to the original PDF filing that I produced, and whether the complainant or the respondent can also have access to that. But mainly it's the task force. That's a big mystery. I don't know what you people have access to. If you only have access to what's on the public record, i.e. what you get when you click through the agenda to the PDF with the P numbers on the bottom, stamped on the bottom, if that's what you get, if that's all that you have access to, then you're losing all that information. And I don't have to, I shouldn't spend my time and my money putting it in the first place, and B, I'll find some other way of drawing your attention to the appropriate information or putting page numbers for the attachments and so forth. So I'd like a referral to staff or other resources. I've got you, Cheryl. I'm timing myself for factual information. Back to you, Madam Clerk.
Did we have another? Did we have another public comment?
I would like to speak on Patrick.
Are you ready, Patrick?
Yes.
Go ahead, sir.
I cannot begin to express my disappointment with the task force. I have been engaged in filing sunshine complaints, supporting complainants, all the way back to Alan Grossman. You remember Alan? He was a brilliant lawyer. And I can't believe that after 20 years of being involved with the Sunshine Task Force, suggesting revisions to the language of the Sunshine Ordinance and rooting for the task force to be a truly independent body of City Hall, that you are still demonstrated today that, as Mr. Sullivan indicated, the task force is being snowed by public information officers who are not knowledgeable technically about the sunshine complaints filed against their city agencies. They waltz into your hearings and they lie to you. They don't present you with accurate information. They throw sand in the eyes of the bull, and you folks swallow it. Hook, line, and sinker. What you just got out of DPH on my complaint is complete bullshit. I don't care if my First Amendment use of the vernacular annoys members of the task force, but there you have it. You just got snowed. That data is available in Epic, in their database. They should never have spent $164 million on a database that doesn't know where their patients have been discharged to. The Sunshine Task Force is becoming, in my eyes, a huge disappointment in keeping our government open for we, the people. We do not cede to DPH or anybody else being able to come in there and snow the task force and lie to you through their teeth.
Thank you. Thank you. Any other public comment? Last call for public comment. All right, I'll just say to the last speaker that, first of all, your comment, is on an item that was on our agenda. So not appreciative of that, respect. And we did find it in your favor on 5 counts. So that ends public comment. I'm not hearing anybody else stepping up. So public comment is closed. Let's go to the next item. Thank you.
Chair Wolf, item number 7.
Item number 7, yes.
Yes. File number 20100, complaint filed by Winship Hillier against the Behavioral Health Commission, formerly known as the Mental Health Board, for allegedly violating Section 67A, failing to post the agenda 72 hours in advance, and failure to provide a description of each item of business. 67.7B, failing to post documents on the website or make available to the public. 67.7D, failure to take action on any item not on the agenda. 67.7G, as in George, failing to allow public comment. 67.9A, failure to post relevant documents on the internet. On June 8th, 2021, the Education, Outreach, and Training Committee heard the matter and moved to find jurisdiction. The records are public and refer the matter to the task force to consider the following violations. 67.7 for failing to comply with the gender requirements, 67.15 for failing to allow public comment, and 67.29 for failing to maintain and update their web page and access.
Okay, I apologize, folks. There was supposed to be an item before this to determine whether items number 7 and 8 should be combined, and that has been omitted from the agenda. There was after reading both of these and seeing that they were heard by 2 different committees inadvertently, I contacted the chairs and confirmed that they did confirm it. So I want to entertain a motion to combine the items, and we can get some explanation why.
I'll second that motion. This is Member Highland.
Okay. So note that I made the motion to combine items 7 and 8, second by Member Highland, and I'll defer to both Member Highland and Member Schmidt, who are chairs of respective committees that heard this item, for any presentation or comment or report.
Member Highland,
go ahead.
Go ahead if you want, or else I'll take a shot at it. Our case may have been the more global of the two from looking at this.
I agree. I think a lot of our items come up again in yours, so I think we're a subset of yours. But what members might want to do is, as Member Schmidt is presenting, is take a look on the next item, item 8. Look at the attachment. Look at page 449. There's a list of all the complaints there, so just to give you that sort of that global perspective as to what we're dealing with here, if you haven't already. But that will kind of, I think, start us out at a 33,000 foot vantage point on this, and then kind of drill down to where we need to get to. So go ahead, Member Schmidt.
Sure. In terms of the motion, at least, which certainly I can understand value in combining these two. The case that was heard before the EOTC, Chair Highland, seems to be limited to approximately 7 claims arising out of a July 15 meeting, and they're all meeting violation claims. The second matter, which is in our committee, the complaint committee, there's actually enumerated, I think, 103 claim violations by the claimant, which would encompass pretty much what was included in 20100. I'm not sure if they match up item by item, but you take that July 15 meeting and then several other meetings, both before and after, and it's the same types of claims. There's about 7 or 8 provisions in the ordinance that are cited. I think that the argument in the presentation would be on the same issues, and I believe that our ruling would probably be in the first case. It would be pretty much dictated by what our ruling would be in the second case. In terms of the types of claims, they're all about basically how the meetings are being run at the Behavioral Health Commission, how they're posting their agendas, whether they're putting up certain documents. I mean, there's a litany of claims, as you can see. The complainant has been extremely helpful in detailing all these claims and even enumerating them for us to the point where I think that the Behavioral Health Commission, we haven't gotten too much of a response from them, although it's a pretty massive set of allegations that are here. So with that in mind, I think that we might as well combine the two and hear them together. That's all.
Okay, great. Just want to recognize Vice Chair Yankee has returned to the meeting at 5:55 p.m. I have a question for either or both of you. Both of these complaints involve meeting issues around open meetings?
Yes.
Okay. And while the second item 20143 has more reports of the violation the violations are more or less the same, or the allegations of violation are more or less the same between the two?
Yes, with maybe one or two sort of random ones that are thrown in. I think I count about 8 different sub provisions that seem to be implicated, and so there's a couple more on top of what were considered in 20100.
Okay, so as you were saying, 20100 is somewhat of a subset or inclusive of the similar or same allegations as in 20143.
Yes.
Okay, great. Member Highland.
I was just going to echo that basically I think any violation, should we find any in 20143, would more than amply cover 20100, would be my feeling.
Okay, great. All right, since we have motion on the floor, any other members, any other discussion or questions on combining items 7 and 8? So these are files number 20100 and 20143. They fit our, just for everybody's edification, they fit our criteria for combining, which are would be have the same nucleus of facts, have the same complainant and respondent, have the same complaint and or administrative codes in question. Issues or violations must be within 90 days of submission of the initial complaint. And so with that, let's open up for public comment, and this will include the parties. Parties may speak on this combining of the two. I will ask that the parties be, if they wish to speak, that they speak first. And so that would be Mr. Hillier and the respondent, whoever's representing the commission.
Okay, let me know when you're ready.
Do we have a respondent who'd like to speak?
Can you hear me?
Yes, we can. Is
Hello?
that Mr. Gray?
Can anybody? Oh, okay. Yeah, this is Jeffrey Greer, Executive Director.
Okay, Mr. Hillier first.
Yes, I know. Mr. Hillier, are you ready to speak?
Yes.
Go ahead, sir.
Thank you. I'm only speaking on the motion to combine. Just wanted to say I was very careful not to duplicate any claims between the two complaints. They're all distinct claims. However, the 20143 covers the July 15th, 2020 meeting, which is also the exclusive subject of the 20100. 20143 also raises some records issues. We did request some records, and there were some violations of specifically the higher numbered divisions of the Sunshine Ordinance. Back to you, Madam Clerk.
Ms. Leger?
I'm with it. Just a second. Mr. Gray, are you ready to speak, sir?
Yes, I am.
Go ahead.
I just would like to echo that I don't really have a problem with the combination of the two files. There are distinct differences, as the complainant pointed out, which I will get into as we get into the further explanation. I do have public comment from a commissioner that can't be present. I don't know if this is the forum or time, but just to kind of echo the sentiment, I don't have a problem with the combination of the two files.
Okay, thank you. Before we take additional public comment on the combination, members, do you have any questions for any of the parties? Okay, hearing none, let's continue with public comment and then we can come back to discussion.
Do we have other?
Can I present public comment on behalf of a commissioner that cannot be present?
If it pertains to the combining, if it's specific to the merits of one or the other case, okay. So hold off on that until till we get into the meat of the case. Thank you. Any other public comment? Okay, members. Any other discussion? I find Mr. Hillier's comment to be somewhat compelling. He seems to have been deliberate in making these separate. I do have some concerns that they, it's kind of, we don't allow duplicative complaints. We would prefer and generally accept complaints about the same parties around the same kind of issue, whether it's a meeting or the same documents, and to have all the issues be contained in that one complaint, because it sets a precedent, and that's why we created the combining provision in the complaint procedure. Any other discussion or debate?
Member Highland here, Chair Wolf. Not quite sure what side of the line you're falling on with that comment. What I heard from Mr. Hillier is, yes, he had different things that he put into different complaints. but he also agreed that they would be covered by the same parts of the Sunshine code. So I kind of read his response as he was okay with the combination. That's how I read it.
Okay, that's fine. All right, are we ready for a vote? Okay, hearing no objections, please call the roll.
Give me a minute. Chair Wolf?
Aye.
Chair Wolf, aye. Member Highland?
Aye.
Member Highland, aye. Member Forsley, absent. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Wong?
I did not hear any of this item, so I don't feel comfortable voting. I just showed up 3 minutes ago.
Okay, so if you cannot make a vote on it, then we'll ask you to step out of the room.
Okay,
and
will do.
And
I'll
remain
come back.
absent. Okay, because we can't take abstentions.
Member.
Okay, should I come back in 5 minutes?
Come back in like 3 minutes.
Okay.
Yeah.
Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Vice Chair Yankee, were you present for the discussion?
Yes, aye.
Member Vice Chair Yankee, aye. Moved by Chair Wolf, second by Member Highland, that after reading the agenda and seeing both matters of items 7 and 8 were heard by different committees, and the motion to combine the items has passed.
Okay, thank you. All right, so we're going to hear both these items as one. You can let's start by reading, Ms. Leger, if you can read both of the preambles of the items, because they are written differently on the agenda, and then we'll begin our hearing process.
When you say preambles, do you mean that the description under each item?
Yes.
Okay. Item number 7, file number 20100, complaint filed by Winship Hillier against the Behavioral Health Commission, formerly known as the Mental Health Board, for allegedly violating Section 67(7)(a), failing to post the agenda 72 hours in advance, and failure to provide a description of each item of business. 67(7)(b), failing to post documents on the website or make available to the public. 67(7)(d) as in dog, failure to take action on any item not on the agenda. 67(7)(g) as in George, failing to allow public comment. 67(9)(a), failure to post relevant documents on the internet. Item number 8, file number 20143, complaint filed by Winship Hillier.
Oh, wait a second. Please read the italics.
All right. Okay.
Thank you.
On June 8, 2021, the Education Outreach and Training Committee heard the matter and moved to find jurisdiction, that the records are public, and refer the matter to the task force to consider the following violations. 67(7) for failing to comply with agenda requirements, 67(15) for failing to allow public comment, and 67(29) for failing to maintain and update their web page and access. Item number 8, file number 20143, complaint filed by Winship Hillier against the Behavioral Health Commission for allegedly violating Administrative Code Section 67(7)(a) as in Apple by failing to post the agenda 72 hours in advance of the meeting and failure to provide a description of each item of business. 67B, B as in boy, failing to post documents on the website or make available to the public. 67.7, G as in George, failing to allow public comment. And failing to include notices, rights under the Sunshine Ordinance on the agenda. 67.7H, failing to include contact information and the administrator's name on the agenda. 67.9, A as in Apple, failure to post relevant documents on the internet. 67.15, C as in cat, failing to allow public comment. And 67.21, B as in boy, failing to make files available to the public. On August 17, 2021, the Complaint Committee found jurisdiction that the records are public and referred the matter to the task force.
Okay, great. Thank you. And I'd like to recognize Member Wong at 6:12, I think. Okay, great. Now let's go to both chairs of EOT and complaints. Is there any presentation or report that you'd like to make with regards to this item? And just before you begin, for Member Wong or anybody else that joined us late, we've agreed to and approved to combine items 7 and 8, file number 20100 and 20143. Thank you. Continue.
I believe Member Schmidt kind of gave a pretty good macro look at what this item was about. So other than the 3 instances that we found in the first case, I think we kind of have to get into the meat of it before we discuss any more. But it certainly appears from looking at the information that there were violations. I've read through the respondents' both chronology and response. They obviously had some technical errors. I think they're admitting to some of the violations, so maybe that might be a good place to start, Member Schmidt. The ones that they are acknowledging, and we can branch out from there if we like.
Agreed. Yeah, it does look like at least we have agreed violations, and you'll probably hear more about that from the parties. I'm not quite sure if we will end up wanting to do anything other than group things, and maybe group them per provision and decide which of the provisions that are alleged or which of the provisions we think apply are violated here. I will note 2 things that I did not mention earlier. One is that, we did hear from the complainant, and who did note that among the 103, there's, I believe, 1 or 2, possibly 3 allegations regarding documents as opposed to open meetings, although the document claims are intertwined with the meeting's allegations. And so on my list, I see 21B and 29 too. So those may be part of what we're going to be looking at here. The second thing I wanted to note is that the complainant did include a lot of discussion about quorum issues. And since, Chair Hyland, his committee, my committee, we looked at these things, I thought I would just say that I don't think that the quorum questions and the quorum discussion is really going to play much of a role here. I tried to get a sense of whether there was some way in which these quorum, the quorum discussion that we got from the complainant would somehow tie into what we're deciding here today, and I don't think it does. You know, someone may think otherwise, but I believe that we generally don't decide quorum questions here. I may be wrong about that, but it also didn't look like we had any kind of sort of interplay between a quorum question and the kind of questions that we'd be looking at here today.
Well,
with
quorum is based upon the Brown Act. It's described in the Brown Act, so it definitely is. And quorum is in the Sunshine Ordinance, so I believe it is within our jurisdiction.
To decide whether there was a quorum from meetings?
Sure. If a meeting happened and there was not quorum, then the validity of whether the meeting is in question. That's within our jurisdiction, absolutely.
Okay. Then, okay, let me, okay,
we can discuss it later and we can hear.
Yeah, let's see if we think there's anything that the quorum seems to play into. Okay. Yeah, I may be definitely overlooking something, but yeah.
Okay, great. So let's move ahead. We'll start with and I want to say that and I'm sure the petitioner will point it out. I've noted that on page 334, that would be under file number 20143. That there's very lengthy. It goes on for pages. That's not a judgment. I'm just noting fact. It goes on for pages. You know, the number of claims or the number of allegations. So that might be helpful as we move along here. And I would ask for either parties to please, since we're trying to keep our meetings timely, if there's specific pages or areas within the record, please do point them out by the page numbers printed on the PDF itself. If there is no printed page number, please refer to the PDF number. So it'd be like 6 out of 132 kind of thing that's in your PDF reader. Okay, we're going to start with the petitioner. We'll have 5 minutes to make a presentation. I'll hand it over to Ms. Leger.
Mr. Heller, are you ready?
I'm ready.
Okay.
Thank you, Ms. Leger. I don't need, I'm sorry?
Go ahead.
Okay, thank you. I don't need a warning. I'm timing myself. Ladies and gentlemen of the task force, I ask for your indulgence to raise and to not raise. Hello? I'm hearing a lot of background noise. Can I start over,
we can
please?
hear you. We can hear you. You can start over.
Okay, thank you. All right, so I'm starting over. Ladies and gentlemen of the task force, I ask for your indulgence to raise an issue not raised in either of the complaints. With respect to the July 15th, 2020 meeting, we said that there were 11 members of the commission present, and left it at that as far as whether it was a meeting. After further research, starting with the third complaint, we picked up the idea, we understood, we studied the law, and really, the governing law for the commission does not allow holdover service. And when you take out those holdover members, there were only 3 commissioners present at the July 15th, 2020 meeting. So if this task force adheres to its precedent, which is that SF Charter Section 4.104B applies to the commission, and that the word member in 4.104B means position, office, vacancy, or seat, then there would be 17 members of the commission, and there would be 9 of them would have to be present at a meeting in order for a meeting to occur under the open records laws. Obviously, there weren't 9. So I'm asking you to raise to deal with this issue now, because if you just reach through to the merits, and then we get on to my third complaint where we take the correct statute, the correct point of view, and then you rule as I just described, well, then we will have wasted all of our time today together reaching the merits issues when this task force had no jurisdiction. And just to clarify, we do not capitulate. We do not forfeit our complaint. We actually want to challenge you and argue you off of your precedent. 4.104B does not apply to the commission. We think we have an unbeatable argument to that effect. It's included in the record. And even if it did, the word member therein does not mean position, office, vacancy, or seat. Okay, so moving on, we promised you legal authority to support the proposition that the words in the statute have their plain and common sense meanings, and that should be used in interpreting the statute. The authority is Jackson versus LegalMatch.com, Volume 42 of California Appellate Reports, 5th Series, pages 760 and 771, decided in 2019, opinion authored by Justice Brown, and I quote, "We must rely on a statute's plain and common sense meaning, unless the statute specifically defines the words to give them a special meaning, ... end quote, citation omitted, square brackets added, quotation marks omitted." We also cited a number of sections of California codes for other boards and commissions to show you what governing laws are like as far as holdover service. Some of them allow holdover service, some of them prohibit it. We didn't cite any that make it optional, which is what the commission thinks applies to them. When it's optional, there needs to be explicit language in the governing law that says that holdover service is optional at the discretion of the member. And some examples we give are Title 52 of the United States Code, Section 30106, Subdivision A2, capital B, and Title 39 of the United States Code, Section 202, Subdivision B1. And with my remaining time, I'd like to clear up a couple of errors in the documents that we submitted, appearing in both files. We said P429, the supplement to 2.100 and 2.143 at page P430, the paragraph just before the logic table. It says if Charter Section 4.10, that should be 4.104B, applies, and the word member in it means position, office, vacancy, or seat. Or if Charter Section 4.10B does not apply at all. Okay, that last, I got you, Jill. That last clause should be deleted. I apologize very badly. I mean, you know, there's a reason why that's there, and it's a mistake. And also on the 2 pages forward from that, this part about quorum, just delete that whole thing. What matters is a majority of the members present. The word quorum is occasionally used in the open records laws, but I think that's what it means. Back to you, Madam Clerk.
Okay, are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Hearing none, respondent, Mr. Greer, you have 5 minutes. Wait for Mr. Leger.
Okay.
Mr. Greer, are you ready?
I am, if you can hear me.
Yes, we can. Go ahead, sir.
Okay, in the interest of time, I'll try to just dive right in. Mr. Hillier is trying to call into question the general calculation of quorum by invalidating holdover. First of all, it's been advised to me through City Attorney, the Behavioral Health Commission is not a charter commission. Is therefore not subject to holdover limits under Charter Section 4.101.5. The Behavioral Health Commission stay until their seats are reappointed. I have been vigorously working with the supervisors and the Board of Supervisors and their Rules Committee in order to fill the rest of our seats. Moving forward to some of the other items, specifically classified under 20100, because up until now it was considered two separate. 67.7A, failing to post 72 hours. Agenda, this is not true, as evidenced by the attachments in Mr. Hillier's own presentation. This was timely posted. Posting time can only be validated by the DPH IT services team. Number 67.7B, failing to post documents on the website and make available to the public. This is not true also. As you can clearly see, the document can be viewed by anybody going to the DPH website. 67.7D, failure to take action on any item not on the agenda. If you look into this particular item, action was taken on July 15, 2020 under items 1.2C and 1.2D. Action was taken as evidenced in the minutes. 67.7G, failing to allow public comment. 5 public comment sections are clearly posted on the agenda. In the agenda, an opportunity was given for public to fully respond. 67.9, failure to post relevant documents on the internet. This is not true, as all relevant documents are timely posted with the support of the DPH IT team and services. As we go, somebody's talking in the background. As we move on to the other section, 20143. In a brief mention, primarily the issue is the Behavioral Health Executive Committee meeting. This is what most of these complaints are, 67.7A and all the way through D. It is my contention that meeting never occurred. I went all the way back. I exhumed documents from the DPH IT filing. The actual person who received and does the filing on that particular date that would have been present for the July 6th meeting contends and in writing that there was no document submitted to pre-posted either minutes or agenda for a meeting that was theoretically to occur on July 6th. Now, I must say that during June, July, and August was a transitory team for most city entities. It certainly was for the Behavioral Health Commission, as we were transferring from live meeting to teleconferencing to Zoom. All evidence from my position, as I assumed my post on February 8th, 2021, every research piece that I've looked into, there is no evidence that a meeting occurred on July 6th, 2020. So thereby invalidating many of Mr. Hillier's claims on that regard. As you can see, most of these do overlap and they fall upon each other. I would like to take the time to address each and every one, but in the interest of time, I think I will stop right now.
Okay, thank you. Are there any persons or witnesses providing facts or evidence on behalf of the respondent?
I do have a written testimony from an individual that couldn't make it today. I'd like to read what she had to say, if that's okay.
Are they an appointed commissioner?
They are an appointed commissioner.
Okay. If there's no objection from any of the task force members, I'll allow it.
May I make a suggestion, Chair Wolf?
Yes.
Yes, that we also asked Mr. Greer to submit that statement by email if he can.
Okay, thank you.
Oh, do you want me to submit it by email?
If it's a written public comment, sir, it will be posted in full on minutes.
Oh yeah, I can submit it I can submit it. It's written.
Okay. Let's
I can
do
also
that.
read it. It's just it's less than a paragraph.
Again, it's my suggestion that it be read into the record in this particular section of witness and any other interested persons. That commissioner will become a party, but the commissioner is already party because the complaint is against the commission anyway. So
Exactly.
members are without. If there's any objection, please speak up. If there isn't, then I'll allow it. Okay, I'm going to allow it. You may proceed, Mr. Greer. Again, 5 minutes. Wait for Mr. Leger.
Mr. Greer, are you ready?
I'm ready.
Go ahead, sir.
Okay. This email is from Carletta Jackson Lane, co-chair of the Behavioral Health Commission. To whom it may concern, I will unfortunately be out of town at the biannual conference of the NCBW 100 San Francisco chapter in Black Women's chapter in Orlando, Florida, from the 6th of October through the 10th of October. I would like to provide my testimony in support of the Executive Director, Jeffrey Greer, of the San Francisco Behavioral Health Commission. The San Francisco Behavioral Health Commission has followed the appropriate posting procedures, agenda, and supporting previous minutes, and attachments such as resolutions and department reports for SFDPH and MHSA, Mental Health Service Act. The San Francisco DPH IT Department, Technical Systems Support Team, is the official process for the commission and board meetings with a 72-hour posting window to the public. If you have any other further questions, please contact me directly, and I can send you her email and phone number. She was very reticent of having Mr. Hillier have access to that. And that's all that was said. She was just verifying the fact that at the end of the day, if you're going to verify whether a posting was timely, whether an agenda actually took place, a meeting actually took place, or anything of that nature, that the IT team would be the final date stamp on that. And that's it. That's all.
Okay, thank you. All right, members, question and answer, clarification period. It's the items with you. All right, I'll start the ball rolling. Mr. Greer, can you explain how the Behavioral Health Commission is not required to be compliant with Section 4101 and in et sequitur and the applicable additional provisions of the charter?
Are you meaning of the charter? I cannot explain it because it was a legal document. It was forwarded to me by the city attorney that the Behavioral Health Commission does not fall under the restrictions of a charter. It's not considered a charter organization. I can forward it to you later. I can access it. I don't have it with me.
But Mr. Greer, we're here now. This is the hearing. This is where we need to know what that is. Otherwise, it makes it difficult for the task force to make a determination as to whether it's exempt or not.
Well, under the code, wouldn't the task force know? Doesn't the task force know that code?
I'm sorry?
Code that I read. Are you familiar with the code that was read?
The code, yes, I am.
SC code 4.1.101.5. This is what I was given by my attorney. That is all I have.
Yeah, well, but you made a claim that the Behavioral Health Commission, that 4101.5 is not applicable, but you're basically saying that if it's not applicable, then you're saying that the commission is not applicable under Section 4.101. 4.101.5 applies to 4.101.
No, I'm saying section 4.101.5 dot is stating that the Behavioral Health Commission is not a charter commission. And since it's not a charter commission, it's not subject to holdover limits. That's my understanding. I'm not an attorney. I do not know the specifics. That's what I was given.
Okay, so let's be clear on the exact letter of the law here. Let's start with section 4.101.5. It's titled Holdover Service by Board and Commission Members. A, the application of this section. Unless otherwise provided in this charter or required by law, the requirements of this section shall apply to members of each appointive board, commission, or other unit of government of the executive branch of the city and county, or otherwise created in the charter, period. So there's two conditions. So either it was created, let's say, by the mayor, or by an ordinance of some sort, and that it's part of the executive branch, or it's a charter commission. That's irrefutable, and there's no implication here.
Okay, and as from what I was given when posing the question to the legal entities that we're working with, which is the city attorney, they stated clearly that the Behavioral Health Commission is not a charter commission. Do I know whether or not it was appointed by the mayor, or whether I can't answer that question. I do know that they have stated clearly that the Behavioral Health Commission is not a charter commission. I can forward it to you if you'd like.
Well, but the point is that should have been part of your, defense, your response, for us to be able to see that today. I'm not going to continue this item. So okay. we're going to make decisions based upon the evidence that's brought today. If you can't cite a section of laws required by the ordinance to declare some sort of exemption, then you're leaving us not much choice as to how we make our final decision.
Okay, I was unaware that you needed supporting documentation for this item, but and that and if I was supposed to have that, then I should have had it, but I didn't. I did not know. I thought that all I had to do was let you know what the charter was, let you know what the section was, the code number, and that was it. I didn't know you wanted to have the entire thing written out.
Well, it's just you made a specific claim, and that claim is not specified in the charter section you cited. If you're going to claim that the Behavioral Health Commission is not, section 4.101.5 is not applicable to the Behavioral Health Commission because it's not a charter commission, then you have to tell us where in the charter or somewhere else that it says that the Behavioral Health Commission is not a charter commission. Okay,
I can't tell you. I can't tell you any.
I'm sorry?
May I interject?
Yes.
As the Rules Committee clerk, I can tell you that the Behavioral Health Commission is based on state code. I can give you that in just a moment. It's based on California Welfare Institute Code 56004, and it was instituted by Admin Code 15.12. So basically, it's a state mandated item that was adopted by the city.
All right, please. Can you repeat that, please?
California, it's the California Welfare Institute Code 5604 is the enabling legislation, and the city, through Administrative Code 15.12, created the Behavioral Health Commission.
Okay.
But it was based upon state code. And I am looking for that right now. If you,
I have. So the commission is created on. It's at the beginning of Chapter 15, the Mental Health Service, and Section 1512, right? Behavioral Health Commission.
yes.
So the Health Commission is established by Mental Health Board pursuant to requirements of California Welfare Institutions Code 5604 sequitur, to be known as Behavioral Health Commission. Commission consists of 17 members. Each member of the Board of Supervisors shall appoint a member of the commission. The Board of Supervisors shall appoint the remaining 6, one of whom should be a member of the Board of Supervisors. Okay, as far as 1512 is concerned, it sounds like it is an appointive commission. Now, because of the way it was established, the question is whether it's a state body or whether it is a requirement of state law that a local agency have one. Okay, and the determination is whether this is a local agency commission or whether it's a state commission. And I'm not hearing that. Any other task force members? Any other questions or comments? I'm going to look through this a little bit.
I mean, even though we are bound by state regulations and follow them to.
Well, so are we. So are we. We're bound by the Brown Act and the California Public Records Act. I mean, lots of state laws bind local agencies. So, and all our, our local departments and agencies are bound by lots of state laws. So, the question becomes the creation of the commission as to whether it is exempt from the city charter. That would be somewhat unusual that would be the case. Members, burning time here. Go ahead, Vice Chair Yankee.
Thanks. For trying to decide if this is a part of the executive branch, I'm not sure it is. I'm looking at Admin Code Section 15.11, subsection A, and it talks about the Chief Executive Officer. And it says the Director shall serve as Chief Executive Officer of the Community Mental Health Service and shall be responsible to the Board of Supervisors. And there's some other references throughout that code about the Board of Supervisors. And so I'm wondering if this is actually not an executive branch, so to speak. That then still calls into the question about whether or not it's a charter commission. I'm not sure if 1511 or ever the admin code in general would make it a charter commission.
Can you repeat that section again?
Yes, on admin code 15.11.
Oh, .11. Okay.
Yeah. And I don't see a mention of the mayor in that section. He seems to be responsible to the board of supervisors. So I'm just wondering if that means this isn't actually, almost a part of the legislative body rather than the executive branch.
Which is, we have our own contention with that.
Yeah.
Mr. Chair, may I rebut and maybe help you guys out a little bit? I know a lot about this.
So go ahead, Mr. Hillier. I'll hear you out. Go ahead.
Okay. Thank you, Chairman Wolf. We never claimed that 4.101.5 applied to the commission. And even if it did, it only allows holdover service for 6 months. We have people on the board who've been there for 3 years. They're ready to start over on they're ready to start over on a brand new appointment after the 3-year gap because they've been holding over for that long. And I don't think it does apply. This organization was created on April 10th of 1958 through Ordinance number 193-58, Section 3 of which creates it. And that is now in Section 15.12 of the Admin Code. It was created by the Board of Supervisors. It's not part of the executive branch, doesn't advise the mayor. There are no appointees of the mayor. It advises the Board of Supervisors and various other people, some of whom are in the executive branch, but that's about the only connection to it. It is governed entirely by its by governing laws 5604. I'm sorry. If I could give you a reference, P 431 in file number 20143. The last paragraph of the page, it cites California Welfare and Institutions Code Section 5604C, and it relevantly states that the term of each member of the of the board shall be for 3 years. ... End quote. That's really the only relevant code here. The charter does not apply. This was not created in the charter. The board was not created by the voters. Everything in the charter was created. Was passed by the voters at some point in a ballot in San Francisco, and the Behavioral Health Commission has no part in it.
Okay.
Back to you, Matt.
Appreciate that. Thank you. That I think that clarifies things for me quite a bit. Okay. So okay, that's fine. Any other? Okay. So I have. I'm not sure who was first. Let's go with Member LaHood first.
Yes, thank you. I was just looking at the Sunshine Ordinance, and I want to point out in section 67.3, if we go down to D7, any advisory board, commission, committee, or council created by a federal, state, or local grant whose members are appointed by city officials, employees, or agents. So I think that covers us here.
Yeah. Okay. I'm sorry. That was D3? Yes. Okay.
67.3C. No, excuse me, D7.
Oh,
67.3 D7. Yeah.
Well, okay, let's look at that a little closely. I mean, it says any advisory board, commission, committee, or council created by a federal, state, or local grant. Whose members are appointed by city officials, employees, or agents. I'm not quite sure what that word grant means. Let's DCA Castillo, are you still here?
Yes, I'm here.
Okay, I'm wondering if you can maybe explain the intent of that word grant in 67.3D7.
The computerized message. Go ahead.
67.3D7.
I'm sorry, can you start with the beginning? What was your question? I didn't catch any
The
of
question
it.
is the word grant. What is the implication of that word? What does that mean in this respect?
I have no idea. I would have to look into that further.
Okay.
Yeah. And I'm not addressing the substantive issue, but one point that the speaker for the commission raised, I just want to say that any written privilege communication, he can't disclose that without a waiver from the body that holds the privilege. So he doesn't hold that privilege. And so I heard him offer to send it to you or to the commission, but he would have to check with his with the body, which I think is the commission that holds the privilege, but he can't waive that on his own.
Yeah.
Duly noted. Duly noted.
Yeah. So I'm not addressing the substantive issue since there's an ethical law. But
hold on. I hear you, but I'll tell you this, that the task force has for almost 20 years now disagreed with that interpretation, because the ordinance specifies that those communications are not to be that way, despite St. Croix versus Grossman, which we feel that there are anomalies in there. So I hear what you're saying, and I know that that is kind of the precedent that has been, kind of unchallenged at this point, but it is it's something that the task force has held for a long time as not correct. But granted as it is, there's not much that we can do about that.
Right.
But
all I can do is give you advice.
I hear you. I appreciate the advice.
Yeah.
And I hear you.
No, I just wanted to remind the speaker. So be it.
Yeah, I understand that. It's somewhat inappropriate for you to do that because you work for us, and there is
actually, I would like to address that one point. I can't speak to the substantive issues that he is talking about and the advice that he's been given, but to the extent that we are talking about privileged communication between the city attorney and the client, I'm just reminding the speaker that the privilege is held by the person who received that communication. So that's all I was doing.
Okay, I just, we're sensitive to the ethical firewall. That's all.
So am I.
And so when advice is being made by our legal counsel to a party, even if it's a reminder of what they're supposed to or not supposed to do, it does trigger something for us.
Sure. I was just, well, then we can turn it around. I guess it's to remind the commission that to ask for a privileged communication, that it is a communication that is privileged because it is one between attorney and client. So, and I wasn't addressing the substantive issues that he was addressing and the specific advice that he was given within that communication. So I understand.
Okay. Appreciate it. Thank you.
Sure.
Okay. Member Schmidt.
Yeah. First, I'd like to just be very clear that the statements that are made by the chair in the form of the royal we, as in the task force says, believes this, that doesn't speak for me. I completely disagree with many of the assertions made by the chair about the nature of the attorney-client relationship here and the privilege. And I would disagree if it came to a vote on something about those. I think he's incorrect about several of the things he said about this. And so when the chair says that it's the task force's position, I have no idea where he gets that from. I it's certainly, it's not ever been something I've ever had a vote upon. And I think that St. Croix is good law. In fact, it's my understanding that a published Court of Appeal case that's never been, it's never been disagreed with, or it's never been overruled by the Supreme Court. That's sort of the definition of good law. So I want to say I want to make it very clear that those positions on the attorney-client's, on the city attorney's role here are not the positions that I would agree with.
Okay, so let me be clear. Let me be clear. I said it has been held by this task force, going back to its inception, that it is held a certain. It has held a certain position. Now, we have not had up until that, we have not had an action to make a determination otherwise. We've had lots of discussion as to whether something is it's appropriate for attorney-client privilege or not. But the task force has held in many, many meetings, going back to its inception, that it disagrees with that. Okay, and the details around, I think it's worthwhile to have a meeting around that, because there's some details in St. Croix that are not necessarily applicable to how the ordinance holds that particular statement. So St. Croix was about Mr. St. Croix. It wasn't about the Ethics Commission. That's one of the distinctions that constantly comes up, and that was argued by Mr. Grossman, and may he rest in peace. So I just want to say that, yes, I agree. I'm not necessarily speaking for you or anyone here. I specifically said that the task force has held in past tense, and I'll make the additional clarification that since its inception, that this to be true until something changes. Okay, so that and I'll leave it at that.
I agree to disagree.
Okay, very good.
Thank you. I actually had.
Oh, you had something else. Go ahead.
I had my hand up because I wanted to ask a question of the complainant.
Sure. Go ahead.
Okay.
You have the floor.
Mr. Hilliard, this discussion about the nature of the commission and the status of holdovers, could you explain if you think that affects the validity of your 103 claims of violations, and how would it affect? And I'd say 103 plus the 7 in the other case. How is it relevant?
Thank you, Member Schmidt. It's relevant. I tried to describe that in my opening argument. If you exclude people who are serving on holdovers, you have a very small number of commissioners. At the July 15th, 2020 meeting, just as an example, there were only 3 commissioners there who had current appointments, and there were only 4 overall. So if this commission holds that Charter Section 4.104B applies, I'm sorry, if this task force holds that Charter Section 4.104B applies to the commission, and the word member therein means position, office, vacancy, or seat, then there are 17 seats on the commission. So there are 17 members, and a majority of 17 members is 9 members. And if you don't have 9 members at a...
But you're saying that there's a violation no matter what, regardless of how many people were there, correct? That they violated various provisions. I'm just not seeing how it has any impact on the validity of your claims. I don't see that. In other words, I don't see that I need to even look into those issues to find violations here. But can you tell me what it is that you think how it's relevant to these specific types of violations that you're alleging?
I think he was having some problems with his microphone.
Member Highland here. We're at 50 minutes and counting already on this issue. It looks like the quorum is one part of it. The other meeting violations are a second part, and then maybe documents might be a third part. So maybe we can move on to maybe other thirds and try and get some discussion on that. I'm not sure we're at a point to decide on the quorum issue right here. Just thought I'd throw that in there.
Withdraw my question. Thank you, member.
Member Highland, did you have something else that you wanted to address?
No, that's it for now.
Okay. Mr. Hillier, are you still there? Mr. Hillier?
Can you hear me? I just got back on the line. I got hung up. I don't know how much of my answer you got.
We didn't get any of it.
Oh, I'm so sorry. Can I begin again?
Yes, go ahead.
Okay, thank you.
For purposes of time, I'm going to withdraw the question. My question was withdrawn.
Okay.
Yeah, I don't need an answer.
Okay, I'm sorry, Mr. Hillier.
That's all right.
Okay, so I'm not clear as to whether the what they are calling the mental health service is a local agency or not. Without seeing whatever advice the city attorney put out or provided to the commission, the commission is not using that advice to me with enough substance to be able to determine. It's not so much quorum, but is with regards to membership in order to be able to count quorum and whether meetings were happening or not. With regards to the 72-hour postings, the 72-hour postings, it's not really. I'm not quite convinced that it's based upon the timestamp of Department of Technology, and because the question is who exactly is making the postings? Is it Department of Technology? So let me ask Mr. Greer, who's making the postings when the agenda are created?
Who is physically posting it?
Yeah.
Physically posting the DPH IT department.
Okay, and are they posted anywhere else?
Yes, they're posted at the public library.
And are they posted at the clerk's office?
At the clerk's office? No.
They're not posted at the clerk's office. Okay.
No, they're required to be filed with the on the website that is posted on the Department of Public Health website, and for public access, the public library. So anybody that does not have access to the DPH website or does not have a computer or anything like that, they can easily access the agenda and the minutes at the public library.
Okay, thank you. Any other questions or clarifications? All right, should we move to rebuttals?
Actually, sorry, I couldn't figure out how to raise my hand for the moment. This is Member Stein.
Okay.
I did want to ask.
You can just speak. You can just speak up. It's fine.
Yeah,
You know.
sorry. I did in the end. So I just wanted to ask another point of clarification from the representative for the respondent, which is that I understand why you're saying that you feel you met the requirements for trying to post, more than 72 hours in advance. But I also recalled in this packet that that the Behavioral Health Commission does accept that they didn't really describe agenda items very well.
No, I don't think that's true. Not that part. Description of items in the agenda have been, well, I'll let you go ahead. I'm sorry. I didn't mean to interrupt. I'm sorry.
Yeah, I don't think I wrote the page numbers that I saw that at, but I know that was in the packet, that there was a acknowledgement that some of the agenda items were vague, and that since these postings, people have undergone training and they understand that the agenda items need to be more descriptive. I would have to go through all my highlighting to find exactly what page that was on. But so you're saying you didn't say that?
Could I clarify?
Yes.
Okay. During that time period, and I think it was probably one of the first hearings, and it was probably my first, I was trying to be genuine and forthright into what I realistically thought happened. I had no definitive idea. I was not present. As I said, I'm trying to piece together a lot of history that I don't really have. Since we had that conversation, I've had an opportunity to go through some of the historic agendas that have been posted. And quite frankly, items that are clearly posted in the agenda seem to follow the description of seem to follow what was being discussed. There is no one else, absolutely no one else, that has raised any kind of complaint, question, or thought about the description being on the agenda that does not match the discussion or it being unclear. There's only one individual that has raised this point.
Okay, and then I also had in my notes that there was an acknowledgement that some supplementary documents were not posted online for one of the meetings, at least. Acknowledgement of failure to include notices of rights under the Sunshine Ordinance, and failing to post all of the relevant documents because of that supplementary document on the internet. Are you also saying that you don't agree with that acknowledgement?
No, I will agree that there are, and I can't recall which item, but I know it was during that transition period between loss of staff. I know there was a question of whether or not there was a grant or support. The entire Behavioral Health Commission is being supported by staff, a third entity, that for all this period of time, when new legislation came into place, which was activated at the beginning of the year, the Behavioral Health Commission and DPH will be taking over the staffing. However, they've been trying to come up to speed. But the point is that they're more than likely, and I cannot tell you, I mean, once again, I'm trying to be transparent. We're trying to get through this, that of all the filings that were done during the entire transitory period from face-to-face to telephonic to Zoom, and as you evidenced with Mr. Hilliard having technical difficulties, there is a possibility that the 4 sheets that include the document for disabilities, English, language differences, and that those addendums that go along with the original agenda that is being posted could have been left off. I can't tell you which one. I know it's very minimal. I know that it seemed to be rectified around the period of June, maybe June, July, around that area. So I cannot say no, that never happened.
Okay. Yeah, so I'm just looking. Yeah, I guess I was looking at P311 in the item number 7 for the agenda, where you just say that, where did it just go? At the time that things were posted, you thought it was sufficient, but now having done training, you understand it needs to be what needs to be there to best inform the public of meeting content.
Absolutely. I mean, I'm not going to justify. All I can tell you is that if you go through a year or two, like we all went through, and you have 4 or 5 different hands on a document that is timely, time sensitive, and requires, certain items to be attached, it's not impossible that something was left off during one of those periods of time. Like I said, I can't go back and identify which one. I concede it's highly likely that there was some addendum that is generally attached to all agendas that go out, not just the Behavioral Health Commission, may have been left off.
Yeah. On 311, I guess one attachment on the July 15th meeting that was left off.
Yeah, it may have been July 15th. I'll go in there while we're talking and try to look at it, because it's right there in his the complainant's for lack of a better word, pile. And then again, I don't know, is this under 2001? Which one is this under?
This is under the item number 7. So 20100.
20100, okay.
Yeah, I just wondered if you changed that acknowledgement, but you say you can't refute it, basically, and it does seem like you acknowledge it on those pages.
I cannot, there's the legal law and then there's the spirit. And I mean, in my own spirit, I cannot say that did not happen. It's just, I mean, the amount of filings that we do are massive, and it just, during that training period, somebody might have left it off. They got the agenda up, but they left off the other stuff. So, yes, if you're looking for a yes or no, yes.
Okay, yeah, I just wanted to see if you still agreed with that. Okay, all right, thank you very much.
Mm-hmm.
Member Schmidt, still have anything to add? Your hand is.
Sorry, my mistake. I never lowered the hand signal. There you go.
Got it. Okay. Any other questions or clarifications from either party's members? If not, let's move to rebuttals. Mr. Greer, each party will have 3 minutes. The respondent goes first. Mr. Greer, you're first. Wait for Ms. Leger with the clock.
Mr. Greer, are you ready?
Yes, I am.
Go ahead, sir.
Well, I appreciate the opportunity to present, and this has been a very, 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 very well-deserved learning process coming before the task force. I would urge and hope that in the future, as you get another bevy of complaints, that you see fit to consolidate those as well. We as a commission move forward and strive to do the best that we can to serve the community. We provide a vehicle for the public commentary. We are the gatekeeper for the public to provide advice to the Department of Public Health as well as the Behavioral Health Services. We are that one voice, that one public entity that allows this direct communication. We would like to continue and get back to the job that we're committed to perform and adhere to all guidelines suggested by the Sunshine Task Force, the Brown Act, or anybody else. That is our purpose, and that is our building. That is what we're building towards. I don't have a whole lot more to say. I mean, a lot of it is there. It's in writing. You kind of understand it. You understand what's going on between the two parties. And I think that we fully understand the weight and why there is a Sunshine Task Force, why there is a hearing like this. So as we move forward, we hope that we will be on. We hope that we'll be able to move forward and have a stronger footing, so to speak. And that's it. I don't have too much more to say than that.
Okay, thank you. And Petitioner Mr. Hillier, you have 3 minutes. Wait for Ms. Leger.
Mr. Hillier, are you ready?
I'm ready, Ms. Leger.
Go ahead, sir.
Thank you, Ms. Leger. We think that the commission should be stopped from asserting any defenses to the counts that were previously in 20100. I'm hearing a lot of background noise, a lot of clinking and clanking. Could you please put yourself on mute? Thank you. I'm still hearing it.
Yeah, please. Okay, please stop for a moment. Could everybody who is not, except for Mr. Hillier, please put themselves on mute, press *6. I'll wait. I won't restart the meeting until folks do that who are on the phone. *6, please.
Chair Wolf,
Okay.
I will go ahead and mute everybody. And you can unmute, our speaker can unmute himself once I mute everyone. I cannot tell the difference.
Go ahead. Okay, Mr. Hillier, *6. There you go. Oh, no. There you go.
Okay. I never got the message that I was muted. So when I pressed *6, I muted myself. Then it said I've been unmuted.
You're good. You're good. Okay. Continue.
All right. As was discussed when 20100 was heard in committee, the commission has basically admitted to all of the claims. And I would point out that there are actually 8 claims associated with 20100, and the 8th one got left off the end of the page. Only the first page was included, and it was the sole thing on the second page. So I think that 72 hours advance warning should mean that it needs to be on the website for 72 hours before the meeting. Otherwise, what you're going to have is they're going to hold meetings on Tuesday, and they're going to send the notice to the IT department over the weekend, satisfying the 72-hour requirement, and the IT department's not going to post it until Monday. And so you'll get 26 hours of notice or something like that. So I really don't think that's a good enough solution. I think 72 hours means you need to work out with the IT department what you need to do in order to make sure that it's before the public for 72 hours. And that's all. Back to you, Mr. Chair.
Okay, thank you. Okay, members, the complaint is with us now to deliberate and come to an action and conclusion. Now we speak about the merits. Okay, if no one's going to speak up, Member Stein?
Yeah, I'll just say, I'm inclined to find violation on 67.7A, not because the agenda wasn't up 72 hours in advance, because I think a reasonable effort was made to get the agenda up in advance, but because of IT and the pandemic, it didn't, it was 56 hours in advance instead of 72. But I do think there is an acknowledgement that, and I saw that a lot of the agenda items would be hard to follow them if you were a member of the public and understand what was going to be discussed in them. And then 67.7B, there's already an acknowledgement that, an attachment, at least one attachment we know of didn't get posted online or on the internet. And then there's also an acknowledgement of 67.7G, failure to notice the rights under the Sunshine Ordinance. I realize all this happened in a transitional phase, and it sounds like the BHC did not have strong leadership helping to have continuity or much understanding of newer members, but it still ends up violating the Sunshine Ordinance. So that's my perspective.
Okay, thank you. Anybody else? So I want to start with this. I mean, the question is what is this body? Does this body fall under the jurisdiction of the Sunshine Ordinance? The contention and the response.
Point of order. I
Yes.
thought I heard a motion being made. Did I not hear that?
No, it wasn't a motion. I'm saying where I was standing.
Okay, thank you.
Hearing the response from the respondent with regards to the status of this body based upon the advice that they received and within their testimony, that the Behavioral Health Commission is not a charter commission, nor does it fall under the rules that would apply to appointive boards and commissions. And in the same token, with regards to, as Member LaHood brought up, 67.3D as a policy body. Actually, if you read, I think it's important that we determine whether this body is in fact a local agency body and what it actually does fall under. People do make mistakes. Maybe they don't, they miss something. I think if you look at, you have to go to the Welfare Institutions Code, but it's 5602 that actually, where the state law provides the authority for the creation of it. And I think it's pretty clear in this section as to what really the status of the commission is. And it states just really one sentence. It says the Board of Supervisors of every county or the boards of supervisors of counties acting under the joint powers provision of Article 1 shall establish a community mental health service to cover the entire area of the county or counties. It is authorizing the county to create it for the county. That, to me, is very clear that it is not a state body, and it's not created by the electors. It's created by the Board of Supervisors in and of itself to in fact create it at a local level. So then if we go back to 67.3D, you would look at number 3, which says any board, commission, committee, or other body created by ordinance or resolution of the Board of Supervisors. To me, that speaks fairly clear. Okay, if I'm inclined to to hear maybe what our legal counsel might have to say about that. But what about everybody else? Member Stein.
Yeah, I just want to mention one other thing when I was looking at, this body and how it was created. That if you go to the mental health board of San Francisco, it talks about the state of California passing a, it's part of mental health board, right?
It's section.
Chair Wolf, I can answer that. It was previously known as the Mental Health Board, but recently there was an ordinance changing it to Behavioral Health Commission.
For a second, thank you. Yes, that's correct. So for a second, I got like, okay, wait. But in their own history page, they say that in 1957, the state of California passed this act to give counties the responsibility for providing treatment and care to the mentally ill through community-based and community-operated mental health systems. And the legislature at that time mandated the establishment of a mental health board in each county. But it goes on to say, San Francisco, however, had already established its own MHB a year earlier than that. And when the state legislation came along, it incorporated that language into its city ordinance regarding the board. So again, to me, that sort of reinforces that it's a city group.
Or actually county, because they're...
Well, right, county, yes.
Yeah.
And that's on the history page of the Mental Health Board of San Francisco.
Okay. Anybody else? Yeah, Vice Chair Yankee.
Yeah, I'm in agreement. I do definitely think this is something that would be under our jurisdiction, that it was created. I guess I continue to have a question. I don't know how much it ultimately affects this case, but I still do have some questions about the quorum issue on this. I tend to think that it does not fall under 4.101 because I don't think it is a charter commission. It seems to be an ordinance that was enacted kind of in compliance with state law, and I don't see it being a branch of the executive office, although it's worth noting that in Welfare and Institutions Code 5604, subsection C, it does talk about the term of each member of the board shall be for 3 years. And it says the governing body shall equitably stagger the appointments so that approximately 1/3 of the appointments expire in each year. And so I guess the question I would have, and perhaps this is something our legal counsel could weigh in on, is how does that state law that kind of interacts with the terms of something created by a local ordinance, does that set it in like a hard cap at 3 years, like 3 years and 1 day? Is this term expired? Is there any type of holdover provision in the city and county law that interacts with that? Because I do think state law clearly speaks to the term of these appointments, and if some of them are extending way beyond 3 years, I don't know if that would be an acceptable continuation of the term, even though it may not fall under the specific city code that talks about holdovers. So maybe legal counsel, could you speak on that a little bit?
DCA Castillo, are you still there? You may have to press *6. We can't hear you. DCA Castillo, are you still there?
Hi. Okay. Sorry. Press *6 like 3 times.
Good.
Sorry. No, what I was going to say is, I would need to look at the San Francisco ordinance and the local ordinances to see how the state Welfare and Institute Code 5604 works with the local court. So it's something that, we can get back to you on, but I couldn't give you an interpretation on the spot right now.
Okay.
And what about 5602?
Same. Yeah.
Okay.
Chair
I
Wolf,
Yeah, I
would-
didn't know if that was an issue. That yeah. Anyway, we'll look at it and see.
I guess my concern would be that if some of these appointments are no longer valid, then the body might not have a quorum to begin with. If it doesn't have a quorum to begin with, all these things about what happened in certain meetings or didn't happen is kind of a moot point because those meetings should never have occurred. You know, if it doesn't have quorum, then they shouldn't be holding any meetings. So that's kind of where I'm at. I'm not sure we can move ahead and talk about, well, did this meeting have an agenda posting or this meeting not, if we don't even know if the meeting should have occurred in the first place. That's where I'm at on this one.
Chair Wolf, this is Victor Young.
Sure.
Yes, in general, as in my role as the Rules Committee clerk, in terms of holdovers are indefinite until they are replaced by another person, and there is no limit on a holdover unless it's one of the charter committees.
Correct. I was just going to say that because we fall under that same rubric.
Except the difference in this case is that our body, the Sunshine Ordinance, is created purely by city ordinance. There's no state law that says our terms end on such and such a date and even goes as far as to talk about how terms should be staggered. In this case, we have a unique aspect of state law dictating the terms of a county body. So I don't know if that state law setting a 3-year term allows for holdovers because it's not purely a term that's set by city and county law.
I hear what you're saying. I agree with you. It's kind of in lieu of any holdovers, they built in expiration dates and limitations of service, right? Is that what you're saying?
Well, I'm saying that I'm not sure that state law allows for holdovers. It says the term, California Welfare and Institutions Code said the term should be 3 years, right? So it's setting the term, like for our body, right? You know, the Sunshine Ordinance is a purely city ordinance, right? Our terms are set in a city ordinance that was passed by the voters. But the terms for this board are actually set in state law, right? So I don't know, because that term, and it even goes so far as to talk about how terms should be staggered. So I think there's some intent that these terms don't all expire at the same time and that there should be some type of, appointment process that works on a rotating type basis. And so even though that this board is appointed by, and the number of members are determined by a city ordinance or something passed by the board, the fact that state law prescribes a specific end to the term limit, does that mean that if the board doesn't reappoint at the end of that term that the people can continue serving? Or does that state law put a hard cap on it?
Well, I guess the question I have, I'm sorry, I'm speaking out of turn. Member Schmidt, go ahead.
Yeah, to Member Yankee's inquiry, he's wondering about, I'm not responding to the last thing you said, but before that, you were talking about how, well, if they don't have a proper quorum, then how could there have been a meeting, and therefore how could there be violations? Maybe I hope I'm paraphrasing that somewhat fairly. I guess the way I'm thinking about this whole issue about, okay, maybe they didn't have a proper quorum, et cetera, is that if you have a meeting and you don't have a proper quorum, then that invalidates anything that you do in the meeting. But I think that if violations occurred during that meeting, that it's not like you can take away your sunshine violations by saying, oh, but actually we didn't have a quorum, so we didn't commit any other violations. That's my thought on your inquiry, that if they took actions, then and they didn't have quorum, then the actions themselves are invalid. But that's a separate issue from, did they commit Brown Act type violations? So that's just to get to what you were kind of querying about.
Right. I understand what you're saying, and I wasn't saying that there would be no violation. I think there would be a violation. It would be continuing the meeting beyond. I think when there's not quorum, you can only do what roll call, and an adjournment, right? You can't take actions, right? So I think there would definitely be potential violations, but they would be that the meeting continued beyond the roll call where they found, and then they didn't adjourn, right? So I'm not sure that the violations we're looking at are the right violations. I think the violations would be that they conducted a meeting without quorum. There definitely could potentially be a violation if they went, but just wouldn't be, like, for instance, I saw some of them were talking about public comment. Well, right, there should never be a discussion item if there is no quorum. So whether or not they allowed public comment or didn't allow public comment, it's kind of a moot point if we decided that at the offset the meeting should have never occurred beyond, a quorum not being established. And that would be the violation I would find, that the quorum wasn't established, assuming that that's true. And I'm not saying that it is. That's why I asked legal counsel.
Although, can you find a provision of what we're dealing with that is violated? I mean, I'm still trying to figure out what in the Brown Act, the Records Act, Sunshine. Where do we see something that says, oh, this is violated when you stop having quorum? And if we can find it, great. I just want to see what that is. I don't know if there is one.
Okay, so Member Highland, did you have your hand up? And Member Stein?
Yes, I did. Member Highland here. I think the way this is going, and based on my past experience, it might be useful to bifurcate this. In other words, have two motions proposed. If we are going to find violations, one on the parts of the charter that we're familiar with and comfortable with, the noticing, the agenda, all that kind of stuff, and then have a separate motion on quorum violations. That way they stand alone. I think that's probably a healthy way to progress. We're at the 1.5 hour mark right now. I would invite someone to start with maybe violations of agenda and documents. Start with that one, and then have a separate motion on the quorum. That would be my advice at this point.
I believe you're muted, Chair Wolf.
Thank you. I'm sorry, Member Stein, do you still have your hand up?
Yeah, I'll just say briefly that, I personally wasn't convinced about not taking public comment, because public comment is mentioned throughout their agendas. And I think there's also many boards that don't specifically mention it with each item, but it's still taken with each item. And so I didn't have convincing evidence that there wasn't space for public comment at the meetings. But I do feel like there's admission on certain points that also seem to clearly have documentation. And most of those things are things that occurred prior to the meeting anyway, which I already kind of went through, such as how the meeting was described and whether things were made public and whether sunshine notice was there. So I still feel like those violations, I'm comfortable with those violations being moved.
Would you like to take a stab?
Okay, I'll take a stab. So
before you do, I just want to notate something, because there's some other sections of the 5604 law that Mr. Hillier brought up that I think that also the respondent had, that this is a 17-member commission. Can Mr. Greer, can you confirm that? That's star 6.
I don't know if they heard. Shit, I don't know if they heard me. Oh, excuse me. Hello? Can you hear me now?
I can hear you now.
Oh, okay. All right. I was saying that. Pardon?
Go ahead. I'm sorry.
I was going to answer that. Yes, at full capacity, the board should be operating with 17-member membership. I think the first 11 seats are supervisory appointees. The next 5 are rules seats, and then we have 1 supervisor seat.
Okay.
And then each one of those seats are broken down by category.
I understand that. I would urge you to read the Welfare Institutions Code 5604 A1.
I've got it in front of me. Got it right here.
It specifies that it should be no more than 15. That's not in our jurisdiction per se, but if you're claiming that there's 17 and then you're counting quorum against 17, that brings up an interesting question.
Right, and I have to
Actually,
look at our bylaws. Our bylaws state 17, and there's another document somewhere that it says 17. This is the first time I've ever seen 15. Thank you for pointing it out.
I think I heard DCA Castillo.
Sorry, Chair Wolf. 5604, that same section A1, the last sentence says this section does not limit the ability of the governing body to increase the number of members above 15.
Above, I see. Okay, I see that now. Above 15.
Yeah.
Okay, thank you. Appreciate that. Okay, no problem. Thank you. So then the first consideration is the body a local agency? And thus, is it then need to be compliant under the Brown Act? Thus, the Sunshine Ordinance. I think we're kind of clear on that. And then the question is around the holdover issue with regards to what Vice Chair Yankee brought up in 5604C. That the term of each member shall be 3 years, and they should be staggered, where 1/3 is staggered, every year. So there's a limit on. It doesn't necessarily speak to holdovers, but because there's an expiration of term, it means that there actually can't be a holdover. It means it just is a vacancy. I think that's the way it's kind of supposed to work. So I don't know how applicable that is for our purposes at this point, but I think it was worth mentioning. So, okay, Member Stein.
I'd like to comment on that.
In what fashion? What? I'll allow it if you think that it would help us come to some.
Yeah, if something's moving around in the background, I'll try to talk over it.
Okay.
Well, in that point, 5604C, the term of each member of the board shall be for 3 years. The governing body shall equally be staggered, and so the approximately 1/3 appointment expired in each year. We had a situation where legislation had to be written in. We previously did not have staggered expiration dates. As commissioners termed out, they were traditionally replaced. It wasn't an issue. Supervisors generally replaced. For some reason, over the past year, past couple of years, and I'd have to go back and historically, it looked as though the commissioners, they did begin to term out at the same time, and then there was legislation put in place to enact this staggered process. But in order to enact this staggered process, some people were going to lose time, some people were going to gain time in order for it to come into effect. So those people that lost time consequently became holdovers. And so anyway, I'm just trying to point that little aspect out, that there was once again a transitional year.
Yeah, I hear what you're saying, but I think this doesn't allow for a holdover. That it says the appointment expires. So If the appointment expires, then the seat is vacant. The question then becomes, is there a section of law elsewhere in the state that speaks to this particular kind of body, or does the holdover rule apply locally? And I think we've already been down that road as to whether it's part of the executive branch or the legislative branch, and whether the legislative branch has holdover. It applies to this body with regards to holdovers. I'm not going to continue to adjudicate that at this time because of time. So let's go back to Member Stein. You wanted to take a stab at a motion.
Except for, does Member Schmidt still have his hand up?
Oh, Member Schmidt.
Sorry, forgot to take it down again.
Okay. Go ahead, Member Stein.
Okay. Mr. Chair, could I rebut?
I did take Mr. Greer out of context. I'll just give you a minute to rebut. Okay, go ahead.
Thank you. It won't even take that long. Section 15.13 of the San Francisco Administrative Code, Subdivision A, states as follows, and I quote, "Except for the Board of Supervisors member, the term of each member of the Behavioral Health Commission, parentheses, commission, shall be 3 years, period, ... And it goes on. Back to you, Mr. Chair.
Thank you. Okay, Member Stein, go ahead.
Member Stein. So, based on the evidence that I saw, I felt that there were 4 points that seemed most convincingly to have been violated, and that was 67.7A for failing to describe the agenda items well, that piece of it. 67.7B, which relates to the same thing, posting these relevant descriptions online. 67.7G, failing to include notices of rights under the Sunshine Ordinance. And 67.9, failing to post supplementary documents, again, on the internet. And so I would move to find a violation of these 4 sections.
Just clarification before I ask for a second. Was that 67.7A, B, D as in David, or G as in George?
67.7 A and B. And then
what?
G. And then
G as in
67, yeah, G as in girl, B as in boy,
Okay.
A as in apple, and then 67.9 A as in apple.
9A. Okay. Is there a second?
Second.
Okay, moved by Member Stein, second by Member Schmidt. I wanted to notate that the timestamp for posting an agenda is not specific about what goes on the internet. It's specific as to when it's posted in general. If you read 67, where is it? It's 67.7A. It talks about at least 72 hours before regular meeting, policy body shall post an agenda containing meaningful description. Each item of business be transacted or discussed at the meeting. Agenda shall specify for each item of business proposed action statement, blah, blah, blah. In addition, policy body shall post the current agenda on its internet site. Now, before the internet got created, these got posted at the meeting room. That's where it's supposed to be posted. That's the official posting. The internet is in addition, and the ordinance had not been I don't believe was updated since its inception. for it to be meaning anything else.
Well, I was going to say, I don't think that I saw evidence that it wasn't posted elsewhere, and they certainly said that they sent out emails to everyone on their list more than 72 hours in advance, and there's pretty ample evidence of at least a week or more beforehand trying to get that agenda posted. So I just wasn't convinced that they didn't make a reasonable effort to get the agenda out.
But I think you mentioned something about a difference between 56 hours and 72 hours.
Well, that's when it finally went up 56 hours in advance on the example I'm looking at, but they submitted that agenda to go up like more than a week before more than a week before the meeting, or somewhere around a week before the meeting. I mean, there was plenty of time. It should have gone up, and they made a good faith effort to submit it in time.
I understand that, but that's not the point of the posting, the 72-hour period. The
but
point is,
it was also, was it not also during the pandemic and all kinds of things were happening?
Yeah, but this is to benefit the public, not to benefit the body that's trying to have a public meeting. If anybody posted an agenda less than 72 hours and the public was unable to have adequate access to be able to have that, we would consider it a violation at any time. So whether if the body was monitoring when the posting was going up, and if whoever they assigned to post it didn't post it up in time, then the meeting can't happen. If that happened to the Board of Supervisors, they'd be held to pay.
Well, in any case, it might be we see it differently, and maybe I'm wrong. It doesn't actually affect my motion because my motion still says a violation of 67.7A, and both clauses are included in that.
I understand, but we're not just making, I mean, we've been kind of scolded many times about making, taking actions and just citing sections without applicable, what exactly is the violation? So, I'm stating if we're going to do 67A, then I'm going to, your portion for 67A it's based upon the description, not on the time.
For somebody else, it could be based on the 72 hours in advance. It's still a violation.
But that's been a big problem of ours, is that when we send it for monitoring, it's what are they monitoring for? Are they monitoring for description, or are they monitoring it for timeliness of the posting? There are two aspects to this particular paragraph.
So are you saying you want me to say that they failed on both?
Well, if you don't agree with that, then that's fine. I'll make a subsequent motion. Moving forward, you're the maker. I mean, I could certainly interject by making an amendment, but I'm not gonna. We spent a lot of time on this already. Right. But I'm just noting as part of the whether that might be another compelling point. I mean, yes, the commission may have made a full faith effort to whether it was a week before or 3 weeks before. But if the people that were responsible to put it up online on their behalf, at their direction, didn't do it in time, then it's a responsibility of the body as to whether they can actually have the meeting or not, because they didn't allow the public, provide the public with proper notice.
Right. I'm just going to say, given COVID and everything else, I'm not fully comfortable with that, so I'm going to leave my thing the way it is, and you can do an addendum if you want.
Member Stein, I just want you to clarify for me what your motion is. It's 67.7A for failing to describe agenda items, 67.7B, and what was that?
Oh, I mean, I was telling you my rationale. I mean, I'm very comfortable just saying violation of 67.7A, 67.7B, 67.7G, and 67.9A. I was telling you my own rationale for why I chose those.
I understand, but what we have to do is name what the violation is, because 67A is there are two aspects to it. One is the 72-hour posting, and the second aspect is meaningful description.
Okay. Well, I see it as for failure to describe agenda items.
Okay.
Adequately.
And then B?
Failing to post docs or documents for the public online or to make them available.
And G?
Failing to include notices of rights under the Sunshine Ordinance.
And 67.9.
In this case, for failing to post supplementary documents needed for the meeting on the internet.
Second agrees.
Ms. Leger, did you get all of that?
Yes, I did.
Okay.
I have to say, I have a new computer, and so the keyboard is like, I'm not used to it.
Thank you. I thought I saw Member Highland's hand up. Is there something you wanted to say?
No.
I guess that was a no. Okay. Let's open for public comment. And we have somebody's phone or microphone that's making a lot of noise. Okay. Please wait for Ms. Leger if you wish to make public comment. This is public comment for members of the public other than parties.
Sullivan.
Can you hear me now?
Ms. Leger, are you there?
Yeah. Hello, do we have a second public commenter?
Can you hear me now?
Yes, I can hear you. Are you speaker number 2?
No, I'm sorry. It's David Pilpel. I have no comment on this item. Can you just tell me what item number we're on? That's all.
Well, we combined item number 7 and 8.
Excellent. Keep up the good work. I'll keep tuning in. Thanks.
So it looks like Mr. Sullivan is our only public commenter. Mr. Sullivan, are you ready?
Yes.
Go ahead, sir.
Okay, to address a few things. Section 15.13 of the San Francisco Administrative Code on Behavioral Health Commissions, terms of removal. B, no member shall serve more than 2 consecutive full terms. So if each full term is 3 years, then that's 6. The next sentence says, a member shall be deemed to serve a full term only if the member serves at least half of the full term. So about 7.5 years is the most any commission a member could serve, and can't be a holdover. It all depends on when they start. As far as I agree with Chairman Wolf as far as the policy body being 67.3D, D3. So if you guys go with the federal, it also works with 7 because there's an or between local grant who's member. So it's an advisory board, commission, committee, or council created by a federal, state, and then there's another or local, or local grant. The local grant has nothing to do with this. So if it's federal or state, it's fine. Also, the Brown Act 54952, legislative body means governing body of a local agency or any other local body created by state or federal statute. And as far as quorums are concerned, that's all in the definition of meeting. either in the Sunshine Ordinance or in the Brown Act. And instead of using quorum, they use a congregation of a majority of members of a policy body at the same time and place, or majority. They use majority a lot in defining the quorum of commissions or any type of meeting in both the Brown Act and the Sunshine Ordinance. Okay, thank you for your time.
Hello? Wishing to make public comment.
Please wait for Ms. Leger.
Thank you.
Are you speaker number 2?
I guess I will be. The name is, tell me when to go, or whatever I need to do.
All right. You may begin.
Thank you. This is Stephen Banuelos. I'm currently a commissioner on the Mental Health Commission. I'm sorry, Behavioral Health Commission, though I wasn't at the time that the issues being discussed were going on. I've only been on the commission since early 2021, and we're talking about issues related to the summer of 2020, when, as has been said before, there was many issues going on, lack of staff, whatnot. So I did want to point out that whatever gets found, please bear in mind that as of late last year and into this year, under current or new legislation, the behavioral health, not commission, I'm sorry, the Department of Behavioral Health Services is now responsible. So, whatever decisions you may make are in a certain sense pertaining to a body that is different than currently. And under current legislation recently passed by the BOS, it would be Department of Public Health, Behavioral Health Services section that would be responsible for implementing anything that you would hope would be going forward. And that includes the time of appointments. That specific legislation which passed late last year does specify, myself, for example, people being, their terms terming out every few years on a schedule. So keep that in mind when you make these decisions, because there will be further issues that will be discussed. Because I know Mr. Hillier has maybe another couple of hundred issues that he's filed with the commission that we will be discussing at some point, but I believe they're from 2021. And like he likes to say, during every meeting, that the meeting is happening.
30 seconds.
Okay. Anyway, I'd just like to say, at every meeting, Mr. Hillier will quote something, and I don't know the law because I'm not a lawyer, but he says that this meeting is happening against the Brown Act and Sunshine Act. So I suspect he's going to have that mentality no matter what. Thank you.
Any other public comment?
Can I make public comment? No, I can't. I'm the administrator. No, never mind.
Party. All right.
Yeah.
Okay. Hearing no public comment, folks, are we ready for a vote? Okay, please call the roll. Hearing no objection.
Member Stein?
Aye.
Member Stein, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Forsley, not present. Member Neighbors?
Aye.
Member Neighbors, aye. Member Highland?
Aye.
Member Highland, aye. Member Wong?
Aye.
Member Wong, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member LaHood?
Aye.
Member LaHood, aye. Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member Stein, second by Member Schmidt. To move to find a violation of 67.7A for failing to post the agenda 72 hours in advance and failure to describe the agenda items. 67.7B as in boy, failing to post records online and or make them available. 67.7G as in George, failing to include notices. Failing to include notices of rife on the agenda. Is that what you said, Member Stein? You're on. You muted.
Hi, sorry. I have to go back to my notes. 67, which was the last one you said?
Failing to include notice is 67.7G.
Notice of people's rights under the Sunshine Ordinance.
Failing to post notice of people's rights on the agenda. 67.9A, failing to post supplementary documents for the meeting on the internet.
Yeah.
Okay, thank you. The motion is approved. I'd like to propose a motion to continue this item for the membership and the validity of the with regards to whether this is under the Sunshine Ordinance under 67.3 D3 as to get a little more information as to under behavioral the welfare and institutions codes 5602 and 5604. Mr. Hilliard did file a complaint with regards to these. I don't think we have come to an adequate solution. So I'd like to leave the file open to allow us to get some additional information and to continue this to the call of the chair. So I'm making that motion. Vice Chair Yankee.
Yeah, I'm sorry. I was trying to interject before you started.
I'm sorry.
Did Member Stein's motion contain the violation for the posting on the agenda? Because I thought she wasn't comfortable with that, but I thought I heard Clerk Leger read that back.
No, it was not. She did. It was only for the description.
Cheryl, did you include the 72 hours? I'm pretty sure you just read that back when I heard you rereading the motion. Cheryl, you're on mute.
Yes, I did. I'm sorry. That was 67.7A for failing to post the agenda 72 hours in advance.
I believe Member Stein did not want that included, so that's why I want to be very clear what her motion was.
All right, so we don't want 67A in there?
No. She said 67A, but not that portion of 67A.
It's for not providing an adequate description on the agenda. Okay.
Yeah.
Okay, great. Okay, so thank you for flagging that. So I have made a motion. Is there a second? If anybody needs it repeated, I will.
This is Vice Chair Yankee. I will second that.
Okay. So motion is to continue the item at the call of the chair to review the status of this body as to whether it falls under the Sunshine Ordinance as described in section 67.3. Lost my place here. 67.3 D3.
What about the Welfare and Institutions Code?
Well, that'll be part of the review, but that's not within our jurisdiction. It only will help define. It would need to be reviewed to define whether it is under jurisdiction.
This is Victor Young. I just want to maybe simplify as we want to determine if members can sit as holdovers. Is that one of the main questions?
That is one of the main questions. Yes. There's also the issue of whether there was a quorum present.
Bruce, I need you to repeat your motion. Continue the item to the call of chair, and the status. That's it, or just continue to the call of the chair?
No. Continue to the call of the chair to review the status of the Behavioral Health Commission as to whether it falls under the jurisdiction of the Sunshine Ordinance under Section 67.3D3, and to further review whether the holdover provisions apply.
And who do we have a second on that?
Vice Chair Yankee.
Chair Wolf, this is Victor Young again. Can I assume that you're asking the Deputy City Attorney to provide a report on this or to provide advice?
I think that would be a good idea. I probably would confer with our legal counsel on that. So yes. And considering her participation today.
All right, do we want to take public comment on this?
Yes. Any public comment on the motion to continue? Last call for public comment. Okay, hearing none. Public comment is closed. Are we ready for a vote? Please call the roll.
Chair Wolf?
Aye.
Chair Wolf, aye. Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Member Forsley, absent. Member Neighbors?
Aye.
Member Neighbors, aye. Member Highland?
Aye.
Member Highland, aye. Member Stein?
Aye.
Member Stein, aye. Member Wong?
Aye.
Member Wong, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Moved by Chair Wolf, second by Vice Chair Yankee to continue the item to the call of the chair to review the status of the Behavioral Health Commission as to whether it falls under the jurisdiction under the ordinance under 67.3 D as in dog, and to further review the holder provisions apply.
Okay. All right.
Sure.
Yes.
I actually do think that the agenda issue is important to address. So I do want to make a separate motion because piggybacking on Member Stein's motion, not including that, I did want to move to find violation of 67.7 subsection A for the Behavioral Health Commission not posting an agenda at least 72 hours before a meeting.
I'll second it. Chair Wolf.
Do we want public comment on this?
Absolutely.
Okay.
Any public comment?
Can I make public comment?
One moment, wait for Ms. Leger.
Thank
Are you speaker number 2, you, Mr. Benuelos?
you. Yeah, I'm speaker number 2.
I'm speaker number 3, Patrick.
Do we have other public commenters? Okay, I guess we don't. We will start with speaker number 3. Or 2, rather.
Is that me, Stephen Banuelos?
Yes, it is. Yes, it is, sir.
Oh, just real quickly, I thought I heard Jeffrey Greer say that he presented evidence that the agenda was put out 72 hours ahead of time, so I'm not quite clear. I mean, are we looking at believing one source and not another? Anyway, that's what it sounds like to me. Thank you.
Patrick, are you ready to proceed?
Sure.
Go ahead, sir.
Because of my hearing loss, I'm not sure who just made this motion. I have the impression it was Victor Young. Is that correct?
No, that was Master Yankee.
Oh, okay. I commend him for bringing this motion forward, and I support it. Thanks.
Any other speakers? Last call for public comment. Okay, public comment is closed. Are we ready for a vote? Any objections? Hearing none, please call the roll.
Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Member, Chair Wolf?
Aye.
Chair Wolf, aye. Member Forsley, absent. Member Neighbors?
Aye.
Member Neighbors, aye. Member Highland?
Aye.
Member Highland, aye. Member Stein?
Nay.
Member Stein's a no.
Yeah, no.
Member Wong?
Aye.
Member Wong, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Moved by Member Yankee, Vice Chair Yankee, seconded by Chair Wolf. Moved that Administrative Code 67.7A for the Behavioral Health Commission not posting agenda items, the agenda 72 hours before a meeting.
Okay, great, thank you. I just want to check in members. Just want to check in members. We have 1, 2, 3 items for hearings. Do you want to take a break or forge ahead? Or do you want to take a break after the next item?
I'd say 10-minute break now.
Okay.
I'd second that.
Okay. So, are there any objections to taking a recess now? Or, okay. Let's do that. 10 minutes. It is 8. Let's say it's 8:20, coming on 8:22. So,
Chair Wolf,
who's speaking?
it's David Pilpel. Can you
Yes.
just be a little more clear on what's upcoming and what your plan is for the rest of the evening before you take the break?
Sure. So it's Items number 9, file number 20093, files number 10, 20120, 11, 20011. Item number 12 has been continued. Item 13, which is a report on state bills. And then item number 14 is a review of, I guess, amendments of draft complaint form. There's a chair's report with a system-wide advisory draft and a short report after that, and then the administrator's report, announcements and comments, so on and so forth is the next item, and then adjournment.
Okay, thank you very much. I'm interested in 13 and thereafter, so I'll check back in a couple hours.
Okay, thank you.
Appreciate it.
So the Winship and Behavioral Health Commission are over with.
Yes.
We're done.
You're done,
well,
but
until you call us back. Until you
Correct.
call us again.
Correct.
Will that be coming? Is there a timeline on that?
It all depends upon how quickly we can get the information back. We meet monthly, and it all depends upon how many cases we have in the pipeline. So it may not. It could be November. It may not be November. It may not be December. We're pretty backlogged.
Oh, don't worry. There's a whole pile coming, so I'll see you again.
Okay, thank you, Mr.
Okay. Thank you.
Okay, folks. So it is now coming on 8:24. We'll return back here at 8:34, and we are in recess. Please mute your microphones and turn off your videos. Thank you. Okay. Ms. Leger, are you there? Victor, are you available? Are you there?
Yes, I am here.
There looks like somebody is logged into the system. There's no name. Do you see that?
Is that me? I'm calling in, ending in 4107. Is the phone?
Nope.
Helen,
There's a
moment.
sorry.
There's a kind of a blank.
I see the phone numbers, I see anonymous, and then I see the members.
So I'm looking at the top. At least for me, it has me first, and then there's just a blank entry. And
I'm
then
not
I have.
seeing that.
You don't see that? Okay.
I see one that says guest.
Bruce,
Yeah,
I'm
it
back.
does-
What do you need?
Though I'm using a web browser, not using the Teams app, so it may look different for me. I didn't see that before, so. All right, are we ready? Ms. Leger, are you here?
Yes, I am.
Okay,
Just,
then let's start the recording and.
I didn't stop the recording.
Oh, okay. So then let's come back into session. If you can call the roll, just make sure that we still have quorum.
Chair Wolf?
Present.
Chair Wolf present. Member Forsley, not present. Member Neighbors?
Present.
Member Neighbors present. Member Highland?
Present.
Member Highland present. Vice Chair Yankee?
Present.
Vice Chair Yankee present. Member Stein?
Present.
Member Stein present. Member Wong?
Present.
Member Wong present. Member Padmanabhan?
Present.
Member Padmanabhan present. Member LaHood?
Present.
Member LaHood present. Member Schmidt?
Present.
Schmidt present. We have a quorum. Chair Wills, shall I read item number 9?
Chair Wolf, you're muted.
Yes, please call the next item. Thank you.
Item number 9, file number 20093, complaint filed by Carl Kramer against the Department of Public Works for allegedly violating Administrative Code Section 6721 by failing to respond to a records request in a timely and or complete manner. On April 20, 2021, the complaint committee found that the task force has jurisdiction, the records are public, and referred the matter to the task force with a recommendation to find violations for timeliness and withholding. On June 2nd, 2021, the task force recommended that the matter be continued pending an exchange of records between the parties and referred the matter to the Compliance and Amendments Committee for monitoring. On July 27, the Compliance and Amendments Committee referred the matter back to the task force because there was an exchange of records between the parties, but not to the satisfaction of the complainant.
Okay, Member LaHood?
Yes, Chair Wolf. So we heard this in Compliance and Amendments, and there was an exchange of documents, but Mr. Kramer wasn't satisfied, and we determined in the hearing that there was enough information that there was a possible violation for at minimum timeliness, and Department of Public Works admitted that when they received the initial communication from Mr. Kramer, they had not interpreted it as a sunshine request. And we thought there's enough there for the task force to consider this. So that's why we're here today.
Okay. So this was returned to compliance and amendments for monitoring.
No, there was not an order of determination. It went to us because Mr. Kramer had said that if he received the documents, he might be satisfied and would drop the complaint, but he received the documents and was not satisfied.
Okay, thank you. Okay, so where are we picking this up in our meeting here? We're picking it up after rebuttals. Or is this a first time?
I do not know.
Recommended the matter to be continued. So I don't recall where in the meeting that we continued this. I guess it probably was after rebuttals. So we're not going through our whole process at this point. Okay. This was April, June. Okay, apologies, just a second, folks. June. 4, 5, 6, 7.
And Chair Wolf, to clarify too, the potential agreement to drop was based on receiving 2021 figures, which were not part of the original request. So this was sort of deal making that was happening and the deal fell through.
Okay, so according to the minutes for that day, this is on the June 2nd, 2021 meeting, the petitioner provided a summary. The Department of Public Works, Mr. Steinberg, respondent, provided a summary. And I don't think we got to rebuttals. So we were it was just a matter of not having enough information at that point. So let's pick this up after the opening testimonies, and we're now in Q&A clarification. And now we need to confirm whether the records have been delivered or not to Mr. Kramer's satisfaction. Okay, Mr. Kramer, are you here?
I'm here.
Okay, and representative from DPW?
Yeah. It takes a minute to unmute. But I don't believe it ever came to the full task force. It's been before 2 committees, but not the full task force.
No, it's in the minutes of the full task force of June 2nd, 2021. And then it was referred to the Compliance and Amendments Committee for monitoring. That meeting was held on July 27th, and now the Compliance and Amendments Committee has made a determination and making a recommendation back to the task force. We have documentation to show this chronology.
Okay. I'll take your word for it.
Okay, so Mr. Kramer.
Yes, I mean.
Okay, has there, it's supposedly that there was an exchange of records. All right, there's some background noise. Can people please mute by pressing *6? Thank you. Mr. Kramer, was there an exchange of records?
There was.
Okay. Was it to your satisfaction?
No.
What's missing?
Well, as you know, the complaint was for from 2020, and what I had said to David was that since this was a request from a previous fiscal year, that if we could get the information for this current fiscal year, that I'd be willing to withdraw the complaint. And after my offer was premised on that the department would demonstrate that it was transparent. But after further back and forth emails, I found that the responses from Devin McCullough were oblique and did not directly answer my questions. In one of his final emails on June 15th, which you could see on page 535, David suggested that I communicate directly with Devin McCullough, whom he copied on that email, but I never heard from Devin. So I just find and I'm not blaming David. I mean, he's just acting as the intermediary, but I'm finding the department's budget department, the budget committee, their attitude towards the public on budget matters is opaque, and I decided that they should not be rewarded by my withdrawing the complaint.
Okay, thank you. Does that flow, Member LaHood, does that flow with your finding in committee?
Yes.
Okay, great. Okay, so what's the recommendation from committee? Was there any?
We returned it back because, as I said, Mr. Kramer had said that he would consider dropping it if he received the new figures, but because he wasn't satisfied, he was rescinding the offer to drop the initial complaint, and we found that there appeared to be enough evidence for not responding in a timely manner, because, and DPW had even said they did not, they said they did not interpret his initial message as a request for documents. But if you read it closely, you can see that there is a request contained in his letter.
Got it. Okay, members, any further questions for either of the parties?
Sure, Will.
Yeah.
I'd like to ask my fellow Compliance and Amendment Committee members, was there anything that I missed there, or?
Yep, covered it.
Okay, shall we move to rebuttals? Okay, let's do that. Okay, respondent, DPW, you're first. You have 3 minutes. Please wait for Ms. Leger.
The first speaker is Mr. Steinberg. Is the respondent available?
Just give him a minute.
Yeah, whenever, just go ahead and give me a signal,
Okay.
Cheryl.
Okay, hang on a second.
The system is slow to unmute, folks, so gotta wait a moment.
Are you ready, David?
I am.
Go ahead.
Thank you. So Chair Wolf and members of the task force, again, my name is David Steinberg. I'm custodian of records for San Francisco Public Works. First, I need to point out that the notes in the agenda and complaint committee minutes actually were incorrect. Member LaHood is correct. The complaint committee's original recommendation was for a violation of timeliness, but not withholding. Because the committee agreed with Public Works, we fulfilled our obligations to produce the records. I'll just focus on the issue of timeliness. As Member LaHood pointed out, the subject of the deal was to get the subsequent year's documents. Those were not the subject of the original request. We gave him, Mr. Kramer, all the records in the original request. So let me explain why I disagree with the committee's recommendation that we be found to have violated timeliness. So in his testimony and submissions of the task force and its committees, Mr. Kramer has repeatedly framed the group's correspondence as a campaign to educate departments. And that's exactly how his initial email to our director of finance is viewed, rather than as a records request. And we all know that you don't have to use specific words or use a form or use an X request to make a sunshine request, but there is a point at which a records request needs to clearly indicate that a record is actually being requested. We believe the communications from the Living Wage Coalition failed that test, especially given the fact that multiple departments received similar communications, and he has filed complaints against all of them because none of those departments apparently recognize them as requests for documents. So we're not alone. As Member Highland pointed out at a recent EOTC hearing, the group really needs to make it clear that they're requesting a specific document, or even that the letter is a records request at all. So the first time I was made aware of the letter from Mr. Kramer that's the subject of the complaint was July 23rd, 2020, when Cheryl notified me that a complaint had been submitted to the task force. That same day, I contacted Mr. Kramer asking how he had submitted the request, and he provided a copy of his letter, which he had sent to Julia Dawson, who was then our Deputy Director of Administration and Finance. I contacted Ms. Dawson. She confirmed she'd received the letter. She told me she forwarded it to our budget director because it didn't sound like a records request. She wrote, "I read this as an advocacy message telling us what amounts we should be budgeting for various services and asking for us to confirm that we've done so. The group has sent similar messages every year, and I don't remember them ever being considered public records requests." Mr. Kramer said he also sent it to our general DVW email account, but I can't find any evidence of that. And I asked our staff to look into that. I also asked our director and his secretary if they received it. None of them had. As soon as I did find out about it, I contacted Mr. Kramer the same day, and we acknowledged it. So, not to make light of deadlines. I mean, I was an editor for 30 years, but if we properly received the request on June 11th, we would have had until June 21st, plus the 14-day extension to respond. We actually responded to him on the 23rd, even though I had no notice. I didn't realize that there had been a request. The same day that Cheryl notified me, I got in contact with him, and we acknowledged it, and we gave him all the documents that he was looking for. So I would ask that there not be a violation for timeliness on this issue. Thank you. I'm happy to answer questions.
Okay, thank you. And now 3 minutes for the petitioner, Mr. Kramer. Please wait for Ms. Leger.
Mr. Kramer, are you ready?
I'm ready.
Go ahead, sir.
Yes, thanks, Cheryl. Yes, the initial request was sent on June 11th, as you can see on page 469, and that when he refers to this being a educational campaign, yes, there have been emails sent since 2019 informing the department that according to the ordinance that in 2021 they would need to start providing a written confirmation that's required under the ordinance. And in fact, we got the city controller's office to also send out a memo to departments saying that starting 2021, it would no longer be their responsibility to do calculations on what the effects of MCO wage increase would be on their budget, that they needed to provide that information. The complaint was filed, and there were also follow-up phone calls and voicemails that were left, and we didn't hear back from the department. The complaint was filed on July 23rd, which was 42 days after the initial information request. We did not receive any documents from David Steinberg. In fact, you could look at, as you can see on page 474, the response was, that they didn't interpret the email as a public records request, even though in the subject head it said information request. He further wrote that they don't have to create a response to an information request or a series of questions, and that's not a public records request. And it should resubmit the request more clearly identifying the record. On page 473, you can see that he sent a follow-up email on July 27th with an attachment that had budget figures for fiscal year 2019, and said that it's his understanding the Controller's Office increased the funding, and the Office of Labor Standards Enforcement monitors compliance. Page 472, you can see I responded on July 27th that the request was for a document required by the Minimum Compensation Ordinance, so that's an identifiable record. I further wrote that the Controller's Office had written a memo on November 5th, 2019, that it no longer was their responsibility to calculate the cost of MCO increases, and that starting in fiscal year 2021, it'd be the responsibility of departments. I also wrote that this
Your
was
time is up, sir.
What's that?
Your time is up.
Oh, okay.
Let him finish his thought. Go ahead. Finish the sentence, please.
So I would say on that on page 490, if you look at page 490, it was August 20th, 2020, that David sent an email that the budget team finally did find a document, which would have been a budget submission checklist that would have been submitted to the mayor's budget office back in February. So it was after this back and forth email exchanges about how they don't have to create a document to meet our request, and it was months later that they finally found the document.
Okay, thank you. All right, members, the matter is with you. All right, I'll start the ball rolling. On page 470, third paragraph, we are requesting the written confirmation that the department took these costs into consideration and the amount that the department allocated to nonprofits for these costs. There's the request. And I'm not convinced of the rationale that based upon what Mr. Kramer had reported. I don't quite get confirmation of that, but from the respondent. But the subject line says information request, and if he was being, if the response was, it's an information request, it's not a records request, is a little. That's splitting hairs. I mean, the Freedom of Information Act, it's a FOIA request essentially. It's information or records. It's all the same thing. The ordinance speaks about information. I just think that's not good. Also, I'm having a little problem, and we'll get to this towards the end of the meeting. because we're going to submit send out a system-wide advisory around timeliness, and I'll just state right now. I'll repeat it later too. That where did I put it? That this notion and interpretation of the ordinance that a respondent has 10 days to respond and then gets to extend to another 14 days is incorrect. It's not even part and parcel to the California Public Records Act. The Records Act doesn't even spell it out that way. It's a maximum of 14 days. You're supposed to respond in 10 days, and if you need an extension, the extension is to 14 days, not 10 days to respond and then an additional 14 days. That is incorrect. I don't care what the Good Government Guide says, because that has not been fixed, and it's not been reviewed, and we have not been asked for assistance on various interpretations. So that is incorrect, and people have to stop doing that. Okay, I'll stop there. Member Neighbors.
I agree completely with you, Chair Wolf, and I think on the grounds of what we've identified as a subject line that clearly states that this is an information request, paragraph on P470 that begins, we are requesting written confirmation, and our shared understanding that under the Sunshine Ordinance, requesters can request public information. They do not have to request strictly records. That I'd like to go ahead and make a motion that we find the Department of Public Works and Mr. Steinberg in violation of 6721 for failing to respond to a records request in a timely and or complete manner.
Which paragraph?
Which paragraph of the ordinance?
Yeah, 6721 is a number of subparagraphs. I don't think they all are about timeliness.
Is it let's see. Anyone can help me out. I'd appreciate it. My computer keeps freezing.
It is 6721.
B.
Yeah, B is in Bravo.
Bravo.
721. Okay, is there a second?
I'll second. This is Member LaHood.
Okay, and is there something we would like to, I would suggest, if there's something we want to compel the department to do we want them to deliver the documents? I mean,
well, at this point, I believe the documents from the original request have been delivered, but there is a violation because there was such a delay.
Okay.
Yeah.
Mm-hmm.
We missed that part. Okay, so moved by Member LaHood. Member Vice Chair Yankee.
Yes, the motion I think was for Department of Public Works and Mr. Steinberg, but I wanted to point out that the email was actually sent to Ms. Julia Dawson in Public Works. So I'm not sure if David Steinberg's the correct named party, since the request was actually sent to Julia Dawson, not Mr. Steinberg.
Let's look. No, it should be whoever the complaint was. The complaint form says it's about. And it says the complaint is against the Department of Public Works, and the person named here is Alaric Degrafinred. Mr. Kramer, is that correct?
Yes, that's the director of the department.
Okay.
Former director, actually, yes, at the time.
Former director.
Okay.
Yeah.
So the complaint is, and let's see what is our agenda say here. Yeah, so it's against the Public Works and this named person.
I didn't catch the name.
Alaric, Alaric, Degra, Egra, Finrid, Finried, and I probably trashed that in pronunciation.
It's Alaric de Graffenried. Yeah, actually.
De Graffenried. Okay. Okay. Thank you.
So are we amending the motion to that? I don't know if we need officially.
It absolutely needs to. Member Neighbors and Member LaHood.
I accept the amended motion.
Member Neighbors?
Yes.
Okay,
I
great.
accept.
So Ms. Leger, the violations are against Alaric de Graffenried and Department of Public Works.
Right. So that was member Vice Chair Yankee's amendment.
No, it's just a correction, actually.
Okay.
Yeah, just an amendment.
Okay. Yeah, I got that.
Okay. So moved by members Neighbors, second by Member Hood. Any other members? Any other discussion? Okay. Public comment. Any public comment? Last call. Okay, public comment is closed. Are we ready for a vote? Hearing no objection, please call the roll.
Just a moment. Member Neighbors.
Aye.
Member Neighbors, aye. Member LaHood. Member LaHood?
Aye.
Member Forsley, not present. Member Highland?
Aye.
Member Highland, aye. Member Stein?
Aye.
Member Stein, aye. Member Wong?
Aye.
Member Wong, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Vice Chair Yankee? Vice Chair Matthew?
Aye.
Vice Chair Yankee, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Member Neighbors, seconded by Member LaHood, that the task force finds the Department of Public Works and Alaric Degrafinried in violation of 6721B for not providing records in a complete and timely manner.
Okay, thank you. Please call the next item.
Okay, just a second. Item number 10. Are we ready?
Yes, please call next item.
Yes. Item number 10, file number 20120, complaint filed by Alina Afuamango against the police department for allegedly violating Administrative Code section 6721 by failing to respond to a records request in a complete and or timely manner. On May 18, 2021, the complaint committee found the task force has jurisdiction. The requested records are public and referred the matter to the task force for hearing.
Complaint committee, Chair Schmidt, or anything to add?
Yeah, pretty straightforward. The petitioner complainant, she wasn't there at the meeting, but apparently she said she does want to go forward with this. That's my understanding. Cheryl may know something different. It's pretty much a single document, which is trying to get a hold of a homicide report, and a homicide report appears to have been held up because of the medical examiner's portion that was supposed to be inserted into that report. I think that it was received approximately 2 to 3 months after the request. I think it was maybe in October to January. And the department stated that they needed to wait until they had the complete contents before they would disclose. The one thing that, other than, I think that's the facts, it is the kind of thing where she would receive it, but it's not something that would be made available to the general public. So it's one of those kind of documents that it's never a publicly open document. It's sort of like if someone asks for their own personnel records, their own medical records, and this is your own records of a family member involved in a crime. I think that's everything. Anything else, members of my committee? Member Stein.
No, I don't think I have anything to add to that.
Okay.
I have a question for you. Was there any citation with regards to that withholding, but kind of limited withholding?
There was a citation, I believe, that they have a policy, the police, that they cannot release, or that they can withhold incident reports until they receive a report from the coroner's office. Wasn't it that? And that there was therefore investigation. There was a ongoing investigation, and they were withholding the document until they received that coroner's report.
I think I was more referring to what Member Schmidt was saying, was that a person can ask, if they're a party to the incident, that they can ask for it, but it's not available to the general public. Is there some citational law around that?
Yeah. The statutes, the state statutes that are that govern CLETS, CLETS information. I believe that this falls under that statutory scheme. So that's California Law Enforcement Tracking System. And I think that's how the records like this are handled. Although I'm not 100% sure, because we had another CLETS case, so I may be confusing two cases.
Okay. All right. Well, we'll figure it out. Okay. Thank you. I just thought maybe there was something we could get a little more information on. Okay. Let's start our hearing. 5 minutes for each party, starting with the petitioner, Ms. Fuamongo. Are you present? Just wait for the delay to unmute.
Hello?
Yes.
Yes, this is Elena.
Okay, Elena, thank you for being here. And is there a representative from the police department?
Lieutenant Parra with the San Francisco Police Department.
I'm sorry, can you say your name a little slower again?
Oh, I'm sorry. Lieutenant Aaron Parra with the San Francisco Police Department.
Can you spell your last name, please?
Sure, it's P as in Paul, E-R-A.
Very good. Okay. Ms. Afua Mungo, please wait for our administrator, Ms. Leger, to start the clock. She'll tell you when to begin and when you have 30 seconds left before the end of that period. Thank you. Ms. Leger.
Elena, are you ready?
I'm ready.
You may begin.
I filed a police report online October 5th, 2020. Both written and verbal requests I submitted for the incident report number 200599990. And during that time, there was some back and forth with SFPD. On October 13th, 2020, SFPD responded to me that they received my request, but due to the quote, due to the nature of the report, must route to investigative unit for final release approval. I responded immediately, quote, what does the nature of the report mean? There's back and forth. Lieutenant Philpott called me on October 26, 2020, said he could not release the police report without an ME report because things might change. I asked Lieutenant Philpott how and why things would change, because I'm only asking for a police report, which is a public record. It's not the cause of death, not asking for the ME report. Lieutenant Philpott stated that it is, quote, policy, and that he would not be able to release the incident report. That's when I filed a complaint against the SFPD with the Sunshine Task Ordinance Force on October 29, 2020, for not disclosing public records within a timely manner. And I also contacted Captain Michelle Jean and mailed physical letters requesting the police report, just back and forth requests on November 3rd, 2020. Then I received an email from SFPD Officer Harper, star number 1025, at the SFPD Richmond Station, where he wrote in summary, thank you for contacting Richmond Station. Sorry to hear for your loss. The medical examiner's office is currently in charge of this case. Unfortunately, the SFPD cannot release the report until they give us the okay. If you'd like to talk to the ME office, please call them. Sorry, I'm going through my timeline. November 5th, 2020, I'm receiving conflicting reports from SFPD and Lieutenant Philpott, who have insisted that there's currently no open investigation in the case. And also in rebuttal to what the police department is saying, nowhere did they say this was a homicide case. On November 9th, Giannina Miranda, who's the secretary to Captain David Falzone, gives me the unit policies and the policies procedures, and I read it. It's CISU, shoot, I forget what the number is. But nowhere in that policy does it state that it must be cleared, reviewed by the medical examiner's office before being released to the public or the person who's requesting the report. It only states that in number 8, that the investigative unit shall have the ultimate authority as to the final disposition of the police report. So which, to my understanding, was the police have full authority to release the report. From there, here's it's the Crime Information Services CISU Unit Order 20-18, which was sent to me from the SFPD. And like I said before, nowhere in there is any correlation between the medical examiner's office and the SFPD. And then I didn't receive the police report until probably 110 days later on January 21st, 2021. That's when I received the incident report. That I requested on October 5th, 2020. And that's all I have to say for now.
Okay, thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner, the complainant? Okay, hearing none, we'll now hear from the petitioner. Sergeant Para, you have 5 minutes. Please wait for Ms. Leger.
Okay.
Sergeant Para, you ready?
I'm ready. Okay. So first I want to apologize. I'm not going to refer to the complainant by name. I think I'm going to botch the name up. I don't want to be disrespectful. So I'm just going to refer to him as a complainant. So we were in receipt, the police department was in receipt of this complaint, alleging that we violated Administrative Code Section 67.21. We disagree with this, that we violated anything. We acknowledge that the request for the high sensitive incident report and provided the report responsive records once it was reasonable. Before releasing this sensitive report, it was a case, I think it was titled Death Report Cause Unknown. You know, we have to be vetted through both the homicide detail and the medical examiner. And there was mention who is the investigative unit. The investigative unit is the medical examiner's office. So they have to give the final say of what they determine the cause of death is before homicide may get involved or not get involved. So it's important that we get the clearance from them before we do any sort of releasing of this. So we're waiting for their approval. We received the request from the complainant, as she said, on the 6th of October in 2020. Got back to her on the 13th, basically just explaining that we were going to look into this. On the 6th, we got back to her again. It sounds like she'd reached out to the chief, and then there was follow-up by Acting Captain Dave Falzon regarding this incident. And he basically talked to her via phone and explained what the situation was. So then on the 9th, there was responded by email, a request from the complainant regarding the policies, which we gave her. On the 10th, we sent a letter to the complainant stating the investigator of the homicide detail denied the release of the incident report due to pending medical examiner's report. On the 16th, a homicide informs of the Crime Information Systems Unit that in an email that they couldn't release it. On the 18th, we gave another notice that that they were denying this. We've been continually giving updates on where we're at on this. The 10th, we gave our input to the Sunshine Ordinance. On the 24th, the homicide again informs CISU, that's the unit that issues the report, via email that the incident cannot be released because the medical examiner report is still pending. On the 25th of November, we provided an update again to the complainant via email and basically advised that the homicide has not yet received the medical examiner report. And on January 4th, 2021, we sent an email to criminal investigations or crime investigations, or the CISU, stating their family was in receipt of the medical examiner's report. And then on the 5th, homicide informed CISU that via email that their office had not received the medical examiner report. So they were going back and forth on that. But finally, we did release this report on January 21st, 2021. So they did get it. We were continually updating the complainant about what was going on with it. I'm sorry it took so long. This is not an ordinary case that we have to, this is a serious case. It wasn't a homicide, but it was a death case, cause unknown. I think when she started talking about what Lieutenant Philpott was talking about, part of it is that you need to get the clearance from medical examiner to be able to determine whether or not this could be something deemed other than just, what kind of death? Why did it happen? So I'm willing to take any questions if anybody has any right now.
We'll get there. Okay, all right. Is that the end of your testimony?
Yes.
Okay, thank you. Are any persons or witnesses provide any facts or evidence on behalf of the respondent? Okay, hearing none, members, Q&A time. All right, I have a, go ahead. Who wants to ask?
This is Elena.
Oh, Elena, you'll have to wait until the task force addresses one of the parties.
Okay, I'm sorry.
Okay, thank you. So I have a question for Sergeant Para. You refer to the CISU unit in kind of handling the paper shuffle here, and Elena had pointed out, I think it was a number referenced 20-18. I think that was it, or something to that effect. She claims that the policy does not require correlation with the ME as far as the release or the kind of the status of the incident report is concerned. You're claiming that the department can't release the report unless they have a clearance from the ME. Do you have any written policy, or can you reference a policy by number or a citation, a statute of some sort regarding that?
Well, the way I interpret it is that when they're talking about the agency that's responsible for it, or the unit that's responsible for it, it's a medical examiner's unit. That's my understanding on this. I mean, when you have a case like this, we wait for them to give the final say on what the cause of death is. So for example, if they said that there was foul play in this, then homicide would step in and do something. But the problem is that, if they don't know where this is going, I don't really know what the cause of. I don't know anything about this, what happened to it, but they release something. It could be evidence from the report that could be released to the general public. Could be a problem. They've given out evidence on a possible homicide, let's just say.
Okay, let's stop there for a second. Elena, are you a party or a family member to this case?
Yes, I am a family member.
Okay, so Sergeant Para, I think what is made clear by Elena is that she was not seeking the ME report; she was seeking the incident report. I understand you're saying that if there was some result that came out of the ME report that might affect the incident report, okay, I understand that. But what I'm not hearing is, what is the policy of the police department with regards to this? I'm hearing from you that it's just some general practice or process, but the whole department runs on protocol and law on how these documents are handled. So it's important for us because the ordinance assumes that all records are public records and they should be released, and the requirement for withholding has to be specified by citation of law.
My understanding is that if it's an open investigation, then we wouldn't release it.
But under what law?
I don't have it in front of me. Is that the 62 It's open investigation is what it is. If we have a pending case, I can release, like this case here, we were talking about this one. If this was when it's a closed case, I can release it to anybody. But if it's open, it could jeopardize an investigation. So that investigation is everything when the officers got there. It talks all about everything that was found, who they talked to. This is all the evidence that's building into that's in this case. So
I hear you.
Case is, yes, okay, I'm sorry.
I hear you on that, but and I understand that there's a process for it, but we're talking about what there are certain guardrails and guidelines that basically control exactly what you're saying. I'm asking what they are because Elena did her homework here and was able to specify that the incident report can be released without the ME report that is independent of that. And if you're going to refute that, you're going to have to refute it by some citation of law. Otherwise, we're going to assume that it was if the investigation is closed, that it can be released with or without an ME report.
I'm not going to assume that.
Okay. But that I'm just kind of repeating what is being said here between the two. I'm trying to just get clarity.
Well, right now I'm reviewing that unit order, and I don't have all my codes on this, but we routinely use a section that if it's open investigation, and I've probably seen it yourself. I don't want to quote the wrong section, but if it's an open investigation, we can't release it. So I don't know the code offhand. I'm looking at this as I'm speaking, I'm looking at this as I'm talking to you right now, but it's going to take me a couple of seconds just to read through it and make sure I'm understanding. I don't want to speak out of term, but I just know from past practice that this is routinely done. We do not, you're not going to release a homicide case, No,
I get that. And we've had those citations, made to us about open investigatory cases under the evidence code or the penal code or what have you. But I'm just hearing what I'm hearing from the petitioner's claim. I'm trying to get corroboration on your side, and because I'm confused. So I'm trying to ask questions and get clarity.
Yeah.
Not based upon what I understand, based upon what's being presented here.
Well, it says here, number 8, anytime a report is routed to an investigative unit, that unit shall have the ultimate authority as to the final disposition of this police report release. So my understanding is that a report they didn't get from the medical examiner's office would not allow them to release it based on number 8.
Okay. Go ahead, Member Schmidt.
Yeah, just on that point, Officer, would it ring a bell to you if I said that in your documents that you've submitted that are in our file, you cited Government Code Section 6254F?
That sounds like the right section to me. Yeah.
Okay, and that's which is my understanding that that's the basis for the delay in being able to produce that. Okay, thank you.
Any other questions, clarifications?
This is Member Wong.
Go ahead.
I have a question for the respondent. Lieutenant Parrott? Yeah. I'm kind of wondering also would it have been possible to release a portion of the incident report and redact pieces of it? I mean, just as an initial, response to the request.
No, that's just you can't. Anything could pop if this turned into something. Anything could possibly jeopardize the further investigation. But I know where you're going on that. I mean, depending on the severity of a report, yeah, we probably could do it. But something like this, the nature of it, we need a full approval. Really the approval comes from medical examiner in the homicide unit. You know, we really need them to say yes or no, and then we'll do a final vet of it. But we need their approval first.
Any other questions, clarifications? Okay, ready for rebuttals? Okay, I'm sorry, was it Lieutenant or Sergeant, Para?
Oh, Lieutenant.
I'm sorry, I made a mistake before.
No, that's no problem. It's okay. No worries.
So, Lieutenant Para, you are first on rebuttals. You have 3 minutes. Please wait for Ms. Leger.
Lieutenant Para, are you ready?
I'm ready.
Go ahead, sir.
So I guess just to wrap this up, I feel that we did respond back to the complainant. I'm sorry it took so long, but this is a case that there's many other agents or other units that are involved in this, and it's a serious case. And we ultimately did give the report. You know, I'm sorry to Elena that it took so long. I hope that she understands that, you know, part of this is making sure that we protect, you know, her family member on this, that if it did turn into something more, that we didn't do something that could jeopardize, you know, that investigation. So I think I am sorry for that. But anyway, that's all I really have to say.
Okay, I'll assume that ends your testimony. Okay, Elena, your turn. You have 3 minutes for rebuttal.
Yeah, I'm still. Can everyone hear me?
Yes.
Yes, we can hear you.
Okay, I'm still confused in terms of you know, what the policy says. From what I've received from the Crime Information Services CISU Unit Order 2018 that was sent over. Because again, there's no correlation that I see with the medical examiner's office to the police department in terms of the cause of death and the incident report. Those are two separate entities right there. And like I said before, I've already been in contact since the day my brother passed away, you know, since October 4th, 2020. And then it took over, you know, just back and forth between the ME office, you know, some confusion with the SFPD, police officers, not knowing that it was the report was within the homicide unit, and then receiving the report literally 100 days later. I'm still confused on how that correlates with any changes to what is going to be released in terms of the incident report. So yeah, I'm aware of what is being said about 6254 Section F to disclose the analysis or conclusions of an investigating offer. However, nothing in that division requires that the investigative files reflect any analysis or conclusions of the investigating officer. So I am still unaware of what that analysis or what that conclusion is from the investigating officers. There was no clarity on that between that timeline. Yeah, I'm still confused. Like, what evidence is this investigator convinced to, like, I think what this lieutenant is saying is under California Governor Code 6254 Section F, it says information that would endanger the successful completion of an investigation, but only when the prospect of enforcement proceeding is concrete and definite. Like, what is that evidence? I'm still unclear of that, and I'm still unclear about that policy. That's all I have to say.
Okay, thank you for your testimony. Okay, members, I have one. I just want to. Okay, Vice Chair Yankee, go ahead before.
Okay, thanks. This is just a quick question to the respondent. Kind of came up. I was thinking of it as the rebuttals were going on. At what point did you cite 6254F to the complainant? I see it in the letter. I think it was November something to the task force. But I'm wondering if you gave that citation to the original requester of the record.
Well, it's was that, are you done on speak? I didn't want to cut you off.
No, go ahead.
It looks like it was November 19th, 2020. They cited that. Let me think see if there's any other. I'm just going off this. I wasn't there at the time when this was going down.
Okay.
So, but that's what I have. I don't know if it was cited more than once, but I do. That's one they have noted on my the draft for Sunshine.
Right. The earliest I found it was, I'm looking on page, page P637. And it was the response to the task force when it's cited in that letter. So just to the task force, my concern would be.
I see what you're saying. Yeah, that's the only date I have on there. So to be honest with you, I don't know when they cited it on any of the other ones.
Right. So then to the task force, my concern would be that this very well may be a exemption worth citing, but 6727 requires justification of withholding meat to the requester, and so my concern would be that that justification wasn't produced until correspondence with the task force got involved, and that may have left the petitioner somewhat confused. And I can see that why she would be about why she isn't getting a response. It seemed to be kind of vague, just we can't give it out right now type of thing. So that's my concern. That's all I have.
Okay. Member Wong.
I guess the one other place that I see it is in the packet on P664. I think that's page 100. P664. It looks like it's a standard piece of a unit order. And it was sent by Acting Captain David Felzon. I think you see it in bullet point 2. And that is attachment 3 referenced in, scrolling up, I think it's P637. Sorry, P646. Is that correct? Sorry, it's P645. And then it says it was sent on November 6th. Which is, it's still a month past the request date, but I just wanted to point it out. And it's not specifically explained, but it is referenced in that attachment.
Anybody else? Any other more? It sounds like we've got more clarifying questions here. No? Okay. I have a question. Lieutenant Para, I'm looking on page 664. It's that P664. Do you have that in front of you?
You know what? Mine's not numbered that way, so I'm not
so
sure what you're referring to. But go ahead, tell me about the document. Go ahead.
It's page 100 out of 134. If you're looking at it as a PDF.
I don't have any of that. I have hard copies. So
this is the unit order index number 20-18 that Elena is referring to. And I'm just wondering, it's the subject says procedures for the release of police reports to the public. and it was signed by Captain David Falzone.
Okay,
Star
I have
number
it in front of me.
507. Okay,
Okay.
this is issued to the Crime Information Services Unit. This is what she's referring to here. Is this the process for this particular case? Is this the procedure that was being followed?
This would have been their unit order. So this is what they would have followed.
Right. Okay. This is what they would follow. Okay. So let me switch to Eliana. When you say that the ME's report is no correlation with regards to this this unit order, kind of like, I guess, this procedure, where in this procedure are you seeing that? Can you point that out to me?
So it only states, okay, so what I'm receiving during that time is that SFPD says they cannot release the ME or the incident report without the ME's approval. But as I'm looking at that policy, it says only in number 8 that the investigative unit shall have the ultimate authority as the final disposition of the police report release. But there's no correlation to the ME office. Like, there's no policy for that. Does that kind of make sense? There's no where it's not completely reviewed. Like, there's no incident report that's reviewed by the medical examiner's office before being released to the public or person who's requesting that report.
Thank you. Okay, do you follow where I'm going here, Lieutenant Perro?
Well, I don't know if you're seeing it the same as me, but go ahead.
Well, it's just that I'm listening to what Eliana is saying, and I'm just asking a question, and I don't have an answer. Only you folks can kind of answer that. And the question is that is the investigative unit in managing the investigation, have a requirement for the ME report in order to release it. I mean, it doesn't state in these very explicit procedure that the ME's report is needed for anything.
Well, this is a general document that's used for all different types of releases. They're not just speaking, about homicide cases. But the way I read it is different than you, because I'm seeing investigative unit. I'm thinking medical examiner as an investigative unit. I'm seeing them as being the one that's releasing it. Like, there's the burglary unit, and there's the homicide unit, and there's the medical examiner unit. You get what I'm saying? So these are all investigative units. So that's the way I see it. I may be wrong, but I just know from past practice this is how we've done it. Because ultimately makes a decision on what happens with on any of these cases with death is the medical examiner. If they deem something is a homicide, then homicide will take over. If they say it's natural causes, then it's a medical examiner case. We don't have anything to do with it.
I understand it from your perspective, but the public has a right to know. And if there are certain documents available to the public in the case of this particular order, is a procedure for the release of reports to the public. I mean, the public has to rely on it. It can't be just, in the administration of it, be, kind of laissez-faire. The public has, is relying on procedures, and the police department is kind of the ultimate front end of the law. So, I think it's making me feel a little uneasy, your response.
Well, my understanding is that this is technically it's not a closed case with homicide, so it's open with them. They're going to be the next ones to get it in line. So
right. But let me ask you something.
So they can't release it if. Go ahead. I'm sorry.
Does the word investigative unit, is that a general term for any unit that is managing an investigation, or is the investigative unit a very specific entity?
It's a generic term is kind of what I'm getting at. Like there's a homicide detail that's an investigative unit. You have a burglary detail, they're an investigative unit. You know what I'm saying? There's a narcotics, they're an investigative unit. So
it's a category.
Yeah, it's anybody that does an investigation,
Okay, thank you. All right, anybody else? Okay, okay, members. So let's deliberate and see what is there an action? So the petitioner is suggesting a violation of 6721B for timeliness.
Yes.
Yeah, we're talking among ourselves now so that we can formulate an action. So if you can just stand by for a moment, I appreciate it. Thank you.
Sorry.
Member Schmidt, I'll just put, this may be a motion that may not be the only motion, but I'll put a motion on based on, I don't see a violation here, so I would move to dismiss.
No violation.
No violation.
Okay. Second? Vice Chair Yankee?
I'm not seconding, but I'm actually thinking that there's a 6727.
Okay, wait a minute. There's a motion's been made. Let me see if there's a second. If there's no second, then it'll die. So before you move on, is there a second to the motion to find no violation?
Does it die? Is that how it works?
Yeah, if there's no second, then it dies. That's why we asked for a second. Okay, last call for a second. Okay, no second, the motion dies. Vice Chair Yankee.
Yeah, I'm thinking that there may be a violation of 6727. I'm not necessarily seeing the timeliness issue. I think that there might have to be an investigation completed, and I understand that. My concern more is that a specific reference to the government code exemption was at 6254F wasn't given explicitly to the petitioner, and I think that should have been at the outset. So I'm not necessarily making a motion, but that's kind of where my thought process is. I don't know what other members think.
Anybody else?
I just have a question, Matthew. Is that a reference to 6727 or 6724F as in Frank?
I'm thinking of a violation of Admin Code 6727 for not justifying the withholding. I'm just mentioning that it seems that the justification that they eventually used was Government Code 6254. However, that justification is not provided in writing to the records requester as a justification, which is what's required under 6727.
This is Member Wong. It sounds like a motion to me.
All right, I will make that motion. Cheryl, explicitly here. I move to find a violation under 6727 for not justifying the withholding in writing.
This is Member Wong. I will second the motion.
Okay, moved by second by Member Wong. To find in violation of 67 for not justifying the withholding in writing. Okay. Discussion. Okay, public comment. And I hand it to you, Ms. Leger, to run public comment. Go ahead.
Public comment is open. Do we have public commenters? Second call for public commenters. Do we have public commenters on the motion? Sure. Doesn't sound like anybody is providing public comment on this issue.
Public comment is closed. Any last thoughts, members? Or are we ready for a vote? Okay, hearing no objections, please call the roll.
Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Member Wong?
Aye.
Member Wong, aye. Member Forsley, absent. Member Neighbors?
Aye.
I'm sorry?
Aye.
Okay. Member Neighbors, aye. Member Highland?
Aye.
Member Highland, aye. Member Stein?
Aye.
Member Stein, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Nay.
No. Member Schmidt, no. Member LaHood? Member LaHood?
Aye. Aye.
Okay. Chair Wolf?
Aye.
Chair Wolf, aye. Moved by Vice Chair Yankee, seconded by Member Wong to find a violation of 67.27 for not justifying the withholding in writing.
Okay, thank you. Thank you for parties for attending. Please
Thank
call the
you.
next item.
Thank you.
Next item, item number 11, file number 20011, complaint filed by Ahimsa Porter Sumchai against Mayor London Breed and the Office of the Mayor for allegedly violating Administrative Code sections 6715, 675, 676 by failing to have a meeting quorum and failing to conduct business in a proper manner, failing to notice the time and the place of the meeting, and failing to allow public comment. On May 18, 2021, the Complaint Committee moved to find there is jurisdiction. The requested records are public and to forward to the task force with the recommendation of finding that there is no new information that justifies reconsidering the prior decision as requested by the petitioner. On August 17, 2021, the Complaint Committee found that the task force has jurisdictions because this is either a passive meeting body or a policy body, and that the committee believes this is a public meeting. The committee stated that the matter of the slides information that was offered by the petitioner and rejection may have been a denial of rights under the Ordinance and the Brown Act and possible denial under the state or federal constitution on the meeting of January 27, 2020.
Okay. Member Schmidt, Complaint Committee Chair, anything you want to add?
Yeah, I think it's pretty much what was just read. There was a little bit of a convoluted history on this one. It sort of bounced back and forth, partly because of the way that the documents were. It was presented as a reconsideration, and reconsideration, that water's under the bridge. There's no reconsideration being considered here today. But what was hidden in a way was under the request for consideration was a new item, which is an alleged denial that took place with regards to a subsequent meeting in January 2020, where Dr. Sumchai made a request to have certain slides shown. And even though prior to the request that she made, she asked first, may I make comment, may I submit documents? And she was told yes. And then she submitted the documents and they said, no, you can't use those. And so that's what this is specifically about. And there's a specific provision in the Brown Act about, basically we call it content neutrality when you're talking about constitutional law. And that's one of the reasons I wanted to throw in the constitutional provisions here, because the concern here was she denied that opportunity to present what she had because of the content, as opposed to some procedural or bureaucratic reason that had nothing to do with the content.
Okay, great. Did the committee address the respondents in the complaint? I mean, the respondents are the Sunshine Task Force, and naming myself as chair and naming Cheryl Leger as the clerk.
Well, I know there's a separate. At some point, there was a separate complaint, but it was much later. This right here, the way it got here is, I don't know if I necessarily need to get into this, but this specifically is limited because the task force told us, at the task force meeting, we decided we're only going to deal with this one here. And so that's what this is. That complaint against y'all was something that took place 10 months subsequent.
Okay, perfect. Okay, thank you. Just want to get clear
Sure.
of what's in the record. Okay, so let's start our regular hearing procedure here. Each party will have 5 minutes to speak on testimony. Is Dr. Sumchai present?
Yes.
Okay, and is a representative or the mayor present?
Yes.
And can you state your name, please?
Elise Vincent, Office Manager of the Hunters Point Shipyard Citizens Advisory Committee.
Okay. Before we start, Dr. Sumchai, I want to clarify. Our agenda states that it's against Mayor London Breed and the office of the mayor. Is that who the respondent is for today?
Yes, this is a organization of mayoral appointees. The original complaint is generated against Mayor to the administrator, specific administrator.
So is the focus of today's hearing on the mayor and the office of the mayor, or is it on the Hunters Point Shipyard CAC?
Hunters Point Shipyard CAC is the mayor's Shipyard CAC and our mayoral appointment.
Yeah, I understand that, but the agenda specifically says that the complaint is filed against the mayor and the office of the mayor. It doesn't specify any other party.
My complaints in this matter have always been directed towards the mayor for reasons that we to expound on. There is a audio tape in which the presenter for the initial meeting in file number 19077 admits that the mayor instructed him not to speak.
Okay, I just want to make sure it's clear, because the rest of the task force has to be able to address the right party. If let me ask the respondent. I'm sorry, I didn't catch your name again. Please repeat it.
Elise Vincent.
Are you here representing the mayor?
I don't represent the mayor at all. So Dr. Hempstead is correct that the CAC board members are mayor appointed, but we are independent contractors contracting with OCII, the Office of Community Infrastructure and Investment, and we do admin services for the board. And we were the ones that told her, anyway, I won't get into that, but
Okay.
I don't represent the mayor. I don't work for the mayor's office. It is just that the board members are appointed by the mayor. This is
Okay.
a passive, yeah.
Okay, thank you. Member Schmidt, what is your understanding here?
Yeah, I good catch on this. I'm not quite sure. Well, if it's against the mayor, I wonder. I'll ask Cheryl if you don't mind. Cheryl, does the mayor's office get correspondence about this matter? Do you know?
Yeah, in fact, I believe I sent the agenda and the notice to Hank Heckel, who has consistently represented the mayor's office. I know that Mr. Heckel has requested that I also notify Elise Vincent and Micah Fobbs, who I believe are part of the group that Ms. Vincent is representing today.
Okay, so the mayor's office has notification.
Yeah.
But they
each
are
time
not here, it sounds
Hank
like.
Heckel has showed up.
Yeah,
He has showed up.
Heckel sent a communication about an hour before the meeting started on behalf of Ms. Vincent to Cheryl Legier that I objected to. So Mr. Heckel today was involved in this hearing.
Okay, hold on a second. Vice Chair Yankee?
Yeah, I just wanted to point out that on page P700, along with Mayor London Breed, the complaint intake form also includes mayor's Hunter Point Shipyard Citizens Advisory Committee. So there was a complaint made against them. Why that didn't make it into specifically in the agenda, I don't know. But Ms. Sumchai did include them in her initial complaint form.
Yeah, I hear you on that, but I would that's why I'm asking Member Schmidt, because if you remember, this had come to us once before, got returned back to, I think this is the one that got returned back to committee.
Right. It was my understanding that this was the portion that had to do with the Hunters Point Shipyard meeting, and that was what was going back to.
I guess I'm trying to get clarification because what's on the agenda specifies the respondent as the mayor and the office of the mayor, despite the original intake form that goes back to December 2020 being for other parties. So the question I'm asking is really back to Dr. Sumchai is, is who is the focus of the complaint against at this point in time today? Is it how it's written on the agenda, or is it how it's written on the original complaint form on page 700?
This is the exact same body that I filed the initial complaint against in July of 2019 in file number 19077. It is the same body. It is the same type of conduct, and I hold the mayor's office responsible. And again, Mr. Heckel was here earlier.
Okay, so it sounds like if I hear you correctly, it sounds like that you're holding the mayor's office or the mayor and the mayor's office responsible for this, correct?
Yes.
Okay, great. So then we'll proceed under that assumption, at this point, we'll hold that to be true. Ms. Vincent, if you're not here to represent the mayor or the mayor's office, is there somebody else here present?
I'm
Somebody
sorry,
else?
but we've been here 4 times. She's always written the complaint that way, and it hasn't been a problem before. I don't know if Hank Herkel is on. The mayor's office has no idea what happened at these meetings or anything like that. She's holding the mayor office responsible because the board members are mayor appointed. But the complaint itself is against what she claims the actions of my office did. This is our 4th meeting. We've been able to speak on our behalf. I'm not understanding why it's a problem today.
Because we haven't been able to start this hearing. So we're trying to assure that we're getting the right respondent. I mean, the point is that the mayor's responsible for the administration of the Sunshine Ordinance to everything in the executive branch under her control, which includes the Citizens Advisory Committee.
So if Hank isn't on, then we are the only people representing. Excuse me. If Hank isn't on, and I am the only person here to represent.
So if the respondent is the mayor, we're going to find the mayor. If it comes to pass that the task force finds a violation, it's going to be against the mayor, not against the Citizens Advisory Committee. And you're going to be your representative.
Sure. Yep.
Okay. Then let's proceed. 5 minutes for each party. The petitioner complainant goes first. Dr. Sumchai, please wait for Ms. Leger. She'll let you know when the time clock is ready. Thank you.
Dr. Sumchai, are you ready to speak?
Yes.
You may proceed.
My name is Dr. Ahimsa Porter Sumchai, and I will try to keep my comments brief. I know that for many of you, this is not your first rodeo matter, and I have telemedicine consults that start tomorrow morning at 7 a.m. But the agenda actually cites the complaints from file number 19077, in which a meeting was held on July 17, 2019, that had no quorum started. In fact, there was only one member of the committee present, and there is videotape that I captured sitting in the front row that showed that there was not a quorum. I stated there was not a quorum, and the meeting conducted anyway, and then there were falsified minutes that were concocted that not only placed an individual in the meeting who wasn't there, but had her leading the meeting, and the minutes identified that there was business attended to, and the minutes contradicted the testimony to the full Sunshine Ordinance Task Force that was given in September of 2019, in which the respondents stated that there was not a quorum. The current incident, however, is very straightforward. I plan to attend the January 27th meeting of the HSCAC because the Navy was giving a presentation on Parcel F that included biomonitoring of fish and clam tissue. Biomonitoring is screening for toxins. There is a biomonitoring program for women firefighters in the city who have cancer, and since 2019, I have launched the first human biomonitoring program at a federal Superfund site, and we've detected a host of radioactive and heavy metals in people with breast cancer and brain cancer, and I do believe that there's been an effort to try to suppress our findings by this committee, which is funded by the developer. But I did request the opportunity to show some slides, and you have the email thread. Initially, there was an approval, and then there was a decision that was made, I believe, by Ms. Vincent. I thought it was made by Mr. Fobbs. but in which she said specifically that they would not allow me to present the biomonitoring information. So clearly this is a violation of my constitutional rights to freedom of speech. I'm also the editor, environmental health and science editor of the SF Bayview newspaper. It constitutes a violation of freedom of press, and it represents an open government violation if they are selectively allowing people to present, public comment that they accept, and they're trying to exclude people don't want to hear from. So that is essentially, what has happened. I do think that there is some disagreement about whether or not you have jurisdiction over the matter of the quorum. There was a public comment statement that found that I did file a request for reconsideration of the matter in a timely manner, and it should have been acted upon.
Does that conclude your testimony? Dr. Sunshine, does that conclude your testimony?
Yes, it does.
Okay, thank you. Are any persons or witnesses provide any fact or evidence on behalf of the petitioner, the complainant? Okay, hearing none, we'll now hear from the respondent, Ms. Vincent. You have 5 minutes. Please wait for Ms. Leger when the clock. Thank you.
Okay.
Ms. Vincent, are you ready?
Yeah.
You may begin.
Okay. So before, I'm not going to address any of the falsified documents or quorum issues. Those are all happened in 2019 and at previous Sunshine Ordinance meetings. We have concluded that matter. So I'm only going to talk about the issue of denial of public comment. The first board member who spoke, I didn't catch his name, about this and gave some background information was incorrect when he said that Dr. Hemsa, what her slides that she wanted to have during public comment were approved, and then once she sent us the information, it was disapproved because we decided we didn't want to hear that. That's not what happened. What happened was Dr. access to use our projector screen. As you all know, there is no need to make a request for public comment. She only did so because she wanted to use our office's equipment to present her slides. She submitted what she wanted to present. Once we looked at what she submitted, we granted her approval. After she was approved for those slides, she added information. There was a biomonitoring slide in her business license. Dr. Hemsa's business is in biomonitoring. We told her, and Micah sent her the email, not myself, but that doesn't matter. Our office had an internal conversation and said, it appears as if she is trying to use our equipment and our staff time to solicit business at this Navy meeting, and that she would not be able to do that. So we simply told her that she could present her original request, her original slide, and that the other slides could not be heard at this time, leaving it open for if she wanted to make another request or come back at a different time, she would be able to do so. Dr. Hemsa, in turn, decided not to show up to a meeting. She would have a case, in our opinion, that we violated her civil rights or her First Amendment rights if she turned up to a meeting and attempted to make public comment and we somehow barred her, locked her out, told her she couldn't do it, or any of that. We actually told her she was still welcome to come to the meeting and present the original documents. We have a protocol that we follow, just like you all. We cannot allow for someone to come in and request to present information, agree to that information, and then add in additional information that we did not agree to. It should be in our rights to say, no. Public comment on January 27th, we are a passive active body. We do not hear any policies or anything like that. And at that meeting, the chair allowed for public comment. Plenty of people came to that meeting and gave public comment. If Dr. Hemsa would have decided to show up to the meeting, she could have used our projector for her additional slides, and then she could have came back and talked about biomonitoring. Evidence of this is that Dr. Hemsa has talked about her biomonitoring kit during public comment at other CAC meetings. Not once has myself or any other staff person tried to silence her or has told her that she cannot talk about biomonitoring. We decided that because we felt, based off of the information she sent us, that she was trying to solicit business and that her biomonitoring program is her business. We should not be held, we should not be forced to allow anyone to use our staff time and our equipment to solicit business for themselves. But if she would have come under public comment, she could have done that. Dr. Hemsa used to be a board member. She is well versed in our rules and regulations. She knows how to contact us. We have allowed her to present to the CAC several times. She comes up and she makes public comments all the time. She sits down. If the chair allows it, she'll make 3 and 4 public comments. We have never borrowed her. We have never said she cannot come to a meeting. We have never tried to silence her. In addition, her accusation is because there's information that she wants to share that we don't want to get out to the public because it is in direct opposition to what the Navy or the developer is saying. And that is simply not true. If that was true, we wouldn't have let her present in times past. And this community board listens to the members of our community. There have been plenty of times when there was a professor in Santa Cruz who said that he had information that was in direct opposition to what the Navy was saying. He contended that 1 in every 8 people living on the shipyard was going to get cancer. The community came to this board and said, we want to hear from them. We put them on agenda. They came out. So in conclusion, thank you.
Okay, thank you. Are there any persons or witnesses providing facts or evidence on behalf of the respondent? Okay, seeing none, members, time for Q&A. And also, okay, before we start, I just also want to note, if you want to see the code that governs and created the Bayview Hunters Point Citizens Advisory Committee, is in the administrative code, and it is Chapter 5, Article 8. Okay, I've got Vice Chair Yankee, then Member Schmidt.
Yeah, and this question could be for either the complainant or the respondent, whoever might be able to help. But I didn't know if the slides that were rejected are somewhere in the information packet.
Yes, it should be. It was in the prior. It's her business license and the redacted biomonitoring report.
Do you have
Ms.
to know
Vincent is correct.
I'm sorry, you have to wait. I'm sorry, this is not a conversation. This is a question and answer that is directed. Please wait for a question to be asked of you. There'll be time for rebuttals at the end of the process. Thank you.
No, I'm sorry. He asked for either me or her to speak, and I think it was just a confusion of I spoke and then she was speaking. He didn't direct it at any particular one.
I understand, but it's also a directive to him to be specific as to who he wants the answer from. Okay?
Okay. Thank you. Thank you.
I'll ask the respondent first. Do you know the page number of the rejected slide?
I don't have that in front of me. I don't. I can try to look it up, but if Dr. Hemsa knows it, I'll let her answer.
Okay, Dr. Simchai, do you know the page number in the attachments of the slides that you wanted to present that were not allowed?
But I need to clarify that Ms. Vincent is incorrect. I did not submit my business license. I submitted a biomonitoring slide screening. Are you listening to me?
Yes, that's why I'm asking, so we could actually see. So if you could tell us the specific page number
The
of what...
original story was that they denied me because they had concerns about HIPAA privacy issues. And when I submitted to you the screening that had been cleansed of PHI, then they changed their story. The fact, again, is that the Hunters Point Community Biomonitoring Program is a 501c3 public benefit nonprofit. I am not paid, and it is invasive for them to suggest that
Ms. Sumchai, please, Dr. Sumchai, Dr. Sumchai, we're asking for very specific questions so we can get clarity, okay? You provided us with a lot of documentation and some testimony. There's some questions that we want to ask. We'd like some answers. All Vice Chair Yankee is asking for is a page number, so he can see.
Page number, and I've submitted information repeatedly. At the last meeting, subcommittee meeting, I submitted to you a copy of the screening that I had submitted, as well as a copy from the Navy's document showing that the Navy was presenting biomonitoring information. That's why I added the biomonitoring slide, because I read the Navy's report. That was not my intent. My intent was not to be there to promote my business. And in January of 2019, the chair of the committee interrupted me when I was trying to present my information on biomonitoring. That is also not true.
Hi, I believe I have the page number. I think it's page 713. Let me check that out.
He's 713?
I believe so, yes.
All right. Thank you very much.
Okay, Member Schmidt.
Thank you. I've got a couple of questions for Ms. Vincent. This is Member Schmidt. I was trying to listen real carefully, and I need a little bit of clarification in terms of two things. One is, you said that you were given a copy of the business license. Are you saying that one of the proposed slides was a slide of her business license?
Yeah, I am.
Okay.
So the original request was not that, and then she submitted that after we said yes.
Okay.
Along with the biomonitoring report.
Okay,
there may have been one other slide, but I don't. Yeah.
Okay. So you remember the business license slide and the biomonitoring report slide, and there's possibly a third slide, correct?
Yeah.
Okay.
Yeah.
Now my other question, Ms. Vincent, is now, just to be very clear on this, when she was giving you these slides and asking to be able to put those slides forward in that hearing, was this about doing it during a public comment session, or was it about putting it on as another part of the hearing, which is separate from the public comment section of the hearing?
It was about the public comment section.
Okay, so
she wanted to use our equipment. That was the only reason why she asked. So.
Oh, okay. So she was sort of ahead of time. She was trying to be ready to put on her slides during the pre-scheduled public comment part of the hearing, correct?
I'm confused about what you mean by pre-scheduled. The only reason why she asked, so public comment is public comment. People come up, they talk about, things on the agenda or things not on the agenda, right? During those different sections. The only reason why she made the request is because she wanted to present slides, and she needed our equipment to do that. And so we said yes. to the original slide so that she could present that information. And so I don't know what you mean by pre-committee. I assumed once, if she would have showed up, we would have, at the chair's direction, either had her present her, had her first a public comment so she can do that, or work her some way in. But there was no pre-selection. Does that make sense? It was just public comment.
Yeah. And I know that when I ask you this, it's probably not necessarily clear how I'm asking it, but there's certain rights that the public has to present public comment, and for example, in the Sunshine Ordinance. But that's a very specific type of thing that happens at certain times during a public hearing. Now, it's unclear to me, not necessarily because you did anything that made it unclear to me, but I'm just trying to make sure that I've got this figured out. Was it during one of those required public comment parts of the meeting that she was asking ahead of time to be able to put her slides on? Or was she trying to be actually a presenter at the meeting during the sort of the main part of the meeting, as opposed to a public comment section of the meeting?
So I can't speak to the operation of her mind and what her intentions were. What I can say is it was during the public comment section on agenda related on the topic, right? So we had the topic, the Navy's presentation. They were the only thing on the agenda, and then outside of the regular minutes and all that stuff, they were the only presentation on the agenda, and then there was public comment on the agenda item. He wanted to present at that time. I'm assuming because whatever she wanted to present, she needed to be able to show the public what she was talking about.
Okay, that's exactly what I was trying to find out. I thank you. Now it's very clear to me. I appreciate your time on that. That's all the questions I have.
Member LaHood.
Yes, thanks for being here. So why did you review the slides ahead of time? I guess my question is, why did you review the content of the slides ahead of time if they were meant to be part of public comment?
So because she was asking to use our equipment, right? And so, for example, if someone says, hey, I want to present something, and they want to have a visual aid to our meeting, for all we know, they could be putting up pornography, right? I hate to be that extreme, but that could be the case, right? And so we didn't take a hard look at it. We just said, okay, and during, to answer the question, the previous question, it was during public comment on the agenda item. So that particular section, the things need to be relevant to that agenda item. We have another section of the meeting that is public comment on non-agenda items, where people can say whatever they want to say. So when we saw that it was simply, okay, it's nothing inappropriate, nothing that we can get sued over, nothing, no pornography, no whatever, fine. It's relevant to what the agenda is about, yes, absolutely, you can present this information.
So here's, I guess the thing that I'm a little bit confused about is that these are images. It was not the text of a presentation. And I understand reviewing slides ahead of time for something objectionable, as your example, if it was pornography, I don't think we would be having this question. But you judged the content of what she was going to say based on the images there. It seems to me that you don't actually know what she was going to say about those images. And a picture of a business license, who knows what she was going to say about it?
So I want to be very clear. Her original request, we did not do a hard review. They weren't images. They were simply they were informational. There were stats. There was numbers. I can't, I'm looking at it right now, whatever. But they were actually so I didn't know what she was going to say. Yet we still approved it. right? We didn't know what she was going to say. But when she submitted the biomonitoring information along with her California state business license and another
it's a medical license from the medical board, and I didn't present that to you. I added that was part of the email.
Hold on. I'm asking the respondent a question, and she was just answering.
So the way we read the email and interpreted the email from the additional slides that she said she was going to also include and gave us then the order in which we should put the slides in, we in our office looked at it, and she mentions the license in another email, and we said, one, this looks like it could, because we don't know what she's going to say. We don't know if she's going to expose anyone's biomonitoring, like their actual medical report. Two, this appears to us, I have no idea that the biomonitoring is a nonprofit or any of that. It appears to us that she is trying to solicit business, be it private, nonprofit, whatever. And so at this time, we left it open. At this time, we're going to say no to this part. Your original request is approved. And again, I'm going to say for the record, we kept no one from making public comment. If Dr. Hemsa showed up to the meeting, she could have made her public comment. It would be a different case if we had told her, no, you cannot come. Or that if we tried to actually stop her once she was at the meeting trying to make those public comments. We didn't do that. She decided not to show up.
Okay, thank you. You've more than answered my question. Thank you.
Can
Go
I
ahead.
please statement?
I follow-up questions are the, unless I'm
Go ahead.
unless okay.
No, you're not.
Yeah. Are you saying that if she had come in at the time of general public comment, she could have shown her slides?
She was granted permission to show her original slide. Even when we told her that those additional 2 or 3 slides that she added, that we weren't going to use our equipment to do that, we still told her you're welcome to present your information.
But not the slides that you rejected. She wouldn't be able to put those on in general public comment, right?
Because no.
I think you said that.
Unless we couldn't use we couldn't use our equipment to do that.
Okay.
But we had a conversation, whatever, we didn't keep her from making public comment. She didn't show up to a meeting.
Thank you.
Yeah.
Now, quick question for Dr. Sumchai. This idea that you presented a potential slide that contained your business license, did that occur? Is that true?
No, it is the Medical Board of California licensing of the clinic as a screening clinic, and it is embedded in the email. The other thing I must clarify is that I was adding the biomonitoring slide because the Navy presentation on parcel F included biomonitoring information. She is incorrect. My information was added after I read the Navy document. And the other thing is that.
But why did you want them to put up a slide? No. You answered my question. Why did you want them to put up a slide of your business license? What's the purpose of that?
That isn't the issue. I'm saying
no. Please. No, that's my question though. Is why did you want to put your business license on one of these slides?
Wait, it is the Medical Board of California license for a medical clinic, and it was not. Clinic. I wasn't requesting that. That is simply embedded in the email.
So there was no slide. There was no slide with your medical license that you submitted and asked to be put up.
There was not.
No slide.
That was not the issue. And the protected health information had been cleansed.
Yeah, that I understand. I just wanted to know
In that,
If there was any
now to
slide that
change
had your
your
business
story.
license on it. Yeah, okay, thank you.
Okay, any other questions? Okay, I have one. Ms. Vincent, can you explain that your organization, you have some organization that runs or manages the CAC, is that correct, or did I hear that incorrectly?
I'm sorry, I didn't make out what you said. Can you repeat it?
Yeah, you mentioned in your introduction that there's some organization that you're with or some company that runs or manages the CAC. Did I hear that incorrect?
Yes, that's correct.
And what's the name of that organization or that company?
So we are contractors. We are under MJF and Associates. We have a contract with the OCII, Office of Infrastructure and Investment, for former redevelopment agency. So we're independent contractors, and
Okay,
the
so you're
prime contractor is MJF and Associates.
MJF, Frank?
MJF and Associates, yes.
Okay.
Funded by the developer.
Okay, please, Samchai. The questions are not helpful. And what is your role with the company and with regards to, and your role with the CAC?
So I am the office manager. What our office does two primary things. One is we give access to the shipyard. The shipyard is under development. It is a formal Navy shipyard, and so there's restricted access on the base. And so there are passes that we make that says these people have authorization to be here for various purposes, right? So that's one part of our job. The second and the most important part of our job is that the Citizens Advisory Committee board is a volunteer board. So what we do is their admin. And what I do as the office manager is manage the day-to-day operations, but more direct with the CAC board is I facilitate the meeting. Well, the chair facilitates the meeting, but I run the minutes, I put out the notices, all presentations, presenters, whatever, come through me. I set the agendas along with the chair. So that's what I do. I basically put out create the information to be sent out to the public.
Okay, so let me ask: Are you also a member of the CAC?
No, I'm not.
I'm looking at an agenda that says Doris Vincent. Is that you?
That is my grandmother.
Oh, okay.
But
that's a relation to you. Okay, great. And another question: you mentioned at the beginning that you're a passive meeting body. Is that correct?
Yeah. Yeah.
And who notified you of that?
So under the Sunshine Ordinance, we are considered a passive acting body. I don't have the regulations in front of me. It was started by Mayor Jordan in 1993. We don't look at any policy. We don't hear policy. We don't advise on any policy. We don't recommend any policy. That's not what the CAC does. And your board actually made the first claim that Dr. Hemsa brought to us, made the determination that we were a passive active body.
The Sunshine Task Force did?
Yeah.
And what year was that?
That was, what was the first complaint in 2019? The very first complaint that Dr. Hemsa submitted against us. I don't have the date. I'm sorry, I don't have the date in front of me.
Okay, so
the case was dismissed, and they found that they didn't have jurisdiction. They found that we were a passive active body, and they dismissed the case, to my knowledge. Micah presided over that one, but that's, yeah. Okay,
because I was just reviewing that, and it actually got created in 2013. It was an ordinance presented by Supervisors Cohen and Campos. It was approved by the Board of Supervisors and signed by the mayor.
I'm sorry, what was created in 2013?
The ordinance creating the Bayview Hunters Point Citizens Advisory Committee.
No, so that's a mistake. There is the Bayview Hunters Point Citizens Advisory, and there is the Hunters Point Shipyard Citizens Advisory Committee. We are the Hunters Point Shipyard Advisory Committee. That was started in 1993 by Mayor Jordan.
Okay, my apologies on that. Okay, any other questions, clarifications? Okay. Yes, Vice Chair Yankee.
Oh, sorry, that was me accidentally clicking that.
Oh, okay. Very good. Okay. If we don't, are we ready for rebuttals? Okay, let's do it. Ms. Vincent, you go first. You have 3 minutes for any rebuttals. Please wait for Ms. Leger.
Ms. Vincent, are you ready?
Yes.
Go ahead, please.
So I guess I've said pretty much everything I wanted to say. Dr. Hemsa, when she first submitted a claim against us to the Sunshine Task Force, to present day, is still a welcome to the Hunters Point Shipyard Citizens Advisory Committee. No one has personally tried to keep her from presenting any information she has presented in the past as it relates to this matter. Public comment, because we're a passive active body, is held at the chair's discretion. She allowed for public comment. There was much public comment at that January meeting. If Dr. Hemsa would have come to the meeting, he could have presented her information. We went off our own interpretation of her presenting her the state's acknowledgement of the clinic, which is a license to me, and the fact that prior and meetings prior that she has come during public comment with biomonitoring kits, talking about the business that she is affiliated with. And we said, while we allowed her to do that then, and we'll allow her to do that in the future, we would not allow for her to do that using our equipment, as well as not knowing what she was going to say and could possibly release anybody's medical information. So I think she would have a case if she came to the meeting and we tried to stop her. She's very familiar with our process. She has made public comment to our committee multiple times, and multiple times at one single meeting. And so no one tried to keep her, no one barred her, and we did not deny her access to making a public comment. That's it. And we submitted information to the clerk with additional information on this case.
Okay, very good. Thank you. Okay, Dr. Sumchai, you have 3 minutes for rebuttal. Please wait for Ms. Leger. Thank you.
Dr. Sunshine, are you ready?
Yes.
Go ahead.
On July 19th, 2019, I submitted a complaint, file number 19077, and that complaint had two major issues. One, that the meeting that is being referenced was conducted without a quorum, and I have offered you documentation that the meeting was conducted without a quorum. And at the time that the matter went before the full board in September, the videotape that I documented had not been included. The second issue was that despite all of the meetings that Ms. Vincent has told you about that I've attended off and on for 20 years, I did not receive a notice for this meeting either as a stakeholder with multiple reasons to be there and as the Health and Environmental Science editor of the SF Bayview. The SF Bayview was not noticed about this meeting, and there were about 7 people in public comment who documented that they were not invited to the meeting, and I have given you evidence of a videotape and an email thread in which the keynote speaker, Dr. John Balmes, admits that Mayor London Breed told him not to speak to me, and that the 4 scientists of this committee were asked by the mayor to meet in private, and that these represent state meeting law violation. So for the second time on January the 27th, I was denied an opportunity to speak and to present relevant slides during the public comment period. You have the email thread. Initially, Micah Fobbs approved my slides, and then he came back and he said, well, actually it was Ms. Benson. I thought it was him, but she said that they would not allow me to present slides on biomonitoring. So I did not show up to the meeting because this was the second time that this group had insulted me professionally and denied me the opportunity to participate in a matter that I was clearly a stakeholder in. Ms. Vincent is also incorrect in stating that there were potential HIPAA violations, and she is also incorrect in stating that the information that I was presenting wasn't relevant to the Navy's presentation. It was directly relevant. The shipyard CAC has violated sunshine laws. It has violated my constitutional right to freedom of speech, and it violated my right as a newspaper editor for the only community newspaper in this community to speak. And I think it's very, very clear cut to me. But I also want to point out that there are faming comments that have been made about the work that I'm doing as a medical doctor in an underserved a community with a clinic located within 6 blocks of a federal Superfund site. I resent first that this is a business enterprise like the work that she's doing, which is a business enterprise funded by the developer.
Okay. Thank you, Dr. Sumchai. Thank you. Okay, members, the matter is with us now for deliberation and action. There's no discussion, deliberation. Is there a motion?
All right, I'll start the discussion. I was curious, so I did look at page, I think it was 713. I believe it was the respondent who gave that as the page where the slide that was disallowed. And I'm noticing on it that this seems to be some type of patient's lab test results. My concern on this would be that there's the patient's full date of birth, their gender, and their medical record number, which is very clear on that. And I'm not sure under Prop B, which protects privacy rights, that city equipment should be used to give that type of personal information out. That seems to be rather protected. And if that were me, I certainly wouldn't want my date of birth, medical record number, and lab results being broadcast using city equipment. So if that's the slide that was disallowed, I would agree that slide should be disallowed.
I was under the, I'm sorry, go ahead, Member LaHood, and then I'll respond.
No, please go ahead first. It sounds like you had a.
I just wanted to say I'm not sure that's what Prop B was referring to. Prop B was about the sharing of information by contractors from the city of information that beyond the scope of their contract. So if they were allowed to collect name, address, and telephone number, and they collected additionally, a picture or some other information, the only information that they could share would be name, address, and telephone number. Otherwise, they'd be in violation of Prop B. Now, I understand the point at this point, whether it's we're talking about the use of a company's equipment, but that equipment is being used for the purposes of the government body. So, it's really within the realm of the government body at this point. Doesn't matter where they got the equipment from. It's their use during the time of a public meeting. So whether it's appropriate or not is another point. I agree. It is a little disturbing to me that if the MRN number was also redacted, then and the order number was redacted, probably wouldn't have as much of a problem with this. So I do find it to be somewhat, kind of. It shouldn't have been revealed like that without at least the permission of the person whose record this is. Member LaHood, go ahead.
Actually, I'm curious now. Is it possible to ask another question, or do we know whether permission was given?
You can, yes.
Dr. Samchai, can you tell us, was permission given by
and release of information, and the medical record number is the number for the lab. It is not the patient's private medical record. It is a number that is generated by the lab, but all of the screenings that are conducted are conducted with a full consent and a release signed to me and to the Hunters Point biomonitoring program.
Thank you. So that medical record number then does not connect with any other medical record. So the only identifiable information are the gender and birth date.
Yes. So that is the lab assigned number.
Thank you.
And further, what about the order number? Can that be traced to any particular person?
No, that is simply the the number that's assigned for the specimen as it comes in.
Okay, thank you, Member Schmidt.
Yeah, well, that would have been interesting if the medical record number was the patient's number, but if it's not, I mean, the birth date, maybe, I don't know. Although I'm also more of a question that I have that I can't quite, I don't know which side of this we fall on, but if it's not a policy body, and it may not be a policy body, then we can't use, was it 67.15 or 18? And I can't, looking at the policy body standards, does anyone have any thoughts on that one, on this?
Well, I think we did deliberate. I don't recall it, but I believe we did deliberate on this, that it was a passive meeting body. I'm not able to quickly find any information regarding that, but I'm also not able to find any reference to the CAC in city code, in the administrative code or what have you. There's all kinds of information around the Hunters Point shipyard, and there are other CACs that I mistakenly brought out also that was based upon that. I haven't looked through the Legistar search either. I don't want to take up too much more time here. But if this was deemed as a passive meeting body, as was reported, then you have to look at 67.4 to start as to what governs the conduct of a passive meeting body.
Yeah,
there's no.
Yeah, that's one of the reasons I'm kind of on the fence on this thing. I don't know what I don't know if I were to try to say, hey, let's do this, I can't think of what I'd do here.
I don't think Trump's my right to freedom of speech and press. I don't think whether it's a policy body.
It makes a difference because the ordinance, first of all, passive meeting bodies are a unique entity only to San Francisco. And under the Sunshine Ordinance, a passive meeting body is not required to provide public comment. It may, but it's not required.
Well, if they do it for everybody else and they deny me, then it becomes a discrimination.
I agree. Then that's a different question. If they did allow public comment and then deny you, yes, then definitely is definitely within our ability to adjudicate that. Let's go to Vice Chair Yankee.
I just wanted to, I found the initial meeting minutes where this was discussed. We never did decide whether or not it was a passive meeting body or if it wasn't, but I noticed it said at the bottom, this was the December 4th, 2019 meeting minutes. The last paragraph of it says, Chair B. Wolf requested that the SOTF Deputy City Attorney provide advice on the status of the advisory board of Hunters Point Committee for future reference in determining conclusions for other similar types of bodies. So I don't know if we ever received communication from legal counsel on this, but I know you did request it, thinking that this issue might come up again. So maybe our legal counsel could speak to it. I'm not aware of any subsequent communication.
At your last committee meeting, you decided that you would look into whether this was a passive or a policy body. This acts as a policy body.
Yeah, but how they act and what they are two different things. I mean, we've had advisory committees act. We've had subcommittees that acted like advisory committees, but they were really policy bodies, and they didn't know it. Okay, and vice versa. So it really. It's hard to put a scenario together just because they're operating as if. The question becomes if their bylaws specify that they are operating in a certain way, then they're operating that way. If they violate their bylaws, that's one thing. That's actually not in our jurisdiction with regards to how their bylaws. Our jurisdiction is if they're a passive meeting body, they get to do this. If they want to do more than what is required at their minimum for a passive meeting body, then they're free to do that. But if they're truly a policy body and they're acting like a passive meeting body, then that's a different that becomes a different issue. Member Schmidt, do you have something else?
No.
Okay. Right, and that I don't know if we actually got a response that I
like it, and it's something the city attorney's office could very.
Yeah, it would have to go back to where the advisory committee got created in history. And I'm sorry, Ms. Vincent, when can you provide that history?
We sent our bylaws and all our information of our creation to the clerk's office, and we spoke on this last time, but it was created in 1993 by Mayor Jordan.
Joe Jordan, right, okay. I recall you mentioning that earlier. I'm sorry I didn't recall that. Thank you. All right, anybody else? Is there a motion? Is there a motion? Is there a motion?
I'll offer the motion.
Okay. Member Schmidt.
I move that we find single violation of 67.15D. Abridging / prohibiting public criticism of a policy body.
Well, if it's not a policy body, then that can't apply.
I know. That's implied is that the ruling would be that it's a policy body.
But we're not a policy body. We don't make any policy. That's not. You can't change what we are to fit your needs.
Ms. Vincent, as I explained before, sometimes there's confusion as to what is and what is not a policy body, and despite what activity they do. One example would be the Building Code Review Committee thinks that it's an advisory committee, but it's not. It's a policy body. So it had to change its entire bylaws because it was created by the Planning Commission. Absolutely a policy body. But we
weren't planned. We weren't organized by the supervisors. We weren't organized by any commission. We don't hear policy.
But if you were created by the mayor and it was done by ordinance, then you would be a policy body.
What does a policy body do? Where's the confusion?
I'm not going to argue with them about what.
No, I'm not arguing. I really want to know. I'm just curious. Okay. I don't understand it. It's not an argument. I'm asking a legit question. What is it that a policy body does?
I'll answer the question, but by a matter of process, we're right in the middle of an action, and it's a little inappropriate to.
Right, but you guys let Dr. Hempster interrupt over and over again without saying anything. That's not fair.
No, I did. I had asked many times not to interrupt, but I am going to just declare right now I've asked. We have a motion on the floor that cannot be interrupted. So let me get a second, and if there's a second to the motion, or if there's not a second, and the motion dies, then I'll answer your question. Is there a second to this motion? Going once, going twice.
I'll second it because I think we need to move forward with this.
Okay, so moved by Member Schmidt, second by Member LaHood. Now, I'll answer your question. A policy body, the determination of policy body is very clear. It's not a matter of what activity they do, but it's how it got created and including who they report to. And 67.3 is very explicit in bullet point fashion about each different kind of body and how they get created, okay? And so, you know, there's a difference. If any group meets to discuss or advise the mayor or any department head on fiscal, economic, or policy issues, that's a passive meeting body. So if the Urban Institute, which is not created by government at all, but they're just a group or an organization out there, meets to discuss and advise the mayor, that meeting is a passive meeting body, okay? A policy body, on the other hand, could be one out of 6 types. One type could be any board, commission, committee, or other body created by an ordinance or resolution of the Board of Supervisors. Or another type of policy body could be any advisory board, commission, committee, or body created by the initiative of a policy body. Okay, so there's many different kinds, but there is a difference between the two as to what they are. Again, under a passive meeting body, could be an advisory committee created by an initiative of a member of a policy body, the mayor or department head. So that's why I'm asking, like, how did it get created? Because that then determines whether it's a passive meeting body or a policy body. Now, we're going back to 1993. There weren't electronic documents. Everything was done on paper. And so it's not necessarily online to be able to find that. I've done, as this discussion and this hearing's been going on, I've been trying to search around the city codes, every single city code. I can't find a reference for Shipyard Community Advisory Committee, unless it's buried somewhere, but it's not showing up in any search. And I've looked through the Legistar search, but that only goes back to 1998. So that's for electronic documents. Before that, it's going to be in hard copy and some binder probably in the clerk's office. So I think that's why we had asked our legal counsel to look at that. Members of the task force, if you feel
that, but the 2 examples you gave, we aren't any of those. And I guarantee you, if you go down to the other 4, we aren't any of those either. It's mind-boggling how you can try to make us a task force. You can't make. a policy active body. That's not what we are. It was created by a single act of a mayor, an ordinance to make us a passive active body.
Right, and we're asking for evidence of that.
So if you can't,
Chair Wolf,
like you said,
point of order.
It was all
point
written out. So access to the attorney, you can't make a determination without getting that information. You can't just arbitrarily make us something that we're not. That's not fair.
I did not arbitrarily make anything. I'm asking for evidence in order so that we can make a determination. All right, so that is not necessarily on the table at the moment. Right now, we have a motion on the floor that was moved by Member Schmidt, second that's a motion on the floor. No judgment. It's up to deliberation and a vote. And public comment and then a vote.
Are we moving to public comment now, Chair Wolf?
Hold on. Members, or any deliberation? Vice Chair Yankee.
Yes. Not being able to find, and I've looked as well, any reference to this in code. makes me believe that it was not an ordinance or something, enacted by the Board of Supervisors. There's been testimony that it was done by initiative of the mayor. There doesn't seem to be any real evidence that it's either a policy body or a passive meeting body. If what the respondent says is true, that would make it a passive meeting body. I haven't seen any evidence that it's a policy body. I would feel uncomfortable voting as if it were without seeing such evidence. And on top of that, I'm not sure that this was a case of the complainant not being able to criticize the body. It sounded like she wanted to put up certain slides. And again, looking at the slide that was referred to us, I think that there's certainly a level of personal information, medical information in there that would make me feel uncomfortable. And it wasn't particularly clear that this was some type of releasable or consented type of thing. So I don't feel comfortable personally voting for this motion.
Not to be like, not really on that point, but I just want to point out implicit in my motion is the idea that we don't really have any party here who has a burden of producing evidence. And it's certainly not Dr. Somchai's burden to produce evidence to prove the nature of what this entity is. And so we're here to figure out which way do we go. And so that's not a big, heavy burden. It's somewhere in the realm of, say, 5149. So that's part of why I feel okay with this motion still. But I'm ready for vote it up, vote it down, whatever it goes.
Okay, anybody else?
I have a constitutional right to freedom of speech in the United States of America, independent of the box that you put a government organization.
Dr. Sunshine, please, it's an interruption. I'm not taking any more interruptions because we've got a lot of other business to do. We just need to move on through this and get to the end. Let's call public comment. Pass it on to Ms. Leger. *6 will unmute yourself. This is for public comment for everyone other than the parties.
Public comment on the motion. Do we have any public commenters?
David Pilpel.
Do we have other public commenters? Mr. Pilpel, it looks like you're the only public commenter.
I apologize for that.
Are you ready to speak?
I think so. Parts of me are still awake. Okay, David Pilpel. This is on item 11 on a particular motion. So I've been listening to the last 20 minutes. I tuned in again. I believe I heard part of the discussion when this was in committee based on the last representation that I heard from, I guess, the respondent's representative and some of the discussion you just had. It's not anywhere in city code. I did find the website hpscac.net. Under About Us. There are the bylaws, there's the roster, there's the history. I am pretty well convinced that this was created by Mayor Jordan in 1993, that in as much as it advises the mayor and others on policy, that it is a passive meeting body and thus subject only to section 67.4 as relevant here, 67.4A. A3, such gatherings of a business nature need not provide opportunities for comment by members of the public, although the person presiding may, in his or her discretion, entertain such questions or comments from spectators as may be relevant to the business of the gathering, period. I don't believe that this body is a policy body. It sounds like it is a passive meeting body. 67.15 does not apply. And like it or not, the person presiding in his or her discretion can entertain questions or comments and or not. And it seems like, however unfair and unreasonable it may or may not have been, that there's probably no violation of the nature alleged. I'm happy to explain further if anyone cares, but I'd like to hear a little bit on subsequent items before I totally fall over here. Thanks.
Any other public comment? Okay, public comment is closed. Any last thoughts, members?
I withdraw my motion and substitute a motion which, instead of relying on 67.15, it refers to 67.4, and it does find a violation in that when you do allow people to speak, you can't, in any governmental entity, when they do allow people to speak, they can't select based on the viewpoint of speakers, and I think that's what happened here. So that's my substituted motion. That would not require that it be demonstrated to be a policy body.
Okay, so is there a second?
This is Member LaHood. I'll jump in. I like this one better. I'll second the motion.
Okay, so the motion is moved by Member Schmidt, second by Member LaHood, to find a violation of 67.4 for what was your words on that? For select, being selective on
violating oh boy, geez.
When you do allow people to speak, they can't be selected based on the viewpoint of the speakers.
Yeah. It's not a 67.15 violation, but I'm going to say it's a 67.4 violation by not allowing her presentation and choosing to disallow her based on the substance of the presentation.
Okay. All right. Again, public comment. Oh, Member Wong, sorry, before public comment.
Member Schmidt, sorry, just could you clarify which subsection of 67.4?
I am going to say it is the, actually, I'm trying to find it. Mr. Pelpel just read it to us.
A. 67.4A.
A3.
Yeah.
David Pelpel.
Yeah, A3. That A3 was not exercised in a neutral manner, and that's a violation of the proper exercise of A3. That's
There you
my
go. I like that wording better. Okay. Public comment.
David Pilpel again.
Hang on. You ready, David?
I think so.
Go ahead.
Not my finest hour. All right. Again, due respect to Member Schmidt, I appreciate it, but 67.4A3, second portion, although the person presiding may, in his or her discretion, entertain such comments or questions from spectators as may be relevant to the business of the gathering. In my opinion, I think that allows pretty total discretion to the person presiding to decide what is relevant to the business of the gathering and entertain such questions or comments as he or she decides. It doesn't say subject to appeal to the body. It doesn't say or suggest that it's subject to an equal time rule or that viewpoint discrimination is allowed or not allowed. It reads, in my view, pretty clearly that it's the presiding person's discretion. If the complainant here wants to bring a legal action and allege some other legal basis, which may or may not be the case, that's fine, and I'm not arguing one way or the other there. I just think that it would be difficult for this task force to find a violation of 67.4A3. I think it gives a lot of discretion in that language, arguably all discretion to the person presiding over a passive meeting body as defined. Whether we like it or not, I just don't think you can read more into that about the conduct in general or the conduct at issue here.
The administrator,
I'll just leave it at that.
The deciding officer is not clear made the decision. The administrator made the decision.
Well, okay, well, even if that's the case, it's ultimately the members of the body that had an opportunity to say, no, that's not how we want to do it. Or if the administrator is running the thing and with the consent of the members, then that's how they're doing it. I haven't read through all the details of the bylaws. It's too late, and I'm too invested in other things. Look, I have nothing against the complainant here. I have no vested interest in this. I just want to get to other items. I would urge a no vote on the motion before you. Thanks.
Any other public comment? Okay, hearing none. Are we ready for a vote? Okay, please call roll.
Just a second. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Forsley, not present. Member Neighbors?
Nay.
No. Member Neighbors, no. Member Highland? Member Highland?
No.
Member Highland, no. Member Stein?
Nay.
Member Stein, no. Member Wong?
Aye.
Member Wong, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Vice Chair Yankee?
No.
Vice Chair Yankee, no. Chair Wolf?
No.
Chair Wolf, oh, the motion failed.
Okay, so here's what I'm going to suggest. We already have a request of the city of our legal counsel at City Attorney's Office to provide some insight as to what the nature of this body is. I'm going to reinstitute. Sorry about that. I'm going to reinstitute a request on that, and if it's significant to me, I will send it to a committee for a second set of eyes, and see what the committee, if they want to make a recommendation. I'll leave this this complaint open until then. If it's found to be a passive meeting body, then we can decide whether to close. Whatever the outcome is, we can decide whether to close it or to continue to take action. So basically, we're continuing this item to call the chair.
Is that a motion?
Yeah, I'll move that. So it'll be a motion. I move to continue this item at the call of the chair, pending the results of a research by our legal counsel at the city attorney's office, and upon review of myself and by a committee of my choosing, and based upon the recommendations of that, we'll bring it back to a task force hearing sometime in the future, and take the issue up there. With regard specifically to the points that the motions that were being made by Member Schmidt and seconded by Member LaHood. That sound okay? All right, great. Is there a second?
Second.
Second by Member Schmidt. Any discussion? Okay, public comment. Okay, hearing no public comment, is public comment is closed. Are we ready for a vote? Any objections? Hearing none, please call the roll.
Just a second. Chair Wolf?
Aye.
Chair Wolf, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Forsley, not present. Member Neighbors?
Aye.
Member Neighbors, aye. Member Highland?
Aye.
Member Highland, aye. Member Stein?
Aye.
Member Stein, aye. Member Wong?
Aye.
Member Wong, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member LaHood?
Aye.
Member LaHood, aye. Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Moved by Chair Wolf, seconded by Member Schmidt to continue matter to the call of the chair, pending the results of research by our deputy city attorneys, and upon review by Chair Wolf and a committee of his choice, and the recommendation to return to the task force hearing in a future date and take up the issue there. With regard to the points that the motions that were made by Member Schmidt and seconded by Member LaHood. This motion, okay, seconded by Member LaHood, that's it.
Right. The motion is approved. Okay. Thank you for bearing with us, parties. I appreciate your diligence and your thoughtfulness. Have a good evening. Please call next item.
Item number 13, State Bills AB 339, AB 703, SB 16, and AB 361. Report from the City Attorney's Office.
Okay. I don't know if DCA Castillo is still here.
I'm still here.
Oh, marvelous.
Hi.
Appreciate it. Okay, you're up.
Okay. Well, you asked for legal opinions, but given the fact that some of these items have only just passed or been signed into law by the governor, we don't yet have those. I'll start with AB 361, which was discussed earlier under 1A, agenda item 1A. Similar to AB 361, AB 339, that has not been signed into law by the governor yet, but it's very similar, and it provides for public boards to provide, it requires that the public boards provide virtual access for public events, even if all board and council members attend in person. So that's what that legislation is about. Is this, you want me to go over the various legislations to just give a little background? You've already had the legislation, so I don't know if that's a waste of your time.
Yeah, so there are a number of items here. You have 339, 703, SB 16, AB 3 and 361, which we already spoke about. Right. So is there anything to, have you reviewed 703 and SB 16?
Well, 703 is still in committee. It has not been approved or signed into law. And okay. SB 16 was just signed by the governor into law. So that, I believe it doesn't go into effect immediately, but AB 339, 703, and SB 16 we're monitoring it, and to the extent that they just went into law, and it impacts the entire city, not just the Sunshine Task Force. I believe the city attorney will be preparing some sort of a legal memo or advice on these, but I'm happy to go over, just the summary of what some of these legislations entail. If you like, but given the late hour, I don't know if that's necessary since you've all had the legislation, but I'll do what you want.
I think with regards to any of these, if they affect on how we make decisions about how city meeting bodies are operating, based on, any new compliance issues that we are currently not aware of, we'll need some, continued guidance if and when those issues come up in complaints.
Right.
Kind of in the same way.
Yeah.
Go ahead. I was just going to say, kind of in the way that we're dealing with the public records disclosure that got put upon police departments.
Right. So I was going to say it's similar to what occurred after AB 361 was passed and went into law. Our office will provide a similar memo that impacts the entire city, and to the extent that it is a policy issue, because it's not just one city department or board, it's the entire city. We will do that. So that's what we'll wait for.
Okay, you know what I'm going to do? Let's hold off. Let's see if there's any discussion or comments from the task force members, but I know that member of the public, Phil Pell, has been anxiously waiting to speak on this. And then if there's any questions or clarifications that come up, we'll call on you again. DCA Castillo, thank you.
Sure. Can I add one more thing before
Sure.
you go on? SB 16, which has to do with the records requests that go to the police department and to that seek records specific to police officers. That that has many subparts to it. So in other words, It will amend provisions of the Evidence Code 1045, Penal Code sections 832.5, 832.7, 832.12, and add another Penal Code section 832.13. So there will be several different prongs to that legislation. So that's the one that I can think of that will impact what's required to be produced under the Public Records Act.
Very good. Appreciate that.
Okay. Sure.
Thank you. Members, any comments, any discussion? Otherwise, I'm going to open it up for public comment. Okay, let's do that. Let's open up for public comment. Hands off to you, Cheryl.
What?
So we're going to open it for public comment. Please get the clock ready.
Well, just a second. Clock is ready. Do we have public commenters?
Yes.
Hello, Mr. Pilpel.
Oh, sorry. I'm just trying to, yeah. I'm here. Yes, yes. All
Are you
set?
ready?
Yes.
Yeah. Go ahead.
Okay. So David Pilpel, I think the 7-page memo from the city attorney on dated September 28th that's primarily about AB 361 and updating prior advice is very helpful. I would encourage you all to read that carefully and probably more than once. Bottom line is I would encourage you, not necessarily tonight because it's late and I don't feel like drafting something and I'm sure we want to get out of this like, you know, maybe today rather than tomorrow. At your next meeting or maybe at a committee, I'd encourage you to draft advice that you can then approve and circulate to all city departments, agencies, boards and commissions about how to conduct meetings in particular under AB 361. It certainly provides some basic requirements, but I think you could elaborate, for example, on the provision, and I'll have to find where it is in the law, that requires specific instructions for how to access meetings. It's in the middle of page 5 on the memo. So it's not just listing a phone number or a web address, but I think it needs to be very clear that whether it's *6 to mute or unmute, *3 or 10 to raise your hand, that also lowers your hand, that you may or may not be told how many people are in the queue ahead of you. Something like this meeting tonight is more like a party line and has, you know, the whole thing about muting. Just a whole section that's not just read by the clerk at the beginning of the meeting or at each public comment opportunity, but to sort of manage expectations. I had to call in tonight several times just to see where you were. When you're not on video, it's not at all clear what agenda item you're on. It might be worth suggesting that policy bodies meeting that way. The policy bodies meeting on video. Can I have a few more seconds or a minute? You don't have to even enforce equal time rules anymore. Can I? Thank you. The policy bodies meeting on video might use some indication as to what agenda item they're on. The Planning Commission used to have a little flip chart where you could see that they were on agenda item 16. So if they're on video, you can at least see what item they're on, whether or not they're on SF.gov TV, which covers that with captions. If they're just on the phone, that at least every half hour at the top and the bottom of the hour that somebody say, hey, if anyone just tuned in, we are on item 8. We're in the middle of blah, blah, blah. We have or haven't taken public comment. Just so you know, we're on item 8. Something like that. And most important for me is that where the public was used to going to a specific place, whether it's the library or the office of the agency to review documents, agendas, or meeting materials under 67.9 or 67.23, or correspondence, staff reports, whatever, that all of that material needs to be posted on the web. If it's available in advance, then in advance. If it's available an hour before the meeting, then an hour before the meeting. If it needs to be redacted, then it needs to be redacted. If it's being sent to members of the policy body and they have access to it by email, then it should be posted and available to the public. And that should be the practice going forward. And if whatever that takes, and I'm happy to explain that further if you need it. But the point is, I would encourage you to gather your thoughts on how to conduct these meetings going forward and advise city agencies, boards, commissions, and departments on how you think that should be done. And whether or not they do it, you can't compel them, but at least you're providing guidance for how they should do things going forward in the brave new world, because I think we're going to be at this for a while, maybe forever, I don't know. And there are some things that are working well and other things that ought to be fixed, and you should be the folks, leading, asking for more light and less darkness here. It's fundamentally unfair, in my view, for members of policy bodies to have access to material that's otherwise subject to disclosure, that members of the public don't have equal access to online during the meeting, so that they can follow along and make informed, meaningful public comment. Whether I agree with that comment or not, doesn't matter. It's not discriminating on viewpoint here. It's just that everybody should have access to the same information. It's not okay to say, oh, well, if you really want that settlement agreement, or if you want to look through public correspondence, you still have to go down to City Hall or 1 South Van Ness or, some office to flip through stuff. Nobody's there and everyone's in masks and whatever, but we're not going to go through the trouble of redacting it, uploading it, and making it available. And if we get a late staff presentation, the Board of Soups will absolutely put it up on Legistar, but other boards and commissions, they won't. If they don't have to, they're not going to do it, and that's a big problem. All right, I think I've said enough. I'm happy to take questions or, whatever you need from me on this.
Okay, so, and I just want to say that this is on the agenda because of former member of the task force and now public member David Polpel, providing a little extra latitude for him to, and because of the lateness of the night. Okay.
And again, I apologize for that, but thank you.
No apology. I want to suggest though, if you, in your astuteness here, just want to provide some bullet points for us to highlight in a communication, we'll make sure we'll write it on this end, and be sure to include those, because we may not catch all of them.
Okay, I'm happy to put some thought into that. I promise I won't do it tonight, but I will do it in the next couple of days and get something to Cheryl.
Okay, thank you.
Terrific. I'll get it to Bruce.
Any other public comment? Last call for public comment. Okay, hearing none. Members, there's no real action to take at this time. We'll patiently await the city attorney's analysis and report on that. And if there's no objection, we'll move to the next item. Please call the next item.
Moment. Item number 14, review of draft complaint form. I just want to say that this complaint form was submitted by Victor probably in May. It was his first draft. He did another draft, and I submitted that to the Mayor's Office on Disability to make sure that not only it would be clear to members of the disability public, but also after our IT people looked at this form for ease of doing whatever people need to, there is a submit button or not a submit, but a next button at the bottom of the page. I don't think it came out very well when I was trying to get this copied, so that easy progression with the form can happen. Mayor's Office on Disability signed off on it. They said it's great, and it meets their requirements.
Okay. So this is before us for a final approval?
Yep.
Okay. Members, any thoughts, suggestions?
Yeah, I have some thoughts and some questions about this form, and I have like it's in a little bit of detail only because I've been thinking about how to get better submissions for our files and how to make our just everything about the process really try to hone in for people who are submitting cases to put together the strongest cases possible. And so I've just been looking at the documents that we put out. And so there were a couple things I wanted to mention about this one. One is, and I don't know if we need to do this for some reason, but the personal information notice appears twice in this document. It appears in the introductory page, and then it appears again on the form page. And I don't know if we need to have it twice. And then, the form asks about the Sunshine Ordinance sections that you believe are violated, and some of our other forms, just for consistency, talk about Sunshine Brown or the CPRA sections that might be violated, and so I think we might be limiting it too much to just say Sunshine here. And then on page P1430, it's just a typo. It says alleged violation when it should read, please describe the alleged, with a D at the end, violation. Yes, yeah. And then I also think that the opening page has like some unnecessary information that doesn't really add too much for the complainant's understanding of things, and I would try to make it more concise. And I don't know if we want to go this far in the rethinking of it, but I'm kind of putting together my own like recommendations, and I feel like we should suggest shortening the introduction to the form, making it more to the point, that we could probably eliminate the first 4 paragraphs because they don't give like especially clear or relevant information, only very, very general information that people probably already know. And I would
what page you're referring to?
Sorry, I have to.
Because I'm looking at 1424. Is that the page you're referring to?
I was saying 1430. Do I have that wrong? P1430.
So 1430, isn't that the optional? That's the optional worksheet.
Wait. So this is item 14, right? So I'm going back to this. Yeah, that's wrong. Okay, so I guess I'm talking about 1424, I think. Yeah, 1424. Sorry. Okay. So page 1424, I would just cut those first 3, from thank you to section B, I would probably just cut that because I don't think it adds that much to the rest of what we have to say. And I would just start the first paragraph with a brief statement about the role of the Sunshine Ordinance Task Force, and a brief statement of what the Sunshine Ordinance Task Force does, where it can be found, and where it can be found. I have exact wording if you want to hear it. And this is just based on, I was already going through this. And then the second paragraph, I think, should refer people to sections A and B in the complaint procedures and process before filing, so they can see how the process works and learn how to best present a complaint. I think this information about resolving complaints informally is already on the webpage where they start to, where the portal about how to file a complaint with the task force. And it's also again stated in section A and B of the procedures, which is linked on that main portal page. So I have like what I would put on that first page. It's sort of the same information, just condensed and made more relevant, so people aren't you know, having to kind of go through stuff they don't really need and it's not as direct as it could be. So those were my comments on it.
Well, are you asking for those edits to be made, or going to take action on them?
I would love for those edits to be made, and I can read you the exact wording if you want to know what I would put in.
No, why don't you submit the exact wording?
Okay. Yeah, I can do that.
But how are we supposed to know what to approve if we don't see it or hear it?
So you want me to read it? It's not that long. If I find it.
All right, read it, but then send it to me.
Yeah, obviously I can do both. Okay, so what I would say, and again, it's a lot, I'm not really cutting any relevant information, I'm just trying to be more concise. So I would keep, you know, the heading at the top of the page that gives our address and phone number, fax number. I'd keep that link to sfgov.sunshine, but then I would just say, first paragraph, the Sunshine Ordinance Task Force was created to protect the public's interest in open government as specified in Chapter 67 of the San Francisco Administrative Code. The Sunshine Ordinance authorizes the task force to consider alleged violations of public records and meeting laws enacted by agents or agencies of the City and County of San Francisco. Then I would have the second paragraph. If you believe the City or County of San Francisco has failed to comply with the Sunshine Ordinance, the California Public Records Act, or the Ralph M. Brown Public Meetings Act, you may file a complaint using the form below. Review the complaint process or the complaint procedures, sections A and B, for more information on how to effectively file your complaint. You can email this form to sodif@sfgov.org, fax it to 415-554-5163, or deliver it in person to the administrator of the Sunshine Ordinance Task Force, City Hall, room 244, you know, to the end of the address. And then just in the body, please note, while you can make complaints anonymously, the complaints themselves are public documents subject to disclosure under public records laws. So just trying to condense that information a bit and just take out the stuff that wasn't as relevant.
I think that when you said violation by the City and County of San Francisco, I would suggest including the word violation by a city agency or department of the City and County, because
If you believe a city or county agency or department of San Francisco?
No. Please understand that the California Public Records Act is about and for agencies. The Sunshine Ordinance directs it to custodians, actual people. That's what makes it the strongest in the country, is because it's directing it to those. So that's where you begin. You begin in reference to the Sunshine Ordinance with custodians as people, and it then expands to an agency, because if you were to provide enforcement, how do you provide enforcement to an agency? There's not much you can do, but you can provide enforcement to people.
If you believe a custodian of the City or County of San Francisco has failed to comply?
Custodian of records, quote unquote.
Yes. Well, that's what I was trying to get at.
Okay.
I mean, I think by saying the City and County of San Francisco, it can leave people wondering, well, where do I go? What does that mean?
Well, I mean, this is just an introductory page, and they go straight to the form, which tells them how to. Well, I mean, this is a complaint, right? They've already made a submission, but.
Right. The other point I make is you make a reference for people to engage the complaint procedure. That means you have to make that, very available. It has to be very noticeable on how they access that.
Yeah.
Because right now it's buried on the website.
Right now, the website has. I would actually make it. I mean, because I'm going to make a recommendation for this too. It's not that buried. There's 1 or 2 paragraphs at the top of our main portal, and they're pretty short. And right under that, the first thing is the complaint procedure. Then comes this complaint form. Then comes the online form that you can submit. So they will have already seen it, probably even to click through to this form. The only difference is if they're being handed this form in person. if you go to the main web, I mean, it becomes a bit more complicated, but it's right there on our main web portal, how to file a complaint.
Really?
Yeah.
I don't. Where?
Hold on 1 second, and I will find
I
it.
don't see it on our homepage.
They're filing a
It says
complaint.
file a complaint.
File a
Okay.
complaint under Sunshine.
Okay. Right. So, okay, the complaint procedures are there. So what you're saying is
I'm
that,
saying most likely they're going to download this form, right? After going to the Sunshine Ordinance Task Force, filing a complaint with the Sunshine Ordinance Task Force. There's a very brief paragraph at the top of that. Then the next thing is a link to the complaint procedures, then a link to this form that we have in front of us, then a link to submitting the complaint directly online. And this form isn't, I mean, it needs a little bit more consistency with the online form, and so that's part of what I was trying to do. The online form, by the way, has no introduction to it. So this at least gives you a little more information on that page.
I will tell you that sometimes people don't know that they can submit the form online and they just print it out and they fill it out by hand. I mean, Mr. Malloy was a perfect example of somebody who did that.
Right, and so we might want to put a paragraph or two at the top of that online submitted form too, because if they're just going to print that out and then fill it out and turn it in, they're going to miss the same information they would get if they went to the PDF of the complaint form.
okay, all right. So here's, okay, I understand what you want to do. I think what we're, the filing of the complaint page needs some reorganization anyway. So I get that point. I think what we're needing to do here is really more into the substance, because that's where most of the changes were made, is into the actual form fields, which form fields were added. Those are the biggest changes that we made to this. So while I get the opening narrative, could be wordsmith better, the question is if it's going to change drastically, that means this is going to have to come back to the task force, and we really don't have a whole lot of time for that. I think what I would suggest is leaving it as is, and then we can work on your edits and then update it a little more at our leisure. Because whether this is verbose or not, it provides essentially the intent is the same.
Sure. I would still maybe want to fix the typo. If you don't want to touch the rest of it now, I would also still maybe want to say Sunshine Ordinance Brown and CPRA violations listed there.
Yes, I think that's an appropriate.
And I still think the personal information notice doesn't really need to appear twice. But
yeah. Yes, I agree with that. I think it should just be left at the top, and it could be removed from the bottom, or the bottom of the form, or that opening form. Okay. Anything else?
Not from me.
Okay. Members, anything else on the form? Can we now approve this form? Get a motion on the floor. Are you awake?
I'll move to approve the form with the edits suggested by Member Stein. This is Vice Yankee.
This is
I'll
Member
second it.
Second.
Yeah, okay. Member LaHood will second it. I would just suggest that there be a little review of the edits that Member Stein wants to make, but I'm okay with that. Okay. Any other discussion, comments? Okay. Public comment on the form.
David Pilpel.
You ready, David?
I am.
Go ahead.
Okay. I appreciate Member Stein's suggestions. I think those are good. I did see some areas that were redundant here, and I recall historically that there was some stuff on the website about how to file a complaint. Then there were the complaint procedures. Then there was the how-to. That there were a lot of different documents, some of which said the same thing and some of which said slightly different things. So yes, the extent to which you can boil this down to just a form that doesn't repeat too much that's elsewhere, I think is to the good, and perhaps just refers people elsewhere for other background stuff. Somewhere in here, actually on the first page, in the personal info notice, it uses the word complainant. That ought to get fixed. That hurts me. The form itself, I don't have any particular issue with. I do think it may be useful to be very clear that this form is optional and that capturing the same information in some other way is sufficient as well. The subsequent pages, I think there's basic information that you're looking for that makes sense regardless of the nature of the complaint. At some point, though, I think it should sort of bifurcate and say if you are making a complaint about records, here are the relevant questions, the commonly asked stuff that's towards the end about records. If this is about meetings, it's a whole different set of questions, and I'm not sure that I saw the questions related to meetings. There is some overlap, like what department, what contact person, what date, but the other things are sort of totally different if it's a meeting-related thing as opposed to a record-related thing, and I would try to make that as clear as possible. If you want to adopt this tonight, this morning, whatever, and then go back and look at it again, that's fine. If you want to put this off and do one more pass and get it right, that's okay too. I don't have a strong view one way or the other, but I do appreciate that Member Stein and hopefully all of you are giving a look at this, and to the extent that it aids the public in, then that's good. Thanks.
Any other public comment? Last call, public comment. Hearing none, public comment is closed. Okay, any other thoughts on this? I think the last speaker brought up a good point about the not much area for the Open Meetings Brown Act stuff. Member Neighbors.
I'm wondering if it would be possible to, I mean, I know that there's an urge to approve this, but it is such an integral public-facing document, and it's after midnight, and I know that we're not all thinking as clearly as we might be, and as this document deserves us to be. If we're going to approve it, I would ask that we add the word temporarily into the motion, and I would prefer actually that we continue it and revisit it and maybe place it, either do a special meeting or place it earlier in our agenda so that we can give it the attention it deserves. I know we've also talked about or had some correspondence about revising what our expectations are of respondents as well. And it would be nice to coordinate the two documents so that they work well together. But I know that none of us have the bandwidth to go through that right now. So that's my comment.
Well, if we do that, then I'm going to request that everybody please review it and prepare, we do some work and be prepared in ample time before the meeting. So we're not, reviewing it during the meeting, that we're coming prepared like Member Stein did. Because I think we've been working on this for some time. It's been introduced, I think, at least once. And we really need to get it up. There's folks who complain about it all the time. So we need to get something. It's it doesn't matter whether it's temporary or not. We could always revise it. It's a growing, living document. So I think it'll be at least to get something going. I'm a little concerned that there isn't a section around public meetings in there. It's all about records requests. So,
Chair Wolf, I would just suggest that it might not be that we weren't prepared. It might just be that it's very, very late.
Yeah.
I know this is something we've all been talking about and thinking about, and I had ideas, and yet I can imagine that most folks are hesitant to dig into the deep details at this point, given that it's after midnight.
that's fine. May be helpful is if you do have additional edits or thoughts about this, send them into Cheryl. Send them into the office. We'll comb over them, and then if we have to contact you or ask you for an explanation, we can do that too. Because I don't think anything would be so substantive that it would divert from what's currently on the page here. So we've been at this for some time. Okay, so what's the pleasure? Continue? Or to approve and then continue to update?
Member Highland here. I think accept proposed changes, but continue the item to the call of the chair.
Okay. Is that a motion?
I'll rescind my motion so that Member Highland can make the new motion.
Okay.
Matthew, that was a second.
No, I said Member Highland can't make a motion while I still had a motion on the floor, so I will rescind my motion.
As will I.
So what's the motion? Is there a motion? All right, look, I'll just do it. I'll move to continue this item to the call of the chair. All members, if you have updates or adjustments or edits that you want to make, please email them in to Cheryl, and Matt and I will review that. And if there's anything substantive, we'll hold those off to the next meeting on those substantive points. We will include a section around public meetings for sure.
Can I just say, I just want to say one thing about it, which is that I know, you can see this attempt to condense the language as being somewhat cosmetic, but I think it's also an issue of how accessible we are. If people come to our site and it sounds kind of legalistic and has wording that's not that easy to comprehend for the average person, I feel like it's a disincentive to access and use the law. And I'm not saying it's a huge problem or anything, but I do think it matters. And so, at least in the work that I've been doing, I've been trying to go through and see how much can we simplify, get to the point more quickly, keep the information that we need, not be too repetitive, make sure it's consistent despite whatever, manner people want to access the law, and try to be a bit more of a, available and accessible body.
Mm-hmm. Okay. Right, so I made a motion to continue the item. Is there a second?
I'll second it.
Okay. So moved by the chair, second by Member Stein. Any discussion? Public comment? Okay. Let's go for a vote. Is there any objection to a vote? Okay, please call roll.
Chair Wolf?
Aye.
Chair Wolf, aye. Member Stein?
Aye.
Member Stein, aye. Member Priestley, not present. Member Neighbors?
Aye.
Member Neighbors, aye. Member Highland?
Aye.
Member Highland, aye. Member Wong?
Aye.
Member Wong, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Vice Chair Yankee?
Aye.
Vice Chair Yankee, aye. Moved by Chair Wolf, seconded by Member Stein to continue the item to the call of the chair.
Okay, before we move on, we have one last action item, but I want to ask Cheryl, in your report, are there any actual action items?
No. Everything that I have provided is purely information, including several public comments from Anonymous.
Okay, so what I'm going to suggest, we have one, this system-wide advisory, we need to take action on that. And then we can adjourn after that, if you so desire. Okay, please call the next item.
Item number 15, Chair's Report. Bullet point, System-Wide Sunshine Task Force Advisory, Timeliness of Response, which is draft. Bullet point 2, Reporting of Deaths due to COVID-19 in San Francisco in relation to file number 18024.
Okay.
Should I read the rest of it? This complaint deals with the request for death counts in San Francisco from the Department of Public Health. Recent publication and data collection on deaths due to COVID-19 appear puts into question Department of Public Health practices on monitoring deaths in San Francisco. And there are two links to information.
Okay, so we're just going to take the first bullet, which is the actual action item. Starts on page 1439. And while I just want you to note that when I drafted this, I used two different fonts. So the sans serif font is narrative, and the serif font is quotes from the code. Just to delineate. I could probably make it a little more pronounced, but really more interested in just the content and whether enough, whether it's covered all the points that we've discussed and we're concerned about.
Can I ask something else about it?
Absolutely.
Would you consider putting like an executive summary on the first page that just gives bullet points of the common problem areas, and then, kind of references like a section to look at for more details about that?
Actually, the way I was thinking about this is really somewhat of a build-up, because the way that we just heard it tonight. We heard a respondent trying to get 2 bites of the apple from 6721, where they wanted to, and we didn't pick it up as a violation, but they basically invoked a 10-day response and then tried to expand that to an additional 14-day. And as I was writing this, I was thinking exactly what you were saying, but after a while, it was like they really need kind of some background on what the Sunshine Task Force is and how this gets applied, because frankly, most custodians aren't required to take the training. So, they are basically trained by the department head or various managers that are required to take the training. So if they're left to their own devices, here this will go out to every department and then be distributed by the department to all the staff that have that would be considered custodians. So I don't know. That's my thought. That's the way I put it forward and conceptualized it. If you think it needs to be written in a different format, I'm open for it, and we can all vote on it.
I mean, I'm not suggesting changing, I'm just suggesting adding something at the beginning that bullet points out the main points that you want to make sure they know. Like, these are the number of days, and then gives them, see section 67.1 or see whatever it is. I just feel like if you think they're going to read the first page and not read the rest, then maybe they just wouldn't read the rest anyway. And at least if they could, the ideal is they read the first page and they read the rest. And so they get a preview of what the main things are they need to remember. Then they get to see why it's that way. And then if they need to reference back what the way it is, they can look at that first page again.
Well, I would. Okay. I mean, my concern is that they'll read just that first page and then go away. They'll not read anything else.
My concern is they won't read any of it if there's not an easy.
If they don't read it, and they violate don't comply with the ordinance, they're going to be. It's not like we didn't tell them. We didn't provide them, an advisory.
Well, we still provided it to them. We just provided it with a summary. That's all I'm going to say. But
okay.
I just, someone who reads a lot of long documents, I very much appreciate, having that overview. And I feel like that helps people remember. They need to reference back, and it helps them actually preview and then understand what they're reading better too.
Okay. I have member Neighbors and then member Highland.
Yeah, I mean, I think it's not even, members sign you say you feel like. I think it's not even what you feel like. I think it's evidence-based, right? We know that decision making, there's a reason we have executive summaries, because executives don't read the whole doc. And that's why we try to crystallize information at the beginning that is at least the minimum, the big picture, and then the minimum big takeaways that we want them to know. I think it could be really useful, because I think they're not going to read it. I think we hear, in the cases that we hear, we're constantly kind of having to do the basics with folks, with the respondents who come in. So we can assume they're not going to dig in. And it is just something to add, right? Like a call-out box. It just gives them, even if it's half a page, gives them what the main topics or where the main points are. Just, I think that would be really useful and strengthen it further.
Member Highland?
I agree with Lori and Laura. And given that this is a draft, and it's very rough in my eyes, there's no objective statement here too. I would read the first few lines, I would go to, and then I would just switch off. I think you need to come right out and say at the beginning, just a reminder to custodians and department heads, you have 10 days. You don't get to automatically invoke extensions. Notwithstanding what the pandemic laws by Mayor Breed put in, you still have to answer these requests. Just to refresh, please see below for a reminder on SOTF. And then, rather than listing 4 pages of details, if you could put the section 61, maybe the first sentence or 2, and then a hyperlink to the rest of it, and then the next one, and a hyperlink, the next one, hyperlink. Get it all on one page, honestly. And that's going to take more time because you have to really condense it down. But I think that kind of approach hits them right, front and center, and saying, you are in violation if you're not doing this. You want to catch their attention and word it as strong as you can. That's what I would recommend.
Is there any?
This is very academic. This is very academic, and it's going to lose most people. With all this listing sections one after another.
Member Levitt.
Yeah, I'm so tired. I agree with everyone else said. Also, I think a catchy subject line will make sure that people pay attention.
Yeah. Can I just
Yeah,
throw
but-
in, I would frame it, and maybe this is in the subject line or in the first couple sentences, something like, common misconceptions or misreadings of the Sunshine Ordinance, or common things people get wrong about the Sunshine Ordinance, or something that really frames it for them.
Does anybody have any comments on the substance?
Substance is good.
It's awesome.
Do you think I covered all the bases?
Yeah, especially
you
the
read
whole
it?
10-day thing. Nobody understands that, and I think it's really it's good.
Okay. All right. I what I'm looking for is approval really of the substance, not of the format. I appreciate the input on the format. You can work on that offline. And I, having executive summary or some short opening statement. I hear don't put the full quotes in. That's good suggestion and all that. I deal with the formatting and the wordsmithing later. I'm more concerned about the substance. That's what I spent the time on. Because we had a lot of public comment around this. There's a lot of, kind of acrimony from respondents. This is all generated by complainants. So I want to make sure I've covered all the bases here. So that's what I'm asking for support on. Otherwise, I'll continue it and delay it another month.
Chair Wolf, this is Helen Castillo, City Attorney's Office. Before you move to entertaining any sort of a motion, I just wanted to state, since on page 1442 you do reference that the inaccuracies may be coming from superiors or city attorney, I just want to note for the record that since you acknowledge it, the information that you're providing does contradict and goes against the advice that the city attorney has previously provided on this issue. I understand, because you've stated previously that you disagree, but I do want to state that it is in contradiction to advice provided by the city attorney's office on this particular issue.
I understand that, but by the same token, the city attorney has refused to allow the task force for 20 years to assist in providing that advice.
I believe, well, if you're talking about the training, we I thought that while I was away, you and Mark had talked about the task force providing, working with the office on the next training or training material. But as to specific time frame, that's what I'm referencing. So I just wanted to state that for the record.
Yeah, okay.
But I understand your position.
Yeah, and I know, and that's why that's you're fine if you feel that is objectionable to be in this advisory and that we should remove, then my cat's on my keyboard.
I don't think that that's what I'm stating. What I'm stating is just pointing out that when the city attorney issues policy memos pertaining to issues that impact the entire department, all the city departments, they are speaking with one voice. There is one city attorney. And then there are issues where, like in this capacity, we advise various commissions and task forces. And there are ethical laws, and where there are issues that pertain to specific boards and commissions, we advise on those matters. But when you speak about the city attorney, there is one city attorney. So I just wanted to point that out.
Is there another term or phrase that you would suggest be used?
No, because I think if I understand your communication, it is to correct or contradict advice that has been provided to all the city departments and different executive, boards and commissions. So since this is the first I've seen it, it's something that, I'd like to look at and think about and discuss with Mark. But I just wanted to make that point because I didn't know if you were moving to approve it and disseminate immediately.
Okay. Do you feel strongly that you folks should want to review it a little deeper before dissemination?
Yes, I think that would be helpful.
Okay. Then we'll continue it.
Okay.
All right. Any other comment? I see still two hands up. Member Stein, Member Highland.
Sorry, I need to take that down.
Okay. Member Highland?
Yeah, I'm taking it down.
Okay. So a move to continue this to the call of the chair.
Second, Member Highland.
Moved by the chair, second by Member Highland. Public comment?
David Pilpel.
Go for it.
Sorry.
Hang on. Member Highland was the second?
Yes.
Thank you. David, are you ready?
I guess. Yeah. Yes, I am.
Go for it.
Okay. And for the minutes, just something like David Pilpel offered his thoughts on the subject topic is fine. Doesn't need to be more detailed. It seems to me in my first read of this that it seems like lecturing. It seems too long. Not all of the information here is relevant under COVID because some of the sections have been suspended. In general, at a very high level, it's not clear to me what the point is of this communication. I would ask you to consider, does this enhance the credibility and position of the task force vis-a-vis the department heads that you're suggesting sending it to? Would they more likely consider this task force a partner in promoting compliance with the law, or more of an adversary or a pain as relates to their work? So in general, how do you think this will be received? Who will actually read it? Will it be the department heads? Will it be their secretary? Will it get bucked down to the public records person who may or may not already be happy with you? I would seriously reconsider what you're trying to convey in this document and whether this strikes the right balance of saying something useful that they don't already know, reinforcing things that they know or do or should do, or it just reminds them what they don't like about the law and what they don't like about this body. So I'm not saying it's the wrong thing. I'm saying I would think about it very carefully, particularly if you're continuing it, as to the tone and content and what the point is. Thanks for listening.
Thank you. Any other public comment? Okay, ready for a vote? All right, and before I do that, I just want to say I'm really more interested in whether the substance and the points that that I made in here are all the points and all the bases have been covered. Okay, I'm happy to reorganize it, rewrite it, different tone, all of that, but all of that is meaningless if the substance of it isn't hitting the exact points that that we have been hearing from members of the public and and what we're experiencing ourselves. Member Neighbors?
I just want to point out that that goes both ways. That if it's the whole form and substance are the same thing, the substance of what you're saying, as we tweak it or whatever, it's there, but it's not. I have to agree with our public commenter that there's the audience analysis, the tone, all of those pieces are part of the substance. The format is part of the substance in terms of how we treat the readers as partners and as opposed to folks that we're lecturing. So I just urged a kind of a not it's not organic to separate those things, and I hope that we can think of them as deeply wedded moving forward.
Okay.
Bruce, member Highland here.
I obviously got to reformat, rewrite this in a different way, in a different context, because I don't think you're really understanding what I'm asking. That's okay.
Chair Wolf?
Yeah, go ahead. Member Highland, go ahead.
I was just going to say, if I were you, I would delegate this to the writers in the group. We have several very professional writers here. Let them do it. You can always put your name on it and send it out from you. But I think this is something better handled by those members. That's just my.
But that is not the crux of the issue. The issue here that's fine. I don't have a problem with that. But if the writers aren't hitting the points that we need to hit, and it's just about how it's formatted and how its presentation, okay, then it's still not complete.
You can still have a discussion with them as they write it, as they draft it. But,
no, that's a discussion for the full task force. That's what I'm asking all of us to vote on, is whether the points have been covered. And if they haven't been fully covered, then please contribute to what it is that is missing.
I have to say, I feel like I do understand what you're asking.
Okay.
My problem is I joined the task force fairly recently. I'm not even sure where these points are coming from. I'm not sure because you're just giving, you're giving sections of the ordinance. So I'm not sure like what it's most important for you to get across in presenting each of those sections always. And I just wasn't there for these discussions of what's getting misconstrued most often. So it's hard for me to know if you're hitting all the points. It would be great, to have like a rationale of why you're addressing each of them. That might help. But so I don't know, that's why I'm having difficulty. But I do understand that you want to know, am I telling them the information that they're not understanding, that they're not interpreting right, all of that. But I haven't been around long enough to know, are these the main things that people are complaining about? Is there something that's missing? I don't know.
Okay. We had a meeting around this over the summer, and we had a lot of public comment on it. And that's what I'm drawing from. That's what's the impetus for doing this. So it's not so much what was happening historically, it was the input that was being brought forward by some of us and most of it from members of the public. And so that's what I was drawing from. And their interest in having this go out because of the repetition of the same violations over and over and over again that they have to, and that creates our backlog. So this was a way to try to head it off at the pass. Right. So what I'll do instead is I will start again. I will just put out some bullet points of the areas that need to be covered. Okay, so that maybe it's easier for us to see what those are, and then somebody else can write it.
And Bruce, just to finish, if I was to pick the most, I've written to you about this through stuff I've done for EOT. and I'm aware of, we've been having this conversation, but if I was to drill down, it would be 6721B, and you could put out a communication solely about that, which would hit the nail right on the head. I think it'd be much shorter. That's the middle of page 1442. I think that's the biggest malpractice out there by bodies. That's really what we're talking about: the 10 days, the 14 days extension, etc. If we did nothing but that, people would remember that, like, oh yeah, okay, fair enough, there it is. By adding everything else, and that's just my personal. But anyway, I'll close there.
I get that. I appreciate that contribution. I'm just saying, I'm also trying to respect the people who give us our work, the folks that file the complaints. I'm trying to, I think the idea is to try and include everything around timeliness with regards to 6721. And however concise or expansive it is, and respect their concerns for, and they think that we should be doing this on everything, because there should be no complaints, that everything should run 100% pristine, perfect, which obviously is not a reality, but they want us to engage the city more with these kinds of system-wide advisories, because there's no way we're going to go around doing trainings. So so I'll do that. I mean, I'll put this off again. I'll break it down into bullet points of the message, and then folks who want to step up to write the narrative and to organize it more cogently, that's fine. I didn't mean for this to go out in the way it was formatted. I provided what I felt were the key points and the evidence in the law to back it up, so people wouldn't say, we're talking we're pulling stuff out of thin air. That's all. So, motion is on the floor to continue.
We're ready for a vote, you said.
Yes, we're ready for a vote.
Okay. Chair Wolf.
Aye.
Chair Wolf, aye. Member Highland.
Aye.
Member Highland, aye. Member Forsley, not present. Member Neighbors.
Aye.
Member Neighbors, aye. Member Stein.
Aye.
Member Stein, aye. Member Wong.
Aye.
Member Wong, aye. Member Padmanabhan.
Aye.
Padmanabhan. Aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Vice Chair Yankee.
Aye.
Moved by Chair Wolf, seconded by Member Highland to continue the matter to the call of the chair.
Okay, thank you. The second bullet, you can read that on your own. If you have any questions, you can email me about it. Otherwise, I'll entertain a motion to adjourn.
Public comment?
Oh, I'm sorry. Public comment.
I'm sorry too.
My bad. Sorry.
No. We're all falling apart. It's okay. I'll keep it brief. David Pilpel. So my comment was on the administrator's report. Cheryl and Victor are doing a fine job, assuming portions of them are still awake and alive here. But my continuing concern is the continuing backlog, and what I see is the increasing number of incoming complaints compared to the disposition of complaints by this task force. And I've commented on this several times before. I don't have the right solution. It's way late and hard to, articulate at this point. But somehow, once again, last month was 147. This month's number is 166. It looked to me like you only had 7 items on the agenda tonight to dispose of. I don't see, even with the Project Catalytic or whatever other schemes you've got in mind, it seems like the number of incoming complaints continues to far exceed the task force's current capacity to dispose of them. And somehow you've got to have a fundamental meeting of the minds about how you're going to balance that. Otherwise, you're never going to get caught up, and you're never going to get ahead of this, and you're never going to have the capacity to deal with other policy issues, and you're just going to continue to drown in complaints, whether they are with or without merit, good, bad, or otherwise. It's just overwhelming the system. And I strongly encourage you to find one or more ways to deal with that. But it's just, it's unfair to members of the public that may have a complaint, legitimate or otherwise. It's unfair to city staff to sit around for hours and hours waiting for these hearings. It's unfair to those of us who care about policy issues. It's unfair to Victor and Cheryl. It's unfair to all of you and the time that you're devoting to this. So something, it just seems to me, is fundamentally broken here, and I would encourage you to talk about it and find ways to deal with it. I don't have the answer. We don't have to talk about it tonight. You can just sit with that. Thanks for listening. I'm done. Thanks.
Oh, excuse me.
Flash. Any other public comment?
Thanks.
Any other public comment? Okay. Public comment is closed. Please make sure, Cheryl, that public comment was included for this motion. Now, motion to adjourn.
I'll move to adjourn. This is Vice Chair Yankee.
I'll second it. Member Stein.
Moved by Vice Chair Yankee, second by Member Stein. All those in favor say aye.
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 Opposed? Hearing none, we are adjourned. 12:45.
Top of the morning to everybody.
Thank you all. Good night.
Aye.